And again, welcome everybody to the Judiciary Committee. Sorry, we've had a couple of delays due to other meetings that are happening at the same time. We are going to postpone introductions because we have Ann Jordan here who wishes to speak to the committee on LD 679. And I know that you have a time deadline. And so if you would just like to proceed, we're happy to hear from you and welcome you to the committee.
Thank you, Senator Carney, and good morning to everyone on the committee. I apologize, but I have a 10 a.m. meeting, national board meeting that I am chairing, so I can't stick around. I just wanted to point out, I understand there were some questions between the fiscal note provided on LD 679 and the fiscal note that was provided in January of 2018 on LD 860, and what are the differences? I think the simplest explanation is this. The numbers given in LD 860 in January of 2018 were what we would refer to as a swag or a best guess educated estimate of what the costs would be to implement this program. Those figures were provided to us by Tyler Technologies, and the key difference is Tyler did not have a product to allow for electronic transmission of search warrants or arrest warrants at the time. So these were their best guess estimates. Versus fast forward to now June of 2021, the estimates that we provided were actual cost estimates that were given to us by Tyler Technology, which has since developed the product, has launched the product in a couple different areas, and has the product available for us should we elect to use it. Since we are using Tyler Technology products, the Odyssey product, for our court conversion, it makes more sense to use their product than trying to purchase a different product, trying to figure out integrations, dealing with the limitations on such things as their patents and connections and all those sorts of things. So that's what the difference is. You will note on page 5 of the statement, we have broken out the total costs to give some different options. We have the cost for software. We have the cost for the JOP as Justice of the Peace. And we have costs for law enforcement hardware. And then we broke it down to whether we would include the JOPs in this project or not include the JOPs. Procedurally, what happens is during the day, right now, the judges do all the search warrants and arrest warrants during normal business hours. After normal business hours, nights, weekends, and holidays, we have a list of 53 justices of the peace who are licensed attorneys and who are appointed by the court, who are available to review those documents and to provide services. For JOPs, the basic rule is we do not pay them for any search warrant or arrest warrant that they review during normal business hours. After hours, we pay them $40 per incident, or per review, I should say. And so we have included both the JOPs and not including the JOPs. JOPs are independent contractors, so we do not provide them any computers, any computer hookups, any internet, any modems, anything like that. If we include the JOPs, we have listed all the expenses here, and of us providing equipment and other matters would also require our staff to go out to their homes, hook up the computers, make sure the appropriate securities are in place, because oftentimes in these search warrants or requests for arrest warrants, there is what is called CJIS materials, which is criminal history record information from other states and or from Maine. The FBI regulates that, and we must follow their regulations on what can be transmitted and the nature and level of security. For right now, in our current process, JOPs, everything's on paper, so there's no electronic transmission of those records, so there aren't the security costs involved. So that's the big difference as to the equipment and everything. So that's basically what I just wanted to point out to you. And bottom line is the product didn't exist in 2018, And the product is not part of our contract with Odyssey because it didn't exist when we signed the contract. So it would be additional costs involved to secure the product, to implement it, and to get it all going.
Thank you very much, Ann Jordan. Do you have time for any questions from committee members? If we had one question, or you?
I have 2 minutes. 9:55 is is my hard stop.
There may not be any questions. Committee members, are there any questions for Ann Jordan?
Yeah, I've got one.
Quick question. Go ahead, Representative.
If it's me, hello, Ann. Can you give us an idea of the number of reviews done daytime versus nighttime?
We don't keep that record.
Okay. Not judges versus JOPs?
Well, we could, I don't have it immediately. We
Okay,
could pull,
okay,
what did
yeah,
we pay
that's fine.
JOPs last year and divide it up, and we could figure that out, but I
Thank you.
don't have that number available.
Thank you.
Thank you, Ann Jordan, so much for being here, and we appreciate you delaying your other work today to address us, and thank you for the memo as well.
Thank you very much, everyone. Have a good meeting.
Thanks,
Bye-bye.
Dan. Take care.
Bye-bye.
Bye.
Bye.
Bye-bye.
All right, committee members, that was a very abrupt start to our work today, and I would like to proceed with committee introductions. Representative Moriarty, did you wish to be heard on something before we
Well,
do
it's a
introductions?
question for you after we do introductions, I guess.
Okay,
Oh.
thank you. All right, so we are going to start our meeting this morning with committee introductions. And I'll call on committee members as we go forward. And we'll start with you, Representative Moriarty. Go ahead.
Oh, thanks, Madam Chair. Good morning, all. I'm Steve Moriarty, coming to you live from Cumberland. My district is 45, which includes my hometown and part of Gray.
Thank you. Representative Sheehan?
Thanks, Madam Chair, and good morning, everyone. My name is Erin Sheehan, and I represent House District 12, that is downtown Biddeford.
Thank you. Representative Poirier?
Thank you, Madam Chair. I'm Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Thank you. Senator Sanborn?
Good morning. I am Heather Sanborn. I represent Senate District 28, which is half of Portland, half of Westbrook, and I'm the proud mom of a new Portland High School graduate.
Hey.
Thank you. Let's give a round of applause. Well done. And let's see, Representative McCreight, you're next.
Good morning. I'm Jay McCreight, representing Harpswell, West Bath, and Northeast Brunswick in the House.
Thank you. Representative Babbage?
Yes, good morning. My name is Christopher Babbage. I represent House District 8, which is most of the town of Kennebunk.
Thank you. Representative Cardone?
Hello, I'm Barbara Cardone. I represent House District 127, part of Bangor.
Thank you. Representative Newell? She may have had to step away. I am embarrassed to admit this, but Representative Poirier, have I called on you already? I thought I had. Thank you. Senator Keim, go ahead and introduce yourself.
Good morning, everyone. My name is Lisa Keim, and I'm honored to represent Senate District 18, which is northern Oxford County, and two communities in Androscoggin.
Thank you. Representative Newell?
Thank you, Madam Chair. Please excuse my jumping off camera for a phone call. Good morning, everyone. I am Rena Newell, and I serve as the Passamaquoddy Tribal Representative. Thank you.
Thanks. And Representative Rackett?
Yes, I'm struggling to get on this thing, but I'm Lois Reckett from District 31, Ocean into South Portland.
Thank you. And I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. Again, I am sorry for the delays this morning. Some of us were needed to attend a Criminal Justice and Public Safety Committee meeting, although we are all back now. In addition, I wanted to let those who are attending the meeting and who are watching on YouTube that This is a busy time of year and committee members will be either leaving or joining throughout the day as their schedules require. So please excuse our absences when they are necessary. And with that, we will begin our day's work. Want to let everybody know what our schedule is today. We're going to do work sessions on a number of bills, and the order of bills may change a little bit because people's schedules are changing as the minutes tick by today, but we'll do work sessions. We will discuss committee carryovers. We'll attend to some other bills. And then after our lunch break, we'll return hopefully at 1 to do freedom of access reviews on quite a few bills. And so with that, I thank everybody for their patience with some of the uncertainties that are inevitable this time of year. And Representative Moriarty, you had asked to be recognized earlier. Go ahead.
Sure. Cool. Quick question, Madam Chair, concerning Ann Jordan's appearance before us a few moments ago. We voted unanimously over 2 months ago to pass on LD 679. So does Ms. Jordan's report impact our position on this bill in any way? Or is it just informational as far as the cost?
The reason that we heard from Ann Jordan was because committee members had questions about the fiscal note. We anticipated that the fiscal note would have been lower than it was. And so we're doing some additional exploration of the fiscal note with the concern that we might want to ask OFPR to have another look at the fiscal note based on additional information.
Okay, so that has not been finalized yet, the fiscal note.
Correct.
Okay, thanks very much.
Yeah. And then we also do have, I know that Ann Jordan had to leave. We do have Julie Finn from the judicial branch here also to answer questions related to 679. Let's see, I think Senator Keim, you were the primary sponsor of 679, and I apologize that you didn't have an opportunity to ask Ann Jordan questions. It was the schedules today are kind of overlapping. Were you able to hear any of her presentation?
Yes, I was. Thank you. And I guess we'll just have to accept the fiscal note.
All right. Do you have any additional follow-up questions for Julie Finn?
I didn't catch quite all that was stated, but the only question I had was, I think they were saying that, was it they had to get new computers. Normally they don't have computers or internet connections for some people that would be doing the orders, that would be looking at the orders. And so I'm wondering if they have to include them. I guess that was the only question I was left wondering, is whether or not they actually needed, it seemed expensive to include them in that. And I didn't know if it was optional.
Okay, let's ask Julie Finn if she can join us and follow up on that piece of information. I'll bring her over to the panel. Welcome back to the Judiciary Committee. I think that you are our most regular non-committee member attendee.
Well, it's my pleasure, and good morning.
Good morning.
I preferred seeing you all in person, but I guess this will have to do for today. So I can't answer Senator Keim's question, I think. So presently, both judges and justices of the peace can approve or not approve warrants. And as Ann mentioned, justices of the peace can only do those approvals during outside of business hours. So nights and weekends, because they get paid for it. They get paid $40 each time, whereas judges are, they're already at work, and during the day, it makes sense for them to do this. So the way the bill is written and the way the law currently stands, it seems like all people who can approve warrants, which would include justices of the peace, to be included. Of course, the committee could change that in the law. You know, we did talk about this earlier, some of us here, like equipping non-state employees with computer and IT equipment is kind of unusual, I think, with taxpayer funds. And if we were to actually do that, our IT folks were saying, well, they'd have to get in touch with each of them, find out some of them already have internet, presumably, may already have some equipment that would be compatible. So it might not be every single one of them that would need it. And then I have one other option, which would be that justices of the peace could stay with a paper process, and then they would not need the equipment, the electronic equipment. So that was a great question by Senator Keim, and I think I gave you the information to consider.
Senator Keim, do you have follow-up questions?
Yes. So the branch did consider whether or not they would necessarily need to equip the justice of the peace. I mean, would it be possible for this bill to go forward and the electronic warrant part only be available for judges?
It would, yes. Well, you may need to amend the wording of the bill. Because the bill seems to require the technology to be provided to everyone who is now approving warrants. So it might require a minor amendment. But the reason that was separated out, I think, was because it could be changed or eliminated. And just one other point, another piece that in the memo that was separated out was the costs for law enforcement. And different municipalities and sheriffs and the like. And that's actually a greater cost, and that would not be borne by the state, but it's just another thing to think about. So that was separated out as well too.
Okay, so that just two questions then. Are there enough judges to handle the work if we were to not include justices of the peace in the electronic warrant system?
You know, that has been discussed, and I think that would be something probably that we could handle. The judges would probably do something like have a judge that's on call, like have one judge a week be sort of on call and not hear other matters. So, you know, so they could handle the off hours requests as well.
And then the other cost you mentioned for law enforcement, which wouldn't be handled by the state, would that mean then that would be a local mandate?
It could be. And again, like with the justice of the peace, there are some departments that probably have, you know, 100% adequate technology now and wouldn't need anything. And some departments that probably would need quite a bit. You know, it's going to be tremendously variable.
Okay, and that wasn't included, of course, in the note that fiscal note from the judicial branch, you just made note that the expense would be there.
Right. It is in the memo and it was estimated, because in coming up with the memo and the fiscal note, we worked with all the different law enforcement agencies, the state police, the sheriffs, local chiefs of police. And so they were all consulted. And so they were not able to pull all of the police departments to get a firm number on that, which if the bill passed, they would have to do that at some point. But from the information we had, the memo from our IT department does estimate that cost.
Thank you.
Representative Cardone?
Thank you, Madam Chair. This is a part question and part comment. Before I became a member of the legislature, I was a justice of the peace for many, many years. And speaking for myself, I can tell you that it was very rare that I signed a search warrant, because even after hours, I found that the police officers were going to the judges' homes rather than to the justice of the peace's homes. Most of what I ended up signing were blue papers. So but what I don't know is whether that is different in the more rural parts of the state where judges may not live. But it seems to me that it would not be a problem, or at least would be a secure first step to pass this bill with language that eliminates justices of the peace from the electronic system. And again, this is just a guess on my part, that it may be in the more rural areas that you might need a justice of the peace, and to provide that they could be served or they could be utilized via the old paper warrant system, I think would serve you well. I think it would address the vast majority of the warrants, and leave you that coverage for a paper warrant, with for the ones that are going to be a real problem, where you really need something fast. It's the middle of the night, and you got to get to the nearest person, and that's a justice of the peace. So having made that statement, I guess my question is to Ms. Finn, does that seem reasonable? I think you've said yes, but I kind of wanted to put it into that package.
Yes, I mean, I think it does. And I don't know the answer to your question as to whether justices of the peace are more frequently approve these warrants in the rural areas. I do know that there are some who I think are woken up fairly regularly, but I don't have detail on where they are or why that is. Ask them, they could continue to do it with paper. But also I point out that, you know, if we have a e-warrant system up and running, there may be no need to use the paper anymore.
Well, that's true. If you've got the system up and running, you can easily wake a judge up in the middle of the night too. So.
Right.
Representative Babbage, go ahead.
Thank you, Madam Chair. Yes, been thinking along the same lines as Representative Cardone. Ms. Finn, if in fact we do that and exclude justices of the peace, how does that change status quo regarding them, as far as the as far as for instance, you know, we're talking about additional costs. We're actually keeping the paper process. So this would not be an additional expense borne beyond what is current, as far as a mandate is concerned. Is that right? It's not a state, it takes it out of the state's fiscal concern, but would it be an additional cost in other governmental agencies, local, county, sheriff?
Well, if I understand your question, and yes, I mean, probably the different sheriff's departments and different municipal police departments have levels of technology that they are already using. If they already have adequate technology to support this system, it would cost nothing. You know, in some of the bigger departments, that is probably the case. But in some of the smaller departments, they likely would need some upgrades in terms of software and hardware. And that's kind of an unknown factor. So it could be a mandate for some municipalities, but we don't have granular detail on which ones exactly or how much.
But you're saying that would be true even if we continue the paper process for JOPs?
Well, no, if we stay with the process we have, there wouldn't be an additional cost.
Right. Okay, thank you.
Senator Keim, go ahead.
What I'm wondering is if we could start the process by funding it through the judicial branch and allowing, and I don't know if we can write it this way, but allowing the paper process to continue simultaneously. And that way, the departments, the law enforcement departments that have the capacity can at no cost start using this. And then as the smaller departments maybe come online with the capacity, the electronic capacity or whatever it is, then maybe they can take advantage of it at their own pace and timing rather than be a mandate. Is it possible to write it that way? And does that, Peggy, and then does that make sense to you, Ms. Finn?
Well, I think that also would require amending the language of the bill. The reason the fiscal was done the way it is because the bills seem to require that it be used by all law enforcement and also include the justices of the peace. So you can, amend the bill as you see fit. And, the licensing fees from so that, could be a smaller number. We used a couple of different, we used 1,500 as an estimate. That includes, 50% of all licensed law enforcement officers. So not 100%, but 50% plus judicial branch licenses and for judges, of course. So I think you could amend the bill that way if you wanted to.
Let's hear from, I know that you had also directed the question at Peggy. Peggy, do you think that it's possible to craft the bill that way?
I probably, I'm not exactly sure. I mean, are you talking about making sure like at least the state police participate electronically from day one? Because I just, making sure the judicial branch is ready to go doesn't do a whole lot of good if there's no law enforcement agency that can plug into that. So I don't know if that's, I'm trying to pull out the fiscal note and see where the money is going. I guess it's all going to the judicial branch, right? So we're not trying, the fiscal note doesn't fund anything else, right? Okay.
Right.
Okay. So
there is a number that's based on 1,500 users, however, and that number could be reduced if we were anticipating.
So the memo talks about total law enforcement costs for, right? And so that's not incorporated into the fiscal note and the appropriation, right? Okay. We can probably, what do you think? Julie, do you think we can write this so it?
I haven't thought about it until now.
Yeah.
I have a suggestion, which is that I feel that this has been a really fruitful conversation and we have a potential path forward that would start implementation of this really important policy. And I suspect that we will have to at least do one other quick meeting to wrap up a little bit of Judiciary Committee business. And so perhaps the bill sponsor could work with Julie Finn and with Peggy to see if there is a way to write that language. Does that seem like a good process to you, Senator Keim? Okay. And Julie Finn, is that?
So it would be basically an opt-in for law enforcement. It would include the state Department of Public Safety, Maine State Police, and an opt-in for other departments. Okay.
I think so, because doesn't that make sense that they would, it would make their life easier, and at the point that they decide it's valuable to opt in, as long as the from the state, we fund the licensing, then there's no extra cost to them. And I don't want to impose a cost if they're not prepared to take that on. I wouldn't want to, but I think most of them would see it as beneficial and would want to, as soon as they were able, would probably want to take advantage. So yes, I would like to write it that way. And then the paper system continues simultaneously. And then depending on the situation, people may take advantage of whichever process works for them.
I will say that I heard from we had multiple meetings about this with law enforcement and with our partners. They are very enthusiastic about this, the law enforcement folks. So they will certainly have motivation to try to make it work. It's more of a time savings for them, frankly, than it is for us.
Well, and it looks like we need to work a little bit on section 4 because it says it must be done electronically. So that's what we would need to be addressing. The bill's kind of written as everything has to be electronic from now on. So we just need to kind of split that up. And then I don't know if we need to address anything in statute about we can figure that out.
How does opt-in, I'm sorry, Madam Chair, may I ask?
I don't think so, Representative Babbage, on this, because I think we're at the point where it makes sense to have Peggy and Senator Keim and Julie Finn work together on this and bring us back an amendment that will probably answer all of the remaining questions we have. And so I would appreciate if we could let them do their good work on the bill and bring it back to us. Is that okay with you? Great, thank you very much. Does that sound like a good plan, everybody? Members, and we'll be in touch when we have a proposal. Okay, great. So we'll keep you posted on that. And with that, we'll close the work session on LD 679. And unless there's anything further from Senator Keim or Peggy or Julie Finn? Nope. Okay, great. So we'll close the work session on 679. And let's see, we'll open our next work session, which is the work session on LD 320, which is an act to provide the right to counsel for juveniles and improve due process for juveniles. And the sponsor, Representative Morales, is here. And so I'll invite her to join the panel. I can find her. Oh, okay, there she is.
And while she's coming over from cyberspace, I just want to mention that I did share an amendment yesterday that came from a lot of work that the other parties did. I didn't work on it. I was the scrivener and I messed up because I left out a sentence. And I think Representative Morales and if Jerry Reed wants to join, if you want him to join too, they can identify where that is. But if you can pull up your amendment, and if you don't want to pull up your amendment, I can pull it up, that I sent yesterday. I have it dated 5:40 p.m.
Thank you very much, Peggy. And I think what we'll do is we'll start with Representative Morales speaking with us, and if we need to do screen sharing, committee members, please request that. And we'll also hear from Jerry Reed as well. So Representative Morales, the floor is yours, the virtual floor.
Thank you so much, Senator Carney. And thank you to this committee for giving me the time to work on this policy. And I want to thank Attorney Jerry Reed for also working diligently with me on this policy, as well as the DOC. So that's what this week has been about. And I'd love for Jerry Reed to come in as well, so you can hear from him about the work that we have done together, but we've come to an agreement. I'm really pleased with it. It's a very important policy. As you remember, what we were talking about, that we had we weren't totally in agreement what last week was on the issue around 11 and unders, and how we would address that. And so the compromise that we both agree to is that the Department of Corrections will still retain jurisdiction over 11 and unders. However, detentions, should they occur, would be limited to 7 days unless agreed to by the parties. And as you all well know, in the legal field, the parties means the defense attorney and the prosecutor. And we both felt that that provided the greatest protection, as well as gave some flexibility to the department as they search for services to put in place for that young child. Now, I want to also say, I want to thank Peggy because Peggy has worked so hard with us and she has not made any mistakes. So I just want to counter that. She's been absolutely amazing. And Jerry Reed had sent an email this morning just on a sentence to clarify. I absolutely agree with it. And he can come in to explain that. But it just says that a juvenile who has not attained 21 years of age must be represented by counsel at this review, which is to be added to section 13 in addition to section 11. And that was just to keep it consistent with the language.
Thank you very much, Representative Morales. And let's hear now from Jerry Reed on the addition from this morning, as well as your overall comments on the compromise position.
Good morning, Senator Carney and members of the committee. Jerry Reed, counsel to the governor. And I really just want to emphasize my own appreciation for the efforts of Representative Morales, especially, and her patience with the process. It took a long time to work through the issues, but it was a very constructive process. And I think we both feel very good about the outcome. In terms of the substance, it's a very simple matter that Peggy was referencing a minute ago. There was a sentence, as Representative Morales indicated, that was to be added to both sections 11 and 13 of the bill to confirm the right of representation of the juvenile in the reviews that are contemplated by those two sections. And in the draft that was circulated late yesterday, that sentence does not appear in section 13. So it's very simple. But again, I just appreciate the committee's willingness to give us the opportunity to work through the issues. And I'm very glad that we got the result that we did.
Thank you very much. And for the clarity of the committee, because we've all seen the document, and I'll ask committee members if they want to screen share. But could either you, Jerry Reed, or you, Representative Morales, just explain once again exactly what the language is that would get added to section 13 now that we've been oriented to the compromise position?
I can actually show you exactly. If you look at page 5.
Yes.
Paragraph A, a juvenile who has not attained 21 years of age must be represented by counsel at this review. Copy that and put it, I believe, at the end of section 13, which is amending section 3317. So that's what it would look like corrected.
Thank you.
Think that's okay at the end.
I think that's fine.
Yeah, we're getting the thumbs up from Representative Morales as well. So that, first of all, tremendous expression of thanks to all of you for your hard work on this really important bill. While you're part of the panel, I just want to make sure that we give committee members an opportunity to ask questions. And committee members, if you wish to have anything shared on the screen in order to be able to review it, please include that request in your questions. And so with that, committee members, are there any questions regarding the proposed amendment to LD 320? Senator Keim, go ahead.
Thank you. So my question is, so the juvenile can't be committed to a secure detention center, but they can be held there for 7 days. Is that right? And then possibly longer if both parties agree. And what other location would a child that was deemed dangerous, a young child deemed dangerous, what other facility are we looking to put this child into?
Representative Morales or Jerry Reed, would you like to answer that question?
Well, I can start and invite Representative Morales to weigh in on that. Also, I think it's a very good question, Senator Keim. It's been kind of underlying a lot of the concerns that the administration had about the original language of the bill. And I worked closely with Todd Landry at DHHS and the staff at DOC to make sure that they were comfortable that this 7-day period of detention would be sufficient for them to work through this issue and find a suitable alternative setting for a child under those circumstances, whether it's a hospitalization or some other form of treatment setting within the state or potentially out of the state, I think is dependent on the circumstances. These are challenging placements. Everybody understands that, but they felt confident that a potential 7-day detention with the opportunity to extend it by agreement of the parties would allow them to find a suitable alternative treatment setting.
Did you have a follow-up?
Yeah, a follow-up. Yeah, so right now, actually I have two. So right now though, it looks like it would either be hospitalization if it's in state or a treatment center out of state, because we don't currently have anything else developed. Is that a fair assessment of what?
Right, we don't have anything else in state in place today, although DHHS is working to establish that. I can't give you a sense for exactly when that will be realized, but that is certainly something that they are working on.
So then the other question I have that I know was of concern is if the Department of Corrections if they have jurisdiction over the child, they can force them into treatment that they believe is needed. But if the child is not under the jurisdiction of the Department of Corrections, then do we still have the ability to under this proposal, do we still have the ability to take a child and put them into a place where it's recognized they need to be, whether or not their parents, who may or may not be part of the issue going on with them, agree? And how has that been worked out? Can you just help walk me through that process?
Yeah, so that was the other major concern that we had about the original language of the bill. And those jurisdictional changes to the statutes are all in what was Section 2 of the bill. And we were concerned that if those jurisdictional changes were made now and went into effect now, we would lose the ability to require treatment in the circumstances you're describing. But we've agreed to delete those jurisdictional changes from the bill in Section 2 in order to give us more time over the next year to work on that issue. So if this bill as amended were to be enacted, the state would continue to have the ability to require treatment as it does today.
Okay, very good. Thank you so much.
Thank you, Senator Keim, for those helpful questions and also for the helpful answers, Jerry Reed. Representative Morales, did you have anything you wanted to add to that?
No, I think that's accurate. And just to note that these are very few situations that happen. The numbers are very small for the state. So I do appreciate that answer, though, from Jerry.
Thank you. Committee members, are there any additional questions? I am not seeing any additional questions. Well, we don't have a motion yet on this bill, so I guess I'll ask one final time before we move on to a motion, committee discussion, and a vote. Are there any additional questions for the bill sponsor, for Jerry Reed, or for Peggy, our analyst? I am not seeing any. Go ahead, Representative Moriarty.
Prepared to make a motion, Madam Chair, if there are no questions.
Okay, let me just check with Representative Sheehan. Representative Sheehan, did you have a question or were you ready to make a motion? Okay. All right. Then I'm going to excuse Jerry Reed from the panel at this point. And since we do allow bill sponsors to stay on the panel during work sessions, we'll keep Representative Morales here. And so go ahead, Representative Moriarty.
Okay, Madam Chair, I move ought to pass as amended.
Thank you. And Senator Kime?
If I could, Madam Chair, I would request a very short corner caucus.
Okay, let's get a second on the motion and then we'll have a corner caucus. Representative Sheehan, did you want a second?
Yes, I second the motion.
Senator Kime, I didn't know if your hand went up. Did you wish to second the motion? No.
No, it's fine. I just wanted to ask the corner caucus and was not paying attention at the moment to the motions.
Okay, thank you. So we have an ought to pass as amended by Representative Moriarty, a second by Representative Sheehan, and we will take, is a 5-minute corner caucus acceptable? So we'll return at 10:40, everyone. And thank you very much for your work. See you in 5 minutes.
Okay, good.
Representative Babbage, I just wanted to let you know that your audio and video are still on.
Okay, thank you very much.
And Representative Reckitt, your video is on as well.
Mr. Chair, you may be aware, but we're in the Republican caucus is meeting briefly.
Welcome back, committee members. If you are able to, if you're back at your desks, please activate your video and we'll start up again in just a moment. And while we're waiting for committee members to return, Representative Cardone, could you want to introduce yourself? I think we missed your introduction this morning.
No, you didn't. I did introduce myself, but Representative Harnett has joined us, I believe, and he may want to introduce himself.
Yeah, that was going to be my next call. Thank you. I'm just losing track because all the squares are moving around a lot today. Representative Harnett, co-chair, would you like to introduce yourself?
Thank you, Madam Chair. Welcome all. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner, where I reside, and I am sorry to be joining you a little late.
So that's okay. We're happy you're here. And it looks like everyone has returned from our short break. And so we have a pending motion by Representative Moriarty, ought to pass as amended. seconded by Representative Sheehan. Is there any discussion on the motion? Senator Keim, go ahead.
I just wanted to say that I appreciate all the work that's gone into this bill, and I'm very happy that we can be voting it out this session.
Thank you very much. Any additional comments or discussion? Not seeing any. So with that, we will move on to a vote. And we're joined by our committee clerk, Susan Panett. Thank you, Ms. Panett.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Sorry.
My apologies.
Yes.
Senator Sanborn.
And it makes sense. And the court did write us a note saying.
Okay,
I think we're okay.
I'll recall. Senator Sanborn.
Yes.
Thank you. Senator Sanborn votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes. And
Representative Harnett votes yes. Representative Babbage.
Yes.
Hold 1 moment. Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone.
Yes.
Representative Cardone votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Representative Hagan. Representative Hagan is absent. Representative Evangelos. Representative Evangelos is absent. Madam Chair, I have 12 members voting in the affirmative, 0 in the negative, and 2 members are absent.
Thank you very much, Ms. Panett. And with that, the ought to pass as amended motion carries unanimously thus far. And again, I want to just echo Senator Keim's remarks. Thank you so much for bringing this bill forward and all your hard work, Representative Morales.
Thank you all very much.
And with that, we'll close the work session on LD 320 and move on to our next work session. And we're going to take things a little out of order today, again, to accommodate a lot of scheduling issues. And we will next move on to LD 1703. And this is an act to amend the bail code. And the sponsor is Representative Talbot Ross. I'm going to bring her onto the panel. And Peggy, this is a bill that we've received an amendment on. And would you like to present the amendment, or should we ask the bill sponsor to do that?
Well, I know a lot of people have worked hard on the amendment. I'm happy to try to do it if you'd like. I don't want to steal Representative Talbot Ross's thunder here.
Okay, let me call on Representative Talbot Ross then initially. Welcome, Representative Talbot Ross, back to the Judiciary Committee. We're pleased that you're here today and would welcome the opportunity to hear from you about the amendments that you've made to LD 1703.
Well, thank you, Madam Chair, and thank you to the members of the Judiciary for being here today, for all the hard work that you've been doing all session, but particularly today, after a couple of days here at the State House. I do want to give voice to where all the credit is due for the work on the amendment, and that is with DA Sarbuck, who is here with us today, Cumberland County District Attorney, and Megan Sway from the ACLU. just put in quite a lot of work to simplify the bill that I think you've now are familiar with a couple of times. It's been presented, but we did take great strides to try to put it in an order and a sequence that would really simplify this. So I'm fine with Peggy presenting it. I do believe that you have both the amendment and then a section by section explanation of the bill. I think one of the stickling points from before was a piece that we put in at the request of DA Sarbuck. And again, he is here to answer any questions about that component of the bill.
Thank you very much, Representative Talbot Ross. And before we move on to any questions, I'm just going to bring DA Sarbuck into the conversation because I do think that there may be questions for him.
And can I just mention that the I know that Representative Talbot Ross had 2 documents and I combined them in one to send them to you. So the section by section analysis is actually starts on page 6 of the amendment document that you received. So that might not be great for pulling it apart and looking at it, but I was trying not to give you too many individual things.
Yeah, that was super helpful, Peggy, actually, from my perspective. Thank you. Representative Harnett, go ahead.
Thank you. I just want to make sure I'm on the right document. We're looking at the amendment that is dated yesterday. Peggy, from you.
The email is, this is LD 1703.
Correct. Is it in the electronic file? Dated June 4th?
Yes, yes, I'm sorry. It is in the electronic file. Yes. The date on the amendment itself, as it came from Representative Talbot Ross, is May 30th.
May 30th. Okay.
Yes. That's what it says on the document itself.
Thank you. Thank you very much.
Thanks for that clarification. So Peggy, I think at this point, if you'd like to review the amendment with us, please.
Okay, I will. Do you need me to screen share?
Let me just ask committee members, would it be helpful, committee members, to have the screen share?
Yeah. Okay.
Yeah, I'm seeing some nodding heads. Thank you very much, Peggy.
Okay, well, here's the downside of me putting it all in one document, because now I don't have the section by section analysis in front of me. Okay, do you see it? Everybody sees this now?
Yes.
The brain trust working on this bill figured out that we didn't need all that information about what about when a bail commissioner cannot require a financial security for bail. That we only need it in one place. So the first couple sections of the bill are gone. So instead, this just seems like such a streamlined draft now. So this is amending, section 1 amends the bail code with regard to what bail commissioners can do. And if you remember, there was a discussion about there's a $60 fee whenever a bail commissioner sets bail, whatever it is, even if it's personal recognizance, that they wanted to make clear that if the defendant is responsible for paying that fee, unless they don't have present financial ability to do that. And if they're qualified to be released, then that cannot be a reason that bail is not set. And so here's basically the new language here. A bail commissioner shall not refuse to examine a person to determine the person's eligibility for bail, set bail, prepare the personal recognizance or bond, or take acknowledgement of the person in custody because the person in custody lacks the present financial ability to pay a bail commissioner fee. And if you look at what the current language is, it already provides that the sheriff of the county in which the defendant is detained may create a fund for the distribution by the sheriff or the sheriff's designee for the payment of that bail commissioner fee. That is current law now. So this is just clarifying that the defendant doesn't have the ability to pay right then, they do not have to pay, and that can't be the reason why bail is not set for them by a bail commissioner. And then there's this new sentence that the bail commissioner fee is not a financial condition of release for the purposes of pre-conviction bail. Okay, ready to go on?
Think so.
Yeah, this simplified an incredible amount from the book. Okay, so now we're looking at pre-conviction bail or pre-trial bail. And these are, these conditions may include that the defendant, these are the conditions that can be part of bail. And the first one we're going to amend is 9A. And this is the submitting to a random search for possession or use of a condition imposed under subparagraph 9, but only if the defendant is a participant in a specialty court docket. So drug court, co-occurring disorders court, whatever, or any other specialty docket, or by agreement of the parties as part of a deferred disposition. So what this does is it strikes out, you can see here, it strikes out subparagraph 9. So, you can't do a random search, but there's always a search upon articulable suspicion for possession or use prohibited by a condition imposed under 9, if that makes sense. Okay, random search is still okay for if somebody's a drug court participant or is part of their deferred disposition. It also strikes out the requirement, this cannot be a requirement of bail, that the defendant report on a regular basis to the defendant's attorney. Some of this is going to look a little familiar because Representative Morales had a bill, LD 844, that was addressing some of these conditions, but also probation. We're just looking at bail in this bill. So here's the section about cash bail or a financial condition. So a judicial officer, so anybody who is setting bail, may not impose a financial condition on a defendant for whom the highest class of crime charge is a Class E crime, except when it can be imposed on a defendant charged with a Class E crime when that Class E crime is a violation of the sexual assault chapter. That's 1. 2, it was committed against a family or a household member. These are all the things that were in there before. 3 is a violation of a condition of release committed while the defendant is released on bail for a charge that involves these different either sexual assaults or crime against a family or a household member or dating partner. 4, that is a violation of condition of release premised on an allegation of new criminal conduct, or when the defendant has failed to appear on the underlying Class E charge. So failure to appear on the underlying Class C charge, there can still be cash bail set for that. And then here's the one that we stumbled on last time, by stipulation. A financial condition imposed under this subsection may not exceed $5. And so this is why I think DA Sarbeck is in your discussion, because this is something that they use, and I'm going to attempt to explain it. And here's the example I was given, and it really helped me understand it. So a person has violated the law, committed a Class E crime. They are out on bail, no cash bail. They're out. They are misidentified and picked up. It's a wrong identification, but they're arrested for a Class C crime. So they are now arrested, and they are being detained on that Class C crime. And while they're being detained, they are in jail, and if they're not subject to some kind of cash bail for that Class E crime, the time they're spending while that Class C charge is being investigated does not credit against their Class E crime. The time that they might get sentenced for committing that Class E crime. They're not saying they didn't commit the Class E crime. They're saying they didn't commit the Class C crime that they're now being detained for. So the idea is, if the judicial officer sets very nominal bail, but it kind of, pings the system and where they are being detained in the jail, they will identify that this person has bail that's been set and they haven't paid it yet, so they're still sitting there, and that the days that or the time that they're there while the Class C charge is pending, that will benefit them getting out of jail faster. So they get credit. They are serving time in jail. It's pre-trial for the Class C crime, but they will get credit for it. And then say a few days later, they realize, the prosecution, the police realize that was a misidentification. They drop the Class C charge. The person can leave because they're no longer charged with the Class C crime, but it gives them credit for the time that they were sitting in jail once they go to trial on the Class E crime and they get sentenced. So at that point, you want to keep the bail very, very low. So once the Class C charges are dropped, they can pay the $5. Hopefully they'd have the $5 to then be released. So that's why it would be by stipulation, because the district attorney, I believe, and would understand that that's the situation. And if I have messed that up, I really hope that District Attorney Sarbeck can straighten you out.
Thank you so much, Peggy. And I'm going to just turn now, I know that Representative Harnett, you have your hand raised, but I did want to call on DA Sarbeck to add additional comments before we open this particular section up to questions.
So Senator Carney, is it okay if I?
Yes, please.
Okay.
Do you want me to stop sharing?
Yeah, I don't need to look at it. So thank you, Peggy. That would be an example when this could be, then this could happen. I'll tell you this much: in my about 12 plus years of prosecution, I've never seen a scenario like that. What we do though see quite frequently, probably every day we do in custodies, especially in Cumberland County, is when somebody has an open case, either it be a Class A, B, C, D, or E crime that they've been accused of, but they're out on bail, either they've posted cash or they're out on personal recognizance, and there's an allegation that that person commits a new offense. The state has the authority to request the court to have that person held without bail on the old docket. And it could be based upon new conduct, or it could be based upon the fact that they violated a condition of their release. And this also happens quite frequently when somebody's on probation. So if somebody's on probation, there's an allegation that they have violated their probation. On the older docket, the state may file or may request the court that that person be held without bail, meaning no cash bail can be set, that person's in custody. And that happens quite frequently, unfortunately. And so people, if the state moves for them to be held without bail on either the open case docket number or the probation docket number, the court may allow the state's request that they be held without bail. So that new crime, that new docket number, which could be a Class E crime, basically that person needs to have a cash bail component set for them to get credit on that new docket if they're being held in custody on the old docket. And so what we don't want to see happen is that somebody's held without bail on an older docket number, but because bail has not been set on the new docket number, even if it's a Class E crime, that person is not going to get credit for being in custody during that time. So let's say 30 days down the road, they either admit to their probation violation or they plead guilty on the underlying offense. they'll get, and it's and the judge says it's a 30-day sentence, and they've served the 30 days on the old docket, they'll get credit for time served. However, if there's no legal mechanism, no bail amount that is actually set on that individual, then they're not going to get credit for time served. And I'll just give you one example. We have a situation in Cumberland County where an individual was arrested. They posted $1,500 cash bail. Now, and I'm not trying to get into the politics of the state versus federal, but they were detained by Immigration and Customs Enforcement for violating their visa, and they went into custody. So that time that they're in federal custody, because they posted that cash bail within the state, they're not going to get credit for being in custody on the state's case. And we spoke to defense counsel, and COVID hit, and this is a whole nother story. But we wanted them to actually basically revoke that person's bail on the $1,500, give them back the $1,500. So if they're going to be in custody, they're going to be getting credit on the state case. And that's what this does with the stipulation, because there are definitely times in court where I make a bail argument, the judge sides with the state and saying, yes, this person is going to be held without bail. And we basically agree to a $50 or $100 cash amount on that new case, because that person is going to be in custody on the other case. They might as well get the time credit for being held in custody on the new case as well. If that other case gets resolved, then we will have to address bail in that amount. And that's why I think Megan did a great job with suggesting a $5 amount. So that person could possibly post the $5. I'll be quite frank with you, if they did a motion to amend bail to personal recognizance, most likely the state would agree to it. But at least it gives that opportunity. And if we're looking at a jail list and see an amount of $5 cash bail, we're going to know that it's most likely because of stipulation with defense counsel that that person would get that time credit. So that's where I think the more I would say scenarios that happen more often in the court. And Peggy, not to throw water on what your example was, but I think from a practical standpoint, what we see when you have multiple dockets open on somebody, we want to make sure if that person's in custody that they're getting credit on all of those dockets. And I think I told the committee before when we were talking about this, when I look at a jail list in Cumberland County where we have about 200 inmates being held pre-trial, about 2/3 of those individuals have two or more cases open, meaning 2 or more docket numbers open at one time. So it does happen quite frequently. And like I said, if you have somebody who's in custody, we want to make sure that they're getting time credit on all of the dockets that they're in custody for. Now, it's not to say how the case is resolved. Sometimes cases can resolve with consecutive time, meaning it would be sentences done consecutively, but quite frequently in the criminal justice system, sentences are deemed to be done concurrent time, meaning that they, on both dockets, they'll get the same time and they'll do that same sentence simultaneously, meaning concurrently. So hopefully I didn't muddy the waters too much on that, but this was from conversations that I had with Representative Talbot Ross and Megan Sway from the ACLU, wanting to make sure if somebody has that and they're going to be held on bail, that there's going to be a legal mechanism that they're going to get recognized to get that time credit.
Thank you very much. Let's open it up for some committee questions. And I'm going to start by calling on you, Representative Harnett, because you had your hand up previously.
Actually, thank you, Madam Chair. I think DA Sarbeck answered my question. And I got to admit, this is one of these things I understand when I hear it, but please don't ask me to explain it. Thank you. I think I get it.
Thank you. Committee members, are there additional questions for DA Sarbeck? I'm not seeing any questions on that issue. Thank you once again for joining us and for that really thorough explanation.
Great, thanks for having me.
You're welcome. We'll put you back to the attendee part of the meeting. And then committee members, I think that since we've started with screen sharing and we've seen most of the amended version, I'd like to ask Peggy if you could just take us through the remainder of it before we move on to committee discussion and potentially a vote.
Do you want to go back to screen sharing? Is that what you're saying?
Yes, could you please pick up where we were? Thank you.
Okay, So I think we just talked about this stipulation. And now this is items on a non-exhaustive list that judicial officers must take into account when considering what kind of bail to impose. And so this is, it adds in, it kind of describes the defendant's financial resources, including the ability of the defendant to afford a financial condition imposed by the judicial officer. I think that's all of that. I'm sorry, and it goes on. So these are history and characteristics of the defendant, including but not limited to the defendant's financial resources, the defendant's past conduct, without specifically saying including any history of substance use disorder. And then it adds 3 new things to be considered. Whether the defendant is the person primarily responsible for the care of another person, whether the defendant has a specific healthcare need, including a mental health care need that is being met or would be better met outside of custody, and 14, whether being placed or remaining in custody would prevent the defendant from maintaining employment. So these are considerations in determining what type or kind of bail to set. And then this is the contents of the pretrial release order signed by the judicial officer. So so it looks like 1 is already part of the current law. Include a written statement that sets forth 1, and if an agreement to forfeit money under subsection 3, paragraph A, 11 or 12 is ordered, the reason the judicial officer has set the amount of money ordered to be forfeited under the agreement. So it's just, it's not saying that can't be part of what's set for bail, but it's saying if that's set, then the judicial officer has to provide an explanation of why. And I think that's it.
Thank you.
Okay to stop?
Yeah, I think we're good to stop the screen sharing. And
Go
let's, oh, go ahead, Peggy.
I was just going to say, it's so much simpler to understand now.
Yeah, I agree completely. And I'm going to open it up now. Committee members' questions. Let's start first with questions for Peggy. Representative Moriarty, go ahead.
Actually, Madam Chair, this might go to the district attorney if he's still with us.
Okay, I can,
Or
yeah,
possibly Megan.
I'm sorry, he is not with us. I wish that I realized that. Why don't, if you can ask the question, and then I will, we'll see who's the best person to answer it.
Sure. Okay, I'll toss it out. But we've discussed that sheriffs have authority to set up funds for the payment of bail commissioners' fees for those who can't afford to pay themselves. And I'm just curious whether, in fact, that has happened in not just Cumberland County, but in several counties, or perhaps all counties statewide, or is it something that's not been utilized by the sheriffs?
Okay, I think that might be some, Peggy, you're shaking your head, but is that
I don't have information for that. I'm sorry.
No, that's fine. I was thinking that perhaps Megan Sway did, so I am going to bring her over to the panel. And I don't think that is changed by this legislation.
No,
is that correct, Representative Talbot Ross? Okay, so that's not all, whatever the status quo is, it's not altered by this bill. Megan Sway, thank you for joining us. Do you have an answer to that question?
Yes, thank you. Hi, Megan Sway, Policy Director at the ACLU of Maine. I am not sure about the status statewide. I know that Commissioner Liberty talked about how he set up a fund when he was sheriff in Kennebec County. So I do know that they have existed, but I don't know what funds are available and how much money is in each fund. I think that it's a county by county decision.
Yep. Okay, thank you.
Thank you, Representative Moriarty, and thank you, Megan Sway. Representative Harnett, go ahead.
Thank you, Madam Chair. I noted that Senator Troy Morton, I mean Sheriff Troy Morton is in the attendee room, and I believe he heads the Sheriff's Association. He might be a resource here.
Thank you. That's an excellent suggestion. I will bring him over to the panel. And Sheriff Morton, thank you so much for joining our discussion of LD 1703 today. I don't know if you heard the question from Representative Moriarty, but I can just restate it. I think the question is, have other counties established a fund that would help pay bail commissioners for people who were subject, who needed to pay the bail commissioners but did not have the funds to do so?
Thank you, Senator. I was totally unprepared for that, and I appreciate the question. I'm not aware of that. I could try to quickly get you an answer for that. I was actually in the waiting room on another bill, but I'm not aware of a fund that's set aside to pay bails. Now, that's not paying the bail commissioner, which is separate. In many cases, we know that bail commissioners will do bails as they're supposed to by statute, and not hold somebody because simply the bail commissioner fee themselves is not paid. And so I think that's what you're asking, Senator.
I think I actually was trying to restate Representative Moriarty's question, and I may have gotten it wrong. So Representative Moriarty, could you please re-ask your question to Sheriff Morton?
Sure, I can. This is actually existing language. It's not new or an amendment. It indicates that the sheriff of the county which the defendant is detained may create a fund for the distribution by the sheriff to pay the bail commissioner's fees for those who are unable to do so themselves. So in your county, for example, do you have such a fund?
We do not. And so,
okay.
I'm sorry.
Well, have you heard of others that do? Or?
I'm not aware of that, Representative. I can certainly, again, put that out quickly. But I will tell you, in our county, people are not held because they don't have the bail commissioner fee. And so and here's how it kind of works. As you can imagine, most of the county jails, certainly the ones our sides, are conducting regional booking processes, which means people are brought in. At times, we'll have 25 people a day commensurate. And so if bail's set on one individual and another individual comes in, a bail commissioner is already coming in to place bail on a person, and they will bail the other person that doesn't have a bail commissioner fee. We don't, we wouldn't call out a bail commissioner, at 2 a.m. I think we have a process of a couple hours that somebody does not have that we would actually call a bail commissioner in to do what we call free bail for the commissioner's fee.
Okay, well, that's helpful to know that, just what the current status is. So I'm grateful for your answer.
And I suspect, Representative, the answer would be very similar to the other county jails that they work that out. Our bail commissioners work hard and work well with the agencies, and most of these jails are doing regional booking processes.
Thanks.
Certainly.
Thank you. And thank you for being so gracious about being put on the spot on this bill. I'm going to send you back to the attendee part of the meeting, and we'll see you on the bill that you're actually here for in a little bit.
Thank you, Senator.
Committee members, are there any additional questions? Representative McCray?
Thank you, Madam Chair. It's more a comment than a question. There's so much I like about this, but I wanted to just point out a small thing that I think is huge, and that's in section 5, number 1, where the conditions need to be clearly stated as a guide for the defendant's conduct. I think that's so important that people know what's expected. So I just wanted to call that out. Thanks.
Thank you. Committee members, any additional questions? Go ahead, Representative Harnett.
I'm prepared to make a motion if it's the appropriate time.
Yes, it is. Go ahead.
I would make a motion ought to pass as amended.
Thank you. And is there a second? Seconded by Representative McCray. And let's see, Representative Harnett, did you wish to speak to your motion?
Very, very briefly, I think this is a significant bill, a very important bill, and I believe the current bail system criminalizes poverty and leads to incarceration because of one's financial status, and that should never be a reason that one should be deprived of their liberty in this setting.
Thank you. Would anybody else like to be heard on the pending motion? Is the committee ready for the vote? Appears that we are, and thank you very much, Ms. Panett. So we're voting on the ought to pass as amended vote, amending LD 1703 with the document we've reviewed today. The amendment dated May 30, 2021. And the motion was by Representative Harnett, seconded by Representative McCray. Ready for the vote?
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
No.
Senator Keim votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCray.
Yes.
Representative McCray votes yes. Representative Cardone.
Yes.
Representative Cardone votes yes. Representative Galgay-Reckitt.
Yes.
Thank you. Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
No.
Representative Poirier votes no. Representative Evangelos. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Representative Hagan. Representative Hagan is absent. Representative Evangelos. Representative Evangelos is absent. Madam Chair, I have 10 members voting in the affirmative, 2 members voting in the negative, and 2 members are absent.
Thank you very much. And for those who voted in the negative, could you please let us know your report?
Ought not to pass.
Thank you both very much. And with that, the motion ought to pass as amended carries 10-2 with 2 absences. And we will close the work session on LD 1703 and move on to our next work session with thanks to the bill sponsor, Representative Talbot Ross, for bringing the measure forward. And Representative Harnett, did you have a question?
I was playing the role of Representative Babbage. I apologize, Madam Chair.
No, you're doing that very well. We appreciate your efforts in that regard. Okay, so now we'll move on to the next bill we'll take up is LD 1676. This is entitled An Act to Limit Access to Juvenile Case Records and Protect the Confidentiality of Juvenile History Record Information. And as committee members will recall, we had an extensive work session on this last week. I believe it was last week. And then those who had been working on the bill and the Maine Press Association agreed to meet and talk through some additional issues related to public access to information. And that work was very productive, and we have some amendments that are being presented to us for consideration to address those issues. And Peggy, at this point, do you think it excuse me, makes sense for you to screen share again and present us with the the additional amendments that arose out of that meeting or series of meetings?
Yes, that would be great. And I really do want to thank, in particular, Tanya Pearson, because we were working on this. They had a working group, and then she was the one who translated it all to me. So hopefully I got it all right. And I'll be happy to share. What we did was we took the bill and put all the amendments in it. So you're not going back and forth from the bill to the amendments. But when this gets printed, it's not gonna be another 20-page bill. So I'm going to share this. So hopefully you got this late last night. And so this is a bill to limit access to juvenile case records and protect the confidentiality of juvenile history record information. And one of the reasons that that people who've been working on this really want you to be comfortable with this and go forward with this now is because they're concerned once the court records become electronic, they want to have this in place. And if things need to be tweaked going forward, then that's possible. But this is kind of like the baseline. So there's a lot of provisions in the bill, and I don't remember if Christine Thibault told you about the administration of juvenile justice, making all those definitions consistent throughout all the statutes. So the first change that folks talked about is, these are all definitions. A lot of this is already in the current law, just consolidating it. So there was concern about the new civil violations for knowingly sharing information that is confidential. And there are 3 different places, actually 4 different places, because they kind of feed into a civil action, a new civil action. So this is the unlawful dissemination of confidential juvenile history record information. So juvenile history record information is information that is, I think, going to be held by the State Bureau of Identification, although I'm not sure how much juvenile history record information they have. But it's about the juvenile, and it associates the juvenile with criminal charges in the criminal justice system. So the way the bill read was any person who intentionally or knowingly disseminates this information commits a civil violation. And there were folks who were concerned that that was a really easy standard to meet. And so this language makes it parallel with the existing Criminal History Record Information Act and the existing Intelligence and Investigative Record Information Act, which applies to adult records, that says, so any person who intentionally disseminates the confidential juvenile record information, juvenile history record information, while they know it is a violation to do so, commits a civil violation. So I think there were some folks who were very concerned that this would be too easy. Yes, they know they're handing out the information, but they don't know it's in violation of the chapter. So that clarifies that language, and it makes it parallel with what applies in the adult record situations. So we'll see that 3 more times. So if you remember, we went, there was a question about disclosing the juvenile's identity or waiting. I'm sure I'm going to mess all this up. Waiting. Judy Meyer and the Maine Press Association were concerned about waiting for the 30 days after a petition is filed. And I think I'm not even in that place yet. I'm sorry, I'm pulling out the bill to make sure so we must not be there because we would have been striking it out. So here we are at unlawful dissemination of confidential juvenile intelligence and investigative record information. Same thing about defining that. And then juvenile case records are the records that are basically held by the court system. And so this is where there was a whole lot of discussion about when the juvenile petition would be open to the public. And the bill was going to keep it closed for 30 days, except in certain situations. And so this is the agreement that the kind of the working group and the Maine Press Association have put together, that any juvenile petition alleging a violation of these crimes, so murder, manslaughter, I'm not sure what that is. Anyway, those crimes, if the juvenile had attained at least 3 years of age, and the juvenile court has found there's probable cause to believe the juvenile committed a juvenile crime, that would be a violation of those statutes if the juvenile were an adult. That is open to the public. That petition is open to the public. Once the juvenile court has found that there's probable cause to believe the juvenile has done that, so the juvenile is over 13 or over, it's murder, manslaughter, and quick murder, felony murder, sorry, 202 is felony murder and 3 is manslaughter. If the juvenile has not attained 13 years of age at the time, then the juvenile court may allow public inspection. And there's kind of a process in paragraph C. So bad crimes, at least 13, open. And then paragraph B is class A crime if the juvenile has attained at least 13 years of age. So any class A crime, a lot of arson is class A. And again, the juvenile court has to have found that there's probable cause to believe that the juvenile committed that. That's open. If the juvenile has not attained 13 years of age, the juvenile court may make the petition open to public inspection, going through the process in paragraph C. So a petition, so this is for a class A crime, a petition open to public inspection. This is current law. I'm sorry, in the bill, it was proposed in the bill, may be made confidential, not open to public inspection, if somebody asks the juvenile court and the juvenile court provides notice to the juvenile, and as well as the office of the prosecuting attorney, and after hearing in which the juvenile court considers the purposes of this part, so kind of the rehabilitative start over again part of the juvenile code, the juvenile's interest in privacy, the alleged victim's interest in privacy, the nature of the juvenile crime alleged, and the characteristics of the juvenile and public safety concerns is outlined already. And the court determines that the general public's right to information does not substantially outweigh the juvenile's interest in privacy or the alleged victim's interest in privacy, then the court can keep it confidential. So the only change this amendment is doing is making sure that the court is considering both the juvenile's interest in privacy and the alleged victim's interest in privacy. And in doing that weighing, the court is determining, if they're making it confidential, that the general public's right to that information does not outweigh those interests in privacy. So now the next group is a petition alleging a juvenile crime that would constitute, so this is when the child has not attained 13 years of age. And we referred to paragraph C a couple of times. So here's the process. Let's see, if there's a written request is filed by any person requesting that the petition be open to public inspection, that the court finds there was probable cause to believe the juvenile committed the crime, and after notice, the court does that weighing again about juvenile's interest in privacy, alleged victim's interest in privacy, the nature of the juvenile crime, the characteristics of the juvenile, and the public safety concerns, and does that whole weighing again, whether or not in this situation. So again, paragraph C is somebody who has not attained 13 years of age. And then paragraph D clarifies that if there's a juvenile petition that alleges more than one crime, this whole analysis applies, is based on whichever the highest crime is. So if there's a class B, if it had been an adult, then that's how this is analyzed. So basically what this says is murder, felony murder, manslaughter, open to the public, open to inspection, and class A, open to inspection if the juvenile is at least 13. And I hope I'm expressing that correctly, and I think that was the agreement. So there's no 30-day delay. And then this is one of the amendments that the judicial branch really wanted, is that the prosecuting attorneys, we're talking about juvenile case records. So we're talking about records that are really the courts. They're in the possession of the courts. And rather than the court having to go through and redact, if you see right here, it's the bill said the juvenile court shall redact names and identifying information. This puts the burden on the prosecuting attorney to make sure that any information in the petition is redacted before it's filed with the juvenile court, if it's not supposed to be public. You want me to stop there, or you want me to keep going?
I think we don't have too many more changes. So let's go through them all, and then we'll open it up for questions and pull on some of the others who have been working so hard along with you on this.
Right. Oh, definitely hear from them. So the next section, we're again clarifying. This is about orders of adjudication when they're open to the public. And just clarifying again that when there's multiple crimes charged, the one that is the highest crime is the one that dictates how the whole petition or the whole order is treated. So I'm just speeding through this because this is the bill and I'm trying to find the next amendment. So this is the sealing of the records. The bill says that, and these are court records, remember, that the bill says it immediately, the court shall immediately enter an order sealing from public inspection all the records pertaining to the juvenile crime and its disposition. And this is after the juvenile is finally discharged from the disposition. And this says, as soon as that happens, the court has to immediately do it. And the court said, you need to give us some time. So this changes it to within 5 business days. And I think Chris Parr had raised the question about what about records, about cases that were adjudicated before January 1st, 2000, because those are in a different situation. So this applies to in all juvenile cases adjudicated subsequent to January 1, 2000, but prior to the effective date of the statute. And I think the intent is to make this whole bill effective January 1st, 2022. And if that's the case, then we should actually put that date in there. So subsequent to January 1, 2000, but prior to January 1, 2022, the juvenile court may grant the request of the juvenile's attorney for automatic sealing of all juvenile case records pertaining to the juvenile crime and its disposition when notice is provided to the court and the prosecuting attorney pursuant to this subparagraph. So the next 2 paragraphs again are about, so the first paragraph is about an order of adjudication, and whichever crime is the highest crime, that's how we focus. And the second paragraph is about a juvenile petition, and it's about sealing those records. And again, so this is the sealing the record. A copy of the court's written order certifying its granting of the juvenile's petition to seal case records pursuant to paragraph B or its order of automatic sealing as opposed to immediate sealing pursuant to paragraph C must be provided to the Department of Public Safety, the SBI. So that's clear how the SBI needs to work, needs to deal with those. And here's the violation for the unlawful dissemination of confidential juvenile case record information, tracking the other two and the Criminal History Record Information Act. So this is saying this, now we're talking about, before we were talking about records, now we're talking, or about the petition or the adjudication order. Now we're talking about the proceedings themselves, unless, and it's based on whether or not the petition is open to public inspection, which we just went over. So the type of crime and the age of the juvenile. And so that just circles around. So instead of saying it over and over, and it's totally based on whether the petition is open or not. And you'll see that general is struck out in several places. I was supposed to go back and strike it out throughout the bill because really the term is the public. It's either public or not public. So, and this is a change. I'm sorry, this isn't shaded right here. So this is we're in the competency hearing, and what I believe this is a recommendation from the courts that the competency hearing itself is not open to the public. It's confidential, and it's also not open to the people who might actually have some access to other records. So should be persons listed in section 3308D subsection 4. Those are the victim, or if the victim is a juvenile, the parent or guardian of the juvenile, and if the victim cannot act on the victim's own behalf due to death, age, physical or mental disease or disorder, so somebody else is appointed to stand in the shoes of the victim. They can be present at other hearings that are generally closed to the public, but they cannot be public. I'm sorry, they cannot be present. They cannot attend the competency hearing. So that's why they're excluded there. And rather than restating them all, we're just using that same group of people. So I'm trying to remember if this was, yes, this was in the bill, and this was about inspecting the competency order. And this was a big discussion that you had last time. The compromise is that take out this section and replace it with a brand new section in the competency hearing part of the statute. And it explains what's supposed to be in a competency order, because the idea is that competency orders will be open to public inspection. If the petition's open, then the competency order is open. And if the petition's not open, the victim still has access to the order itself. So so it's really important what's going to be in the order. The order must include a finding of whether the juvenile is competent to proceed based on whether the juvenile has a rational as well as factual understanding of the proceedings and a sufficient present ability to consult with legal counsel with a reasonable degree of rational understanding. Okay, that's the first thing. Competence is competent to proceed or not. B, so then B, C, and D are kind of, it depends what the finding is. If the court finds that the juvenile is competent to proceed, the order must specify the day on which the proceedings on the juvenile petition will resume. And there should be a period there. C, if the court finds that the juvenile is not competent, right then, but there is a substantial probability that the juvenile may be competent in the foreseeable future, then the order sends you back to 3318B, which has a whole process for what happens in that situation. But that's what's in the order. So the order says not competent now, substantial probability that the juvenile will be competent in the foreseeable future. Go follow what's already in the statute for that situation. D says if the court finds that the juvenile is not competent now and no substantial probability that the juvenile will be competent in the foreseeable future, then the order must set a date for a further hearing pursuant to 3318B subsection 2. That's already current process. This is just, the order just says not competent now, no substantial probability that will be in the foreseeable future, and go follow the statute. So that's what is in an order. All findings of fact made by the court in association with the issuance of a competency order are confidential and may not be included in the order. So whatever the findings of fact are, they are not included. The legal conclusion, the finding about whether or not the juvenile is competent, does go in the order, and that's what subsection 2 applies to. Competency orders may be inspected by the following persons. In all cases, the victim, if the victim cannot act on the victim's own behalf, then somebody who stands in for the victim, and the public, but only if the juvenile proceeding to which the order relates is publicly accessible. So if the petition is open to the public, the proceeding is open to the public, and then this competency order is open to the public. So I think that met everybody's, I think that was the negotiated agreement. And then again, this is the new civil right of action against somebody who has disseminated confidential information. And so we go back and pick up that language, intentionally disclose when the disclosure was made, knowing it was in violation. And I think those are all the amendments. Yeah. And now I've probably messed up something. So hopefully your whole working group, as well as Judy Meyer, if she's here, can answer your questions as well and straighten me out. Okay, if I stop, or do you have questions that I can answer by sharing?
No, I think why don't you end the screen sharing, please? And I just feel like we should give you a standing ovation. That was a very complicated and excellent summary of the changes. So you're getting a virtual ovation here.
I'm honored. Thank you so much. I'm just the scrivener in these things, you know.
I think your role as explainer is, you do it magnificently, and we really appreciate your work. Committee members, are there questions for Peggy before we move on to bringing in some of those who worked on this? Senator Keim, go ahead.
I have a very basic question, and it's probably in other places in the bill, but if you look at page 7, so it says a petition open to public inspection may be made confidential or not open to public inspection if upon request, and whatever. But my question is sort of, if that means that if a petition is open to public inspection, it would mean that it's already open. So then if someone does a written request, I guess I'm just trying to figure out if it's open and then someone does a written request to close it, does that mean it's been open for X amount of time and then it gets closed? I just was trying to, practically speaking, trying to understand what that meant.
Right. So I think that's possible. I think that probably if somebody wants to make a petition that would otherwise be open confidential, that they're going to move to do that fairly quickly. And remember, these are court records. They're open to public inspection, which means you don't copy them. You don't get a hard copy. You can look at them and that's it. You can't take a picture of them. So somebody could have looked at it, I guess, before it's made confidential and taken notes and know exactly what's in it. But once it's made confidential, then that kind of keys everything else that follows. So once it's made not open to the public, then the proceedings on it would not be open to the public as well. But as far as I know, you're right. If there's a time period where it was not made confidential yet, and somebody looked at it.
Okay, and thank you for that. And then my other question is, I missed the section where it was talking about redacting. Could you just point me to that section again? So I think you said that it was up to the prosecutors to redact the information before they sent it to the courts if it was supposed to be, if it's supposed to be kept confidential.
So this is the petition. So knowing that the petition may actually be open to public inspection, if there's anything in that petition that needs to be redacted, rather than relying on the court to do that, it's the prosecuting attorney's responsibility to do that. I'm not exactly sure what that would be, but there could be victims that would still be confidential.
Okay. And what section is that in the bill?
It's actually on page 8. It's underneath the new paragraph D.
Okay, thank you.
Mm-hmm.
Before calling on Representative Harnett, I do want to bring in some of the folks who have been working on this. And I just want to let you know before I move you through cyberspace, this is going to include Judith Meyer and Jill Ward and Tanya Pearson and Ned Chester. I think that's all the appropriate people. Having a hard time following who's moving through which cyberspace. Okay, I think that everyone has joined us. And Representative Harnett, before we move on to your question, I just wanted to give perhaps Tanya Pearson, you could handle this question. And if we could also hear from Ned Chester on the issue that Senator Keim just raised about confidentiality and records petitions being open to public inspection. If you had anything to add to that.
Certainly. Can I add a couple global? Good morning, everybody. Sorry. Thank you for inviting all of us. We're incredibly honored to be here, and excuse me, Peggy got a standing ovation. She is 100% the rock star, as is Rachel Talbot Ross, but Peggy is amazing. So I'm going to make her blush again because, man, oh man. I would just love to provide an overview a little bit, if that's okay.
Yes, please do.
Okay. So because I don't want us to get into the weeds too much. I want to distinguish between 1964, the bill that we had agreement on, which was the 129th, and then this bill and the differences, because that's, I think, why we recessed and needed to address the new provisions, which were of great concern to the press, and we needed to hash through those.
Could I just interject one thing, because I think that most of the committee members were not on the committee in the 129th. And so I would just say limit the comparison, because for many of us, it's just, it would be new information that we would need to acquire because we just weren't here for that.
Got it. Okay.
Thank you.
Thank you. So the rubric that we're talking about, I think the judiciary refers to it as the tier system. Our work group has referred to it as the rubric, whatever you want to call it, that Senator Kime was asking about, the when things are open, when things are closed. That was part of 1964. And I recognize that many of you were not present for that. And I think it helps to lay out what is open, what isn't open. And when we say open, we're talking about the records, we're talking about the hearing, we're talking about the court records later on. If an individual is over 13 years of age and they are charged with either murder or felony murder manslaughter or a Class A offense, that is open. It is presumptively open. Now, under the provision that was Senator Kime's question, anyone can petition to have a case that's otherwise presumptively open or presumptively closed, open or closed. And that is on page 7, the bottom of page 7, a petition open to public inspection, that paragraph. But the first consideration is that anyone over 13, if it's the murder, manslaughter, felony murder, Class A, it's open. If an individual is under 13, so our most vulnerable population, who we're really trying to protect, if that individual who is charged is under 13, then it is presumptively closed. And that is the only situation where it is presumptively closed for the highest offenses, the murder, felony murder, manslaughter, Class A. And there was some discussion a little while ago about arson. Arson is always a Class A. So when we're talking arson, that is a Class A offense. So here's the way that it works for everybody. For Bs and Cs, it is presumptively closed, but any person, either the press or whomever, can petition to have it open. And we go to that balancing act that the court is doing, which is outlined at the bottom of page 7. And that's really where we want the analysis to be. The court to be weighing the privacy interests of a victim, for example, which has been added in, the juvenile's interests, society's interests, the public's, that public safety consideration, all of those factors. We want the court to be making that determination, and anyone can petition the court to have a hearing open. So that's the quick answer. You can think of it as, if it's the highest offenses, a juvenile is over 13, it is open. And a juvenile actually who is over 13 cannot close those highest offenses. The ability to petition to close it is not available for the murder, manslaughter, felony murder, Class A offenses. If they are under 13, it is presumptively closed, but anyone can petition to have it open. Likewise, as Senator Kime was asking, if something is open, which would really be the only situation where a case would be open, where a juvenile would want to close it, would be the murder, manslaughter, felony murder, Class A offenses, and a juvenile cannot close those. And that is in recognition of the public's right to know, the press's right to report on that, public safety concerns. It's the balancing act that we did when coming up with this rubric. So I hope that helps answer that question.
Let's just turn to Senator Kime for confirmation. Senator Kime, does that address your concern? Do you have any follow-ups? She may have had to step away momentarily, but I thought that was a really helpful and clear explanation. Thank you. Representative Moriarty, did you have a question on this topic?
Yes, I do, Madam Chair. Thank you. Ms. Pearson, this may be an obvious question, but if a record is open to public inspection, as our chair just indicated, you can't get a copy, you can't take a photograph and so forth, but can a member of the press observe the record, take notes, dictate observations into a personal dictaphone, and then go back and write an article?
Yes, the short answer is yes. So if a case is open, if a petition is open for inspection, the process is open for the public or the press to be present. So everything hinges on essentially what is open, right? That's why we turn to the rubric. So if it's open, you have access to be there, you have access to look at the petition and very limited documents, but not take photographs of that. Because remember, our big goal here is we're trying to eliminate highly confidential information that goes out into the world through our digital era that haunts a juvenile who is otherwise rehabilitated down the road, years and years down the road. So that ties in with the digital access as well.
Well, okay, I get that, but if you can look at it and yet still disseminate it through a press article or a broadcast, isn't the net result the same?
I think yes. And the answer to that is we're balancing the public's right to know with a juvenile's right to privacy. And that's why we've honed in on the most serious cases that, frankly, from my experience, it has only been those Class A's and the murder, manslaughter, felony murder cases where I have ever had a press member interested in tracking a case or being present in the courtroom. I'm sure there are exceptions to that. And if there are, that's why we've built in a process that the press could say, or anyone could say, hey, we're interested in this. We have a public right to know interest in finding out about this. Here are the reasons why, and the court makes that determination.
Okay, thanks for your answer. Appreciate it.
Absolutely. There are what we worked on over
before you continue, are you still giving, I would like to just take a break and give the Maine Press Association and Judith Meyer an opportunity to comment also in response to Representative Moriarty's questions, if you'd like.
Yeah, the process is Representative Moriarty, we go to the courthouse, we open the file, we take out a pencil, we write down notes on paper, and we use that as the basis for the reporting. We don't duplicate the records in any way. And that's the current rule as well.
Yep. I assumed as much. I just had to confirm. Thank you.
Yep.
Thank you. And then Tanya Pearson, were you going to continue with the sort of the global overview?
If everyone's okay with that, I keep interrupting and I apologize.
No, you're doing wonderfully. And I think that before we move on to back to the global, Representative Harnett has a question as well.
Thank you, Madam Chair, and thank you, ADA Pearson. My question has to do with records that were open to inspection and then subsequently closed upon request. You can't put the toothpaste back into the tube. What is the status of the information that was gleaned from the records when they were open to public inspection? Are they then treated, is that person supposed to treat them as confidential now? And could they be punished for continuing to discuss them? And I'm concerned about the press here. Am I clear with the question?
So is the question, if originally it's open and then a motion is filed to close it, which really the only presumptive open cases would be those high level cases, then what happens with the information?
Yes.
You know, from that point forward, the information would be confidential, but information that had been reported earlier is out, as you said. And I don't see, and that's why we're trying to be so careful with the information, because we all know the repercussions down the road. And it's that whole policy argument for why we want to protect our youth in the situations where they're in a juvenile system. I can't imagine the press or I can't imagine the press intentionally disseminating information that is now closed. The press is very respectful from my experience of that. I think it would be more likely that a disgruntled individual, an angry individual, perhaps the victim, would want to disclose confidential information. And that's why we have the penalties provision, but we wanted it to be a civil violation and not create another criminal offense. Does that answer the question?
Even though when they obtained it, it was a lawful thing to obtain and a lawful thing to share.
Yeah, it's a great question. I think the answer would be once it has, a court would be deciding that, I guess, is the bottom line, if a violation occurred. And that's what the penalty provisions provide for. I don't think I could answer it, but that's what the court would be weighing and determining. You're right.
Thank you.
I think that Jill Ward has something to contribute to that response. Go ahead.
Yeah, just to get a sense of proportion, and I would welcome Ned or Tanya or Judy weighing in on this, but I think practically speaking, in these very high level, it's very few and far between. We have some of the norms in practice anyway. And, the reporters do, the most important thing about this bill is it codifies the no online juvenile record access. That's the most important thing. And I think, Judy, you may be able to correct me if I'm wrong, but like going to the courthouse and inspecting and then if there is a petition at the time to close it in that moment from the defense attorney, practically speaking, we're still really from a implementation standpoint, limiting access. Do you know what I mean? Like it's very clear right away if the defense is doing their job that they're making that motion. And so I'm just trying to sort of give it context from like pragmatically speaking, how big of a hole that might feel like a big hole. I think practically speaking, it's not a very big hole.
Thank you.
And that's coming from a juvenile advocate. So, yeah.
Would anybody, okay, go ahead, Ned Chester.
Just briefly, that's why we had the amendment that would require 30 days period of time for the defense attorney to kind of assess the case and to make some decisions about whether a motion to close or a motion for a competency eval would be filed, which then would affect whether the case ever became opened after that. This was part of our compromise that we will lose that 30-day protection for that small subset of kids who, frankly, those are the kids those are the cases that the public is probably most interested in. And they are the cases, once they get into the press, are going to haunt our clients. This was a compromise, and defense attorneys may try to find a way around this. I've got some ideas, and the danger there, of course, is that it means that those who are really practicing this are going to be able to make some inroads that maybe less experienced people can't. But this was part of the compromise, and I think Jill's right. We sacrificed the 30 days in exchange for this agreement, and I am on board with that.
Thank you.
Those who have been working on the legislation, any additional thoughts on this point? Tanya, go ahead.
I was just going to add that Chris Parr has been an integral part of the process, and I think he is in the waiting room. And so if everyone is okay with that, he really should be added in as well.
Okay, I do not see him in the attendee part of the meeting.
Then never mind.
Yeah, thank you. I know we've taken this up later in the day than we probably anticipated. Thank you for suggesting that. Okay, so Representative Babbage, I know that your hand was up. Do you have a question on this particular point before we continue with the sort of more global perspective?
Yes, my comment regarding just what we were talking about had to do with not only protection of the defendant, but also protection of, at the time, legally obtained information by the press if they should later distribute. And I didn't know, but I appreciate the discussion, and it's been asked and answered. So thank you.
All right, great, thank you. Tanya Pearson, did you want to continue with the global, as we'll call it, we'll nickname it?
Sure. So we have the rubric, that tier system that we've all been talking about, and it goes across the board. It's, looking at the petition, being present in the courtroom, are the records sealed, which Christine outlined for the members when we had the last work group session, and I'm happy to answer any other questions, but I don't want to beat it to death. That was in 1964. The big changes, and I know not everyone was present for 1964. The majority of you were not present for 1964, but why we recessed, the big changes were, as already been referenced, the 30-day wait period that had been written into our proposal. The penalties provisions, and I would like to talk about that. The sealing provision, and the competency. And the competency is really the significant change from 1964. And I think there is, and I don't want to speak for main press, but there is general agreement on the competency that the information so let's go to that. That is on page starts on page 14, and Peggy already outlined the competency orders, which is on page 15. So when we're talking a competency hearing, we're talking about our juveniles who are absolutely the most vulnerable. They may not be competent, and hence the information ultimately, that is gleaned from that hearing, from that court process, is not going to be open to the public. And so we want to be really careful in guarding the information. And the information that is provided to the court in a competency hearing is the most highly confidential information about the family, about the victim, about information that none of us want out there in the world. And so we wanted to make sure that we're protecting that information. And main press's concern is that they are entitled to report on particularly these high profile cases where a juvenile is found incompetent to proceed, or any type of ruling that the court makes under the competency statute. So that's why we came up with this compromise that allows the press to do that. And gratefully, as Meyer, said, no, we don't want to spew, that highly confidential information, but we do want to be able to report on what the court decided. And so that section on page 15, the contents of the competency order, mirrors verbatim what the court's form has on it that the judge will be ruling on. That form is in the process of the forms for the judiciary are in the process of being finalized. All of the juvenile forms for the court have undergone a update, so to speak, and they haven't been finalized, but that section 1 of 3318C essentially codifies what is going to be on the form. So it's exactly what the court will use. It's the finding that the court will make. And that information will not have the highly confidential information, but will have the ultimate decision that the court made in cases where we have a public interest, where the press is interested. And I'll let Judy speak to that because I don't want to speak for the press, but that section mirrors what the court does. And it identifies, it ties in with that big rubric on the bottom of page 15, section C. We tie into section 3308C, which is the rubric, as to which cases other individuals, i.e. the press or any members of the public, would have access to that order. And it's really important from a victim standpoint that the victim is always able to see the order. Again, we don't want the victim to have the highly confidential information, but the victim is entitled to know what decision the court reached. And so the victim, or if the victim, is not able to get that information themselves. A representative of the victim can get that information, whether the case is open or not. So victim always gets to know what the court decided, but everyone else only gets to know with the cases that are open.
Thank you very much. And I think at this point, it sounds like you've covered kind of the more global perspective, and I want to really focus more on specific committee member questions at this point. But before we get to that, I just want to give the Maine Press Association and Judith Meyer an opportunity to speak to the competency order aspect of this and the compromise on that. And if you could share your perspective on that, please.
Sure, thank you. I really have nothing more to add. Ms. Pearson explained it perfectly and presented our concerns and the resolution. I think this is a really good balance, and we're grateful that our voice was heard on this.
Thank you. Is there anything else you'd like to comment on before we open it up for committee questions?
No, we're fully in support of the compromise.
Thank you. And thank you once again for all your work on this as well.
Certainly.
Committee members, I'd like to recognize anyone who has a question for Judith Meyer, Jill Ward, Tanya Pearson, or Ned Chester. And of course, the bill sponsor, Representative Talbot Ross, as well. Are there any questions, committee members? Not seeing any. I think you've all done your jobs really well in explaining the bill to us. Representative Harnett, go ahead.
Thank you, Madam Chair. I would like to move ought to pass as amended, along with my thanks to all of the stakeholders for the amazing amount of work they've done and the compromise they came to in between today and our last work session and today. Thank you very much.
Thank you very much, Representative Harnett. Is there a second on the motion? Lots of seconds. Representative Babbage, were you're in the upper left-hand corner, were you raising your hand a second? Because I'll choose you.
I appreciate the physical positioning of my square. I will second happily, and I have been looking at this with great scrutiny, and I'm just delighted with the work of everybody involved to get to this place. Thank you.
Thank you. Peggy, I see that your hand is up as well.
Thank you. I have two questions. One is the effective date, which I kind of alluded to, and I think that was a recommendation and I did not draft it in, so my apologies. The effective date of January 1, 2022, but I want to, people are nodding, so okay. Just want to make sure that's soon enough. I know the court wants time to catch up. Okay. And then the other question is one that came up at the last work session, which was that provision in the archives that says any of the records that make it to archives become public after 75 years. And if you're okay with that, then you don't need to do a thing, I think. But if you do want to change that and say, no, we don't want these available for 200 years or 100 years or whatever, then I think you actually do need to write that into each of the sections that describes what the records are. There, so you have three categories of records. So I just want to raise those before you get to the point of actually voting. Thank you.
Yeah, thank you, Peggy. So we'd all decided that we're going to incorporate the effective date as part of the amendment. And then with regard to the archives, my suggestion would be that since we've got 75 years to work on that we maybe try not to tackle that today. Does that make sense to you, Peggy? Okay. Thank you.
Sorry. Yes, if you decide next year that is something that you need to protect for longer than 75 years, then you can have a hearing on that and talk about it. That's
great.
Yeah.
Thanks. All right, committee members, is there any discussion on the pending motion?
Madam Chair?
Yes, go ahead.
I just wanted to clarify that the 75 years is the default position in place unless the legislature takes action.
Yes.
Thank you. Thank you.
Oh, my hand's up. Look at that.
Any other question for any of our guests, committee members? Okay, before we move on to a vote, we again want to express thanks to all of you. I'm going to send you back to the attendee part of the meeting because when we vote, we tend to only have the sponsor on with the committee. And thank you all. Okay, and committee members, I think that we are ready for a vote. Does anybody need time to caucus before we move on to a vote? Go ahead, Senator Kime.
Yes, if I could have just a brief caucus.
Okay, is 5 minutes good with everybody? Okay, so we'll be back at 12:23, everyone. Thank you. Committee members, when you've returned to your desks, you please activate your video just so that we have a sense of who's back and when we're ready to get to move forward with this motion. Thank you. All right, it looks like we're all back. Thank you everyone for being so prompt. So we are moving toward a vote on LD 1676. There's an ought to pass as amended motion by Representative Harnett, seconded by Representative Babbage. Is there any further discussion on the motion? Is the committee ready for the vote? It appears we are, and Ms. Panett, thank you very much. You can go ahead when you're ready.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone.
Yes.
Representative Cardone votes yes. Representative Galgay-Reckett. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
No.
Representative Poirier votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Hagan. Representative Hagan is absent. Madam Chair, I have 11 members voting in the affirmative, 1 member voting in the negative, and 2 members are absent.
Thank you very much. Representative Poirier, could you please let us know your report?
Ought not to pass.
Great, thank you. And so the ought to pass as amended motion carries 11-1 with 2 absences. And with that, we will thank the bill sponsor and conclude our work session on LD 1676. And again, expressing thanks to all those who worked on the bill. And with that, I just need one moment to attend to one thing. So I'll be right back with everybody. Thank you, committee members, for your patience. I did want to recognize Senator Keim. I think that Senator Keim has a request that we reconsider a couple of bills. And Senator Keim, could you just outline what the bills are and the basis for the reconsideration request so that we can understand where you're, just go
Thank
ahead
you.
and explain it, please.
Yeah, so I haven't dug through notes to find the LD numbers, but I did email you, Peggy, yesterday about this. So one is the bill that would make public the complaints, and that already is public. And so we were going to do an amended version of that bill, but have found that that we don't need to. And so we would like to just join the ought not to pass on that because I think it makes it easier. It streamlines the process on the floor. What number is that, Peggy?
That's LD 725, Representative Dillingham's bill.
Okay, LD 725. So, and I know Representative Hagan, though he is absent, wants to join on the ought not to pass, as does Representative Poirier. So, so he would add his vote later, and that would just, I think, make that easier. And then the other bill I was hoping to reconsider, I voted wrong on because it was one that I called in and just accidentally voted wrong. Is that 1380?
Yes, the
Okay.
Option contracts.
Options contracts. So I voted on the prevailing side, but I would like to vote on the minority report. So those are the two, if the committee is willing to do that. I could make a motion to reconsider on 1380 because I voted on the prevailing side, but not on the other bill because I did not vote on the prevailing side.
Okay, it's is there a committee member who would like to make a motion to reconsider on LD 725? Someone who voted on the prevailing side? Motion by Representative Babbage. Is there a second? Oh,
I'm sorry, Representative Babbage was absent for that meeting.
Why was?
But he voted, but he.
That's the one.
But
No,
didn't he end up voting for it?
No, he didn't vote in it. I'm sorry.
That's the one I didn't see that one. That's the one. I'm sorry, Lisa.
Well, now you'll get a chance.
Okay.
I'm
Is there
sorry.
another committee member? Supi, could you please let us know who voted on the prevailing side on 725?
I would be more than happy. Senator Carney, Senator Sanborn, Representative Harnett, Representative Galgay Rickett, Representative Moriarty, Representative Sheehan, Representative Evangelos, and Representative Newell.
Thank you so much. Okay, I see Representative Harnett, you're recognized.
I'll move to reconsider.
Thank
Make a
you.
motion to reconsider.
And Representative Moriarty, I saw you were rising to second that one. Representative Rickett?
Yes, could somebody tell me what the bill was about?
Yes, it was Representative Dillingham's bill to, it was really focused on the portal where people could send complaints about folks who are not complying with mandates during the COVID-19 pandemic.
Okay, I remember now. Thank you.
Right, and it turned out everything was public.
Yeah.
Okay, and so we have a motion and a second to reconsider. And because those who are watching on YouTube can't see our electronic hands, if you are in favor of reconsideration, please raise your physical actual hand.
Well, I have 13.
13 with one absent.
Thank you very much. And so now we will move on to the vote, which we'll do by roll call on the motion to reconsider.
No.
I mean, on the, well, then now we need another motion. Representative Harnett, are you moving ought not to pass?
Motion ought not to pass.
And is it seconded by Senator Keim?
Sorry, are we all waiting for me?
Ready for the roll call when you are.
My apologies. I write pretty fast, but not that fast. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yeah, yes.
Senator Sanborn votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone.
Yes.
Representative Cardone votes yes. Representative Galgay Rickett.
Yes.
Representative Galgay Rickett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Representative Hagan. Representative Hagan is absent. Madam Chair, 13 members voted in the affirmative, 0 in the negative, and 1 member is absent.
Thank you very much. And so the ought not to pass motion carries unanimously with 1 absence. And now we'll move on to LD 1380. And Senator Keim, go ahead.
Madam Chair, on LD 1380, having voted on the prevailing side, I would make a motion to reconsider.
Thank you. And is there a second to that motion? Seconded by Representative Poirier. And again, committee members, all those in favor of reconsideration, please raise your physical hand and keep it raised until the count is complete.
13. I'm fine. 13.
Okay. And then was the original motion, Ms. Panett, was it an ought to pass as amended or an ought to pass?
I had ought to pass.
Straight. Yeah.
Yep. Me
Great.
too.
Okay, Representative Moriarty, would you like to make a motion?
Move ought to pass.
And is there a second? Seconded by Representative Sheehan. And and the ought to pass was the prevailing vote. Is that correct? Okay,
9-4 with 1 absent.
thank you. So I so appreciate the strength of this team. All right, I think we're ready to vote. Soupy, whenever you're ready.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
No.
Senator Keim votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone.
Yes.
Representative Cardone votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
No.
Representative Poirier votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Representative Hagan. Representative Hagan is absent. Madam Chair, I have 11 members voting in the affirmative, 2 in the negative, and 1 member is absent.
Thank you very much. And for those who voted in the negative, could you please let us know your report?
But not to pass. Thank you so much, everyone, for allowing me to do this.
You're welcome. And so the ought to pass motion carries 11-2 with 1 absent. And with that, we'll close the reconsideration of 1380. And with committee members' permission, are we able to move forward with our work session? Actually, before we move forward with our work session on LD 86, well, let's move forward with 861 and then talk about how we'd like to handle the errors bill. I know that there are people here on 861 who have been waiting quite a significant amount of time. Okay, so we'll go ahead, Representative Cardone.
Oh, I'm not muted. Thank you, Madam Chair. I am a sponsor of LD 480, and 480 is on for a work session today. I have to be in AFA from 1:30 to about 2:30, and I wanted to be present for the work session on 480. I wondered whether you could make that work given your given what else you are have on your calendar today. I will be back on judiciary as soon as AFA has concluded.
Let's see, Peggy, are you prepared to move forward on 480 as well?
Right, so 480, the question is, it's a mandate because this is the one about appointing attorneys in guardianship proceedings.
Okay.
Right, we can talk about that now. And I did mention to Kathleen Ayers and Judge Mitchell and Leo Delicata that we might be talking about this, just in case you had questions for them. They know they don't have an opportunity to speak. But if you want to talk about that, I had brought it back to you because it's a divided report. I had brought it back to you because it's been identified as a local government mandate. And I wanted to make sure you knew that and you would deal with that the way you want to.
And in all fairness, I was probably going to ask Leo Delicata to speak. And I'm not asking you to do it right now. If you prefer to move on with the other bill with other people, I just wanted to make you aware of that 1:30 to 2:30 window that I think that's probably what it's going to take. There's a report by Commissioner Figueroa that I need to hear on the ARPA funds and the bill for the ARPA funds. I'm not asking you necessarily to do it right now. I just wanted you to be aware of that window.
Okay, then let's wait and take it up. I'm assuming it will be after 2:30 because we have a number of FOA reviews.
That's fine.
Okay, we'll fit it in with you when you get back. Thank you for bringing it to our attention.
Thank you.
All righty, so let's open up the work session on LD 861. And I do not see the bill sponsor with us today. But I do know that we had an amendment. And Peggy, could you please share the amendment using screen share and then just speak to us briefly about it?
All right. Can you see this?
Yes.
And ignore the typo right there. Don't look at that. So this is LD 861. If you remember, 861 had two pieces in it. One was about directing DHHS to contract with medical practitioners to do the evaluations under what we call the yellow flag law and what other folks are calling the weapons restriction evaluation, I think. And the other piece was the section 2 was limiting who could actually do those evaluations to the medical practitioners or the forensic psychologists at Dorothea Dix and Riverview, at which would cause a huge problem for any law enforcement officer who picks somebody up, takes them into protective custody, and then realizes they need to go through this evaluation. They would have to go to Bangor or Augusta, and that was a problem. So this amendment strikes out section 2, and it amends section 1 to say, to direct DHHS to contract with forensic psychiatrists and forensic psychologists only. The medical practitioner's definition is broader, and the testimony that you had from some folks, not everybody, was that for people who need to do these evaluations with regard to whether or not somebody should forego possession of their weapon for at least a while, should be limited to a higher category of folks who are more trained for that. And so that's why this is limit who can do those. It actually doesn't limit who can do them, but it does direct the department to enter into contracts with just forensic psychiatrists and forensic psychologists who are qualified to perform these assessments, and that they need to be available 24 hours a day, 365 days a year. And the idea is that they wouldn't have to be here in Maine or in Bangor or in Portland or wherever. They could do it using the telehealth system. And that would take the pressure off the hospitals and the people who might not have these qualifications to do those evaluations. So that's the purpose of this resolve as amended. Do you have questions?
Thank you. I think if you could please end the screen sharing. So we can see each other.
Putting forward state.
And okay, so committee members, I have concerns about moving forward with the amendment because I feel like there are a lot of unresolved issues about the amended version of 861. It's a really significant issue to address, and the parties, all the stakeholders in this issue have not been able to resolve it. My recommendation, or to bring us resolutions that show us a way to move forward with this that's implementable and meets the needs of the parties and people in Maine who, whose lives are touched by the so-called yellow flag bill. And I would like to suggest that we table this and carry it over and allow some additional work to be done between sessions. And that is my recommendation to committee members. I'm happy to bring some of the parties who are involved in this legislation onto the panel if people feel that they would like to hear from them. So let me start with the question of would committee members like to hear from the advocates who were proponents of bringing this legislation forward? Go ahead, Representative McCreight.
Thank you, Madam Chair. It just makes sense to me if we're asking people to continue to work on it, that we would hear from them when we come back. So that would be my suggestion.
And as that, I'm seeing lots of nodding heads. Committee members are comfortable giving those who are involved additional time over the between sessions and then hearing from them when we resume in the second session. Okay. Is there anybody who's not comfortable with that path forward? Representative Babbage?
I just wanted to share that in reacting to this concern, regarding third-party contractors, that always opens my eyes. I do see the advantages of it. I was interested to hear that the psychiatric hospitals were not interested in being on call. I don't know how much use this law would actually have, but I was wondering if the possibility of funding additional personnel to handle this might keep money in state rather than contracting an out-of-state contractor. But I'm in favor of allowing the stakeholders to continue to talk on this. So thank you.
Okay, thank you very much, Representative Babbage. And with that, is there a motion? Representative Babbage, was your hand up to make a motion?
I can do that, Madam Chair. I move that we carry over LD 861.
Yeah, I think
868
would be it's 861. I think it would be
861. Right.
First to table and then to carry over.
Okay. So moved, Madam Chair.
And is there a second? Seconded by Representative Sheehan. Lots of seconds, but I saw Representative Sheehan first. Okay, so this is the motion to table, and then we'll be voting on a number of carryovers very soon. So we'll do the tabling motion at this point. And we'll do this by a roll call vote. And so Soupy, thank you for joining us.
Very welcome. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone.
Yes.
Representative Cardone votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. Madam Chair, I have 12 members voting in the affirmative, 0 in the negative, and 2 members are absent.
Thank you very much. And so LD 861 is tabled with the expectation that we will carry it over. There is one of the proponents of the legislation in the attendee portion of the meeting with his hand raised, and I would like to give him an opportunity to address us briefly before we move on to our next piece of work. So I'm going to just ask him to join us. Thank you for joining us, Mr. Austin. What did you wish to speak with us about?
I just wanted to ask if you had given any consideration, since this is being delayed again, since its initial enactment date in June 20th of 2019, to suspending the law pending a resolution. We've been trying to have conversations with the administration since the enactment date on implementation, which was 2 years ago. So is suspension something you considered? We had no idea it was going to be tabled and carried over, which obviously is within your purview, but we didn't know that was coming. I would suggest you consider suspending the effective date again until we can have the conversations that we've been trying to have for 2 years.
Thank you for that suggestion. We appreciate you making it, and not able in a position to respond right now, but appreciate the suggestion. I'm going to send you back to the attendee portion of the meeting. Thank you for sharing your thoughts. Representative Harnett, go ahead.
Yeah, and we may have lost, thank you, Madam Chair. But I think we lost Mr. Austin, but I do want to put on the record that I share his concern. When this law was enacted in 2019, it was with a commitment to develop a telehealth system to allow these evaluations to take assessments to take place in a setting where those making the assessments were not putting their physical safety at risk. And here we are, and that was a compromise on a number of bills dealing with red flags, yellow flags. So I do just want to put on the record, I share the disappointment that we have not moved forward with a system to make this bill work.
Yeah, thank you very much, Representative Harnett. And I share that disappointment. I would very much like to find a way to make it work. It's a very complicated problem. Representative Cardone, go ahead.
I was on the committee when this bill was passed, and I share Representative Harnett's disappointment and frustration, especially since this bill was brought forth by the administration, by the governor's office, as an alternative to the red flag bills that were brought by members of the legislature. I am not pleased to learn that the governor's office has not been open to these conversations. My concern about staying this law is that, if I remember correctly, somebody introduced the figure of this law has been invoked 13 times since it was passed. Those 13 potentially dangerous people were in some way addressed by this law. And I would hate to have us suspend the law while and have a situation arise where someone is killed and injured if that could have been prevented by this law being in place. That was my only concern, given Mr. Austin's request for some sort of stay or suspension of the provisions of the law.
Thank you for sharing that. Not seeing any other hands up. Committee members will close the work session on LD 861. And again, I know that many of you in the attendee portion of the meeting have spent a long time today waiting for this work session and didn't anticipate that we would be tabling it. But we do appreciate your patience with us and your understanding, and hope that we're all able to continue to work on this issue in order to find a workable way forward. So we'll close the work session on 861. And at this point, the only bill left scheduled for a work session this morning is the errors bill. And Peggy, if you could share with us some observations about what would be an effective way to address the errors bill. And then I think it would be wise for us all to take a little lunch break and come back with a little bit of fuel in our bodies to dive into the rest of our work today.
Okay, so just real quick, errors bill is absolutely fabulous, best bill in the world. It is required by the revisor's office by a joint rule to print this bill, and it's supposed to be purely technical corrections, cross references, conflicts, and it's actually mentioned in the statutes as well. And you got a binder that Sam put together. Sam did all the work on it this year. Part of it was the bill from last year, which we worked on real quick and died because of COVID. But we don't need to walk you through every section, although that's like one of my favorite parts. But if you can take your binder and you take your chart and you look at your bill and you say, okay, that's what this is about. There are things that are conflicts. There are things that are cross references. Those are on your chart. They tell you why it's in the bill and how we're correcting it. A conflict is when two different public law chapters amend the same section of law differently, but you can read them together. So a lot of these are conflicts. And I don't know if you want Sam to address kind of the substance of them, but Sam and I were talking and we thought it would make a better use of your time if you could take some time between now and whenever we get together again on another day and see if you have any questions. And then when we sit down, we can zip through it and we can answer specific questions and not spend a lot of time on 80 sections of a bill.
Thank you. That's a great. Sam, did you want to add anything before we take some committee members' questions and comments?
I just wanted to say that I will be sending out an email with a couple updates on sections that may not be needed because of legislation that has been rolling in that addresses a couple of these sections. So I will send out an itemized email saying this section is likely unnecessary because of LD whatever. So I have 3 or 4 of those that I will send to the committee. So look out for that email.
Thank you. Representative Harnett, go ahead.
Thank you, Madam Chair, and thank you for what looks like an enormous amount of work, Sam. It's certainly an enormous amount of paper, and it gets its own binder. I just have a couple questions about the chart, and I'll just run through them real quickly. Some of the entries are in italics and shaded. Is that significant at all?
Those are ones that go together. So you will see that those are grouped together and they fall under the first number. So for that first group there that starts with A7, that group will be together under one summary because they're all part of the same issue.
Okay. And the second thing is, and maybe Peggy just mentioned this, but the category that, what does T mean?
Technical.
Technical?
Yeah.
Okay.
Technical. And our interpretation of technical means it doesn't change the effect of the law.
In layman's terms, so not a big deal? Or
Right.
Is that not a legal term?
It's not substantive.
It's not substantive.
Right.
Okay.
Substantive means it changes the law. If you didn't do it, something else would happen.
Okay. And the last question is under the amend question mark column. The answer to every single one is no, except one that says hold. And what's the significance of that when we're reviewing it?
So that's part of what Sam was talking about is although we didn't get information back from the other committees quite as soon as we would have hoped to put it in this chart, is that we ask you to hold it while we investigate whether or not it's necessary. If we don't think that it needs to be in the bill at all, we will tell you that. And if it's covered by another bill, we'll tell you that as well. So that's all.
And I'll update all of those in an email. I'll lay everything out that might need.
Okay.
And so Representative Cardone, did you have a question?
Yes. I realized I left my binder in my car. Was the, no, it's in the driveway, but was the chart that you're referring to in the binder? Okay. Yeah. All right. I wanted to make sure I got it, and so I assume it's there. If it is not there, Sam, I will email you and ask you to email it to me. And then the final question I have, Sam, and you can answer it another day, is on the very first entry in that notebook. I would like to know, since we are eliminating the apostrophe in Veterans Day and Indigenous Peoples Day, should we also be eliminating the apostrophe in Patriots Day? I am preparing a floor speech on the issue if we can't, if we comes out on a divided report, but you can let us know on that one.
I know that actually LD 286 is addressing, is going to take care of the issue that's raised in the heirs bill. I'll actually I'll check 286 and see if that's doing anything to the apostrophe in Patriots Day.
In Patriots Day.
So committee members, it seems like Representative Cardone needs some time to work on her floor speech. And Peggy has also suggested that we not take this up today, but that we each look through it on our own and then meet at a different time to go through it in a very efficient way. And so I'm proposing that we table this for now and take it up later. Representative Harnett?
I just wanted to confirm that Representative Cardone's speech would have an apostrophe. Would that be a correct use of the grammar there? Thank you.
Thank you. Any other grammatical questions before we move on? Is somebody prepared to table the work session on LD 17, to table 1730 until we take it up? Representative Cardone, is that your motion? And seconded by Representative Harnett. All those in favor?
Yes, move to table.
Yes. All those in favor of tabling, let's do this just by a show of our physical hands. Okay.
I have 12.
Yes, thank you. Okay, and so 1730 is tabled. We will find a doable time. I was going to say convenient, but I think doable is more appropriate time to take up the 1730. So with that, we're closing the work session on 1730. Oh, Ms. Panett, go ahead. No,
I just want a couple of minutes before you all go to lunch, please.
Okay. And so,
I do want to point out that we have freedom of access reviews scheduled for 1 o'clock, and I see people showing up for those.
right.
Just so you make sure that you tell them what we're doing.
I will, for sure. And so what I would like to do at this point is to hear from Ms. Panett and then take a half-hour break so that committee members can get some lunch, with apologies to those who are waiting for freedom of access reviews. We have been working hard since 9:30 this morning, and we simply all of us on the panel here need just a little bit of lunch. And so with that, Ms. Panett, I'll turn it over to you.
Representative Evangelos has his hand up.
Oh, okay. Go ahead, Representative Evangelos.
Thank you, Madam Chair. Just a quick question. I was late this morning, and do we still have language reviews left today?
Yes.
I wanted to make sure I didn't miss the 2 issues that were important.
Yeah, no, we were going to hold them for you. Yeah,
Okay.
but we didn't even get there yet.
Thanks. That's all I wanted to know.
Okay. All right, Ms. Panett, we're all yours.
Yes, and I'm only going to take 2 seconds, well, very, very brief. You've been working so hard, so a lot of amendments are now getting finalized. I'm doing the jackets, as many of you see. I've been going around trying to get votes. I would ask you, if possible, like next week, hopefully Monday, if possible, if you have a break before you go to session or in between, if you could come up to the committee room and sign jackets. Otherwise, I will be floating around the 3rd floor looking for everybody. So I just, we have a lot of jackets that need to be signed.
Is there an ideal window that we should stop by that we know you're going to be there in the committee room?
You know, what I can do is, in the past, whenever anybody missed a vote or something, I have a file cabinet that's right here beside my desk. It's under Seth, I think his name is, the portrait. I can leave all the jackets right there, and all you have to leave a pen, and I'll have a big sign, and all you have to do is, would that work if I do that?
I think so, because our schedules are all going to be a little different. Thank you. That's a great process.
The vote sheets are, I mean, not the vote sheets, excuse me, the jackets are paper clipped right to the committee file. So if there's any question you have on the file, feel free to go through the file. Try to keep it in the same order, but you know, whatever. I'll probably be in the room.
Okay, thank you.
I think that the Legislative Information Office has a table down on the 3rd floor that for jackets, for people to sign bill jackets. So it may be that you can leave all of those jackets there, and just have people, that way the Senate, the House gets a break. They just need to walk out to the table and sign the jackets. And I thought they were leaving emails for people if they had their name on a jacket that needed to be signed.
Representative Cardone, they're doing that for committee clerks who are no longer in their committee. They're either in the chamber being pages or doing other jobs. To be honest with you, I would be really reluctant to leave all my files down there. I have in the past had some disappear, and so.
Okay, all right.
I can certainly hang out down there if that works out for people. Thank you.
Okay, thank you very much. So committee members, are you okay with going to the judiciary room to sign the jackets at your convenience? I think that's a great process, because then we know they'll be there when we have those couple minutes.
And maybe I'll bake this weekend and there'll be some treats up here. So.
Oh, an added incentive. Thank you. Representative McCray?
Well, I was going to say even before baked goods that the advantage is we get to see Soupy in person.
Thank you. All right, committee members, so it's almost 10 past 1. I would like us all to have a half-hour break, and so let's resume at 1:40. And again, my apologies to those who are waiting. It's just been a very busy day. So see everybody at 1:40. Thank you.
Yep.
Yeah, nasty.
Hi, committee members. Good afternoon. If you are back at your desks, please activate your video so that we have a sense of who has returned. And I see that Senator Sanborn is back, and I know, Senator Sanborn, that you have a brewing scheduling conflict and wished to do the HCIFS freedom of access reviews first. And committee members, I just wanted to check in with you and see if that was acceptable to everyone to accommodate our colleagues' scheduling crunch.
Yep.
Okay, great.
And-
Thanks, everyone.
And I'm sorry, I just joined. What, are we taking things out of order?
We are going to take, so Senator Sanborn has an impending scheduling conflict.
Okay.
And she was hoping to take
673.
yes, and 1622 out of order. Is that okay with you?
It can be. Yep. Insulin and IRAs.
Yep.
Okay. Welcome all. Sorry I'm a little late. I just tried to go through 8 of the.
Representative, I just want to interrupt you. You can catch your breath. I was rushing us. You're not late.
Okay. We have a series of FOAA reviews. We've done a bunch of these during the session. You're going to see some common themes in these today. So I'm going to try to run through them quicker than usual. And fortunately, all of the committees that are appearing before us today have prepared wonderful explanations as to why they believe they meet the criteria for us to approve or recommend approval of the exception. And I am going to take them slightly out of order. And the first one I will be doing is LD 673, an act to create the Insulin Safety Net Program, brought to us from HCIFS. And I welcome our colleague, Senator Sanborn.
Thank you, Mr. Chair. This is a bill that requires that by January 1st, 2022, manufacturers of insulin would actually establish procedures to make insulin available to pharmacies for dispensing to eligible individuals who are in urgent need of insulin or who need access to an affordable insulin supply because of gaps in their coverage that makes their medicine unaffordable. The committee did vote 8-5 in favor of this bill as amended. The minority report would be a study to look at issues related to insulin affordability. There's a provision in LD 673 that protects the confidential any health information or records provided to the board if the information or records identify or permit the identification of an individual who is seeking access to the program. The provision further requires that any information is provided to if any information is provided to a manufacturer by an individual applying for the manufacturer's patient's assistance program, the manufacturer is prohibited from selling, sharing, or disseminating that information unless the individual has provided the manufacturer with a signed authorization. So there's two confidentiality provisions in the bill, and one relates to health information that the government would be collecting, and the other is a restriction on what the manufacturers could do with that information. It's narrowly tailored to cover personally identifiable health information, and we believe that this health information is appropriate to keep confidential, balancing the public interest in disclosure. Thank you.
Thank you very much, Senator Sanborn and committee members. I will run through our matrix that you should be familiar with by now. And the first two questions we ask are whether the record protected needs to be collected, and what is the value of the agency or official or the public in maintaining the record. And for that, we look to the conclusion of the Committee of Jurisdiction. And in this case, the only way to run this program, if it is established, is to collect this information. The next question we ask is whether federal law requires the record to be confidential, and in this case, HIPAA applies because we have personally identifying medical information and we need to be consistent with that federal statute. I then look to the various criteria to see if we meet one or more of the exceptions. And I turn first to paragraph D, which is whether the proposed exception protects an individual's privacy interest, and if so, whether that interest substantially outweighs the public interest in disclosure. And here we are dealing with personal, private, medical information. There is no reason for public disclosure, and there is all the reason in the world to protect that information. I would then turn to paragraph G, which is whether the public disclosure of this information could jeopardize the safety of a member of the public. And again, our own personal medical information is just that, our personal medical information, and release of that could interfere with our public safety. The last question I ask is whether the proposed exception is as narrowly tailored as possible. I answer that in the affirmative because the only thing we are keeping confidential is that personally identifiable medical information. And importantly, it does allow the reporting of the information in its aggregate form so that we can learn more about the insulin market and learn how to better protect people in Maine that use that product. So for those reasons, I would request that the committee recommend approval, or whatever it is we call it, Peggy, of this FOA exception. And do we need a motion to do that? Or do we just vote on the conclusion?
I think you usually do make a motion.
Okay, so I would entertain a motion to approve the exceptions contained, the confidentiality exception contained in LD 673.
So moved.
Senator Carney, motion made by Senator Carney. Do I have a second? Representative Sheehan. Motion made by Senator Carney, seconded by Senator Sheehan. Is there any discussion? Seeing none, I would ask the committee clerk to please call the roll.
Thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier. Representative Evangelos. Representative Newell.
Yes.
Representative Newell votes yes. I will recall the absentees. Senator Keim. Senator Keim is absent. Representative Cardone. Representative Cardone is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Representative Evangelos. Representative Evangelos is absent. Mr. Chair, I have 9 members voting in the affirmative, 0 in the negative, and 5 members are absent.
Thank you very much. And with that, I thank Senator Sanborn for bringing that forward. And we will move to our next review, which is a review of LD 1622, an act to promote individual retirement savings accounts through a public-private partnership. And I would note, I believe that this was maybe one of those bills that died in the 129th. It came before us and we approved it when it was LD 594. So Senator Sanborn, welcome. You may proceed.
Thank you, Representative Harnett. This is one of those occasions where I'm very glad to be able to do this review because I get to talk about a bill that we have been working on for 3 years in our committee that I'm extremely proud to say we voted 12-1 in favor of this bill as amended this year. It would establish the Maine Retirement Savings Board and authorizes the board to develop a voluntary program to offer individual defined contribution retirement accounts for persons employed in the state of Maine who do not otherwise have access to a 401k or other type of retirement plan through their employers, or who are self-employed. The implementation of the program will be phased in over time and eventually require all employers with more than 5 employees or more to automatically enroll their employees in this program unless they opt out or unless another retirement program is available to them. And there is a provision in LD 1622 that protects confidential information, individual account information for accounts under the program, including but not limited to names, residential addresses, email addresses, telephone numbers, personal identification information, amounts contributed, and earnings on the amounts contributed, except to the extent necessary to administer the program, the tax laws of this state, and the Internal Revenue Code, or unless the person who provides the information or is subject of the information expressly agrees in writing that the information may be disclosed. This is personal financial information, and we believe that it is appropriate on balance for that type of information to be maintained as confidential. And because of the nature of the public-private partnership contained within this bill, the government is going to have some information that normally they probably wouldn't have about you. So that's the reason we're before you today with this confidentiality records exception request. I'd be happy to answer questions.
Thank you very much, Senator Sanborn. And I did not give the opportunity at the last bill for the committee to answer questions. Are there any questions for our colleague, Senator Sanborn, before I proceed with our analysis? Seeing none, again, the first 2 questions are whether the record needs to be collected and what is the value to the agency. This is a bill designed to encourage retirement savings by people who might otherwise not have access to adequate savings upon retirement, and it absolutely advances a legitimate state goal. The other question is whether federal law requires the record to be confidential, and there's actually is a federal law, the Graham-Leach-Billy Act, which is also known as GLIBA, which puts requirements on financial institutions, including security firms that market things like IRAs, and when they enter into partnerships with state entities or other public entities, that information similarly needs to be kept confidential. So this will keep us and allow those firms to comply with federal law. With respect to paragraph D, when we're looking at the exceptions, whether the proposed exception protects an individual's personal privacy interest, and this is pretty much a no-brainer. It's personal information, including social security numbers, names, addresses, and sensitive financial information. And there is no interest in the public to have that information disclosed to them. I would then turn to paragraph G about whether public disclosure jeopardizes the safety of a member of the public. And again, I don't believe that any of us would want our personal financial records being available online or otherwise under the freedom of access laws to any persons that wanted to access them. The next question, the larger question, is whether the proposed exception is as narrowly tailored as possible. And again, the only thing that is made confidential is personally identifiable financial information. And for those reasons, I believe that it meets our review, and I would entertain a motion on the exception contained in LD 1622. Representative Moriarty.
Yes, I will so move, Mr. Chair.
Thank you. Motion made by Representative Moriarty. Do I have a second? Seconded by Representative Shi. Is there any discussion? Seeing none, I would ask the committee clerk to please call the roll.
Thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentee. Senator Keim. Senator Keim is absent. Representative Cardone. Representative Cardone is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Mr. Chair, I have 10 members voting in the affirmative, 0 in the negative, and 4 members are absent.
Thank you very much, Committee Clerk Ms. Panett, and thank you, committee members, for moving this forward, and thank you very much, Senator Sanborn, for bringing this review to our attention. Thank you. And with that, I will now return to the order that we had these reviews listed, and I will begin with LD 1484, an act to enhance the Connect Maine Authority's capacity to provide world-class internet. And I believe we will be joined by Representative Seth Berry, Chair of the EUT Committee. Is Representative Berry in the attendee room? Do we have a Senate Chair?
Let me see if I can reach out to him. Just a moment.
Okay, I notified him about 20 minutes ago we'd be bringing him up.
Just check in with him.
Okay. While we are waiting for him, I believe I see Senator Lucchini in the attendee room. If you could move Senator Lucchini over, he has 2 reviews. And we would begin with 1352, an act to regulate sports betting. Senator Lucchini, welcome to the Judiciary Committee. You can begin your presentation on LD 1352, dealing with sports betting, as soon as you're comfortable.
Great. Well, thank you. I think Representative McCreight and I will kind of tag team 1352, I guess, because I was on the minority report on that bill, actually.
Okay.
So I don't know, Representative McCreight, if you want to start out or, okay, and I can jump in with whatever. Yeah.
Sure. Thank you. Always nice that you're in the room. 1352 is an act to regulate sports betting. And it is a bill that was 7 members ought to pass as amended, 2 members ought to pass with a different amendment, and 1 member opposed. There are 3 issues within the bill that we're asking to have the review address. The first is criminal history information. Criminal history, like with any background check, is should be confidential, is the opinion of all the 2 ought to pass reports. When someone applies for a license for sports betting, they need to have a background check, and that's what that's about. The second part is child support registry information. When someone has winnings above the reportable amount, if they have an outstanding child support debt, the winnings go toward that. So this record of their child support debt is a confidential report, but is available so that those funds can be moved that way. And the third is about abnormal wagering activity. This allows the facility to be, if there appears to be abnormal wagering activity, patterns of wagers that give rise to concern about the integrity of a sports event, or any other conduct that corrupts a wagering outcome of the sports event, for purpose of financial gain, the director of the Gambling Control Board and the relevant sports governing body need that information so that they can intervene. So those are the three areas within that bill. And our analyst, Janet Stucco, is now in the room, and our amazing analysts are able to help if there are questions.
Thank you and welcome, Ms. Stucco, back to our committee. Is there anything you wanted to add to Representative Representative McCrate's presentation, or would you just want to entertain questions?
Happy to answer any questions you have, whatever makes sense. I did want to clarify there are actually 3 competing amendments, but they do all have all 3 provisions.
Okay, thank you. Are there questions from committee members for either Representative McCrate or perhaps more appropriately directed to Ms. Stucco? Seeing none, and I don't think I'm missing anybody, I will continue or begin with our analysis. As Representative McCrate pointed out, we're talking about 3 particular pieces of information, one being criminal history, and that is needed because the director of the Gambling Control Unit must have access to state and federal criminal history records regarding applicants who want to participate in sports wagering, and that those persons can be denied licenses based on that information. But some of that information is confidential already and should not be disclosed, and that's the reason for this exception. Representative Babich, I saw you had a hand up.
Yes, just a clarification for me. What we are protecting is the public's right to know. And obviously in this bill, it is wise that the Gambling Control Board have this information and so forth. Are we shielding the public from knowledge about abnormal wagering activity that may be confronting the industry that is sanctioned by the state through licensing, or are we protecting the public or forbidding the public to know a person's background that receives a license that is any different from any other industry? I'm trying to understand the substance of the bill is not what we're to debate here, but I'm trying to decide if what we are protecting as far as public access is consistent with what is normal practice.
Representative, I'll get to the abnormal wagering activity aspect later, but with respect to criminal history, and I'm happy for anybody else who wants to jump in here, it doesn't make confidential anything that is already publicly available criminal history information. But I gather your concern is what if they ignore criminal history and provide a license to somebody who you believe they should not? Does that interfere with the public's right to know?
Well, I would be concerned if we, by this action, were prohibiting the public from knowing about a criminal history if in fact they otherwise would when a license is renewed or whatever. I guess what I'm asking is how active is our action here, or is it within normal procedure in this kind of thing? Thank you.
The information is limited to persons who have been convicted of a crime of moral turpitude, a gambling-related offense, or a theft or fraud offense, or have otherwise demonstrated, either by police record or other satisfactory evidence, a lack of respect for law and order. But I don't know if Ms. Stucco, do you have a response to Representative Babbage's concern?
Well, I don't know if it addresses his concern, but just for clarity, because the concern is obviously up to you all to decide how serious it is. But I would point out that part of the reason for the confidentiality provision is there is a fingerprint-based background check that's included. And in order to get that information from the FBI, you have to assure the FBI that it will not be redisseminated. So once it's in the hands of the director of the Gambling Control Unit, it has to stay confidential. But as Representative Harnett said a little bit earlier, you will have the name of the licensee and the applicants if you're in the public, and then you could then check on your own, and all of the information that you can have publicly will remain public. You just can't get the information directly from the director because he will have, it's a he now, that's the only reason I said he, because Director Champion will have information that includes this fingerprint-based FBI information that is not allowed to be disclosed, or else the FBI will stop sharing it with us.
Thank you very much, Ms. Stucco. I recall that now, and it's really the process that we're protecting here. So thank you very much for that. That helps me, Mr. Chairman. Appreciate it.
Okay, thank you. And again, we're talking about 3 different types of information: criminal history information, child support registry information, and abnormal wagering activity information. So obviously they need to maintain this information. The next question we ask is whether federal law requires the record to be confidential. And as Ms. Stucco just pointed out, with respect to criminal information as interpreted by the FBI's Public Law 92-544, the FBI may not share fingerprint-based national criminal history information if dissemination is made outside the receiving department or related agencies. So 1, we would be violating federal law, and 2, we would no longer have access to needed information. With respect to the child support registry information, there is no federal law regulating that, but it's information that needs to be collected by the authority so that they can make sure that those that owe debt to child support, that their winnings are attached or forwarded to the appropriate department to make those funds be dispersed. With respect to abnormal wagering activity information, I believe it's important for the authority to be able to have the investigative function to study that material so that they can determine whether or not there is something abnormal going on. As you mentioned, words like fixing or the changing of odds. I imagine that that's the purpose of that. So it's required by federal law. And then we look for exceptions, whether the proposed exception protects an individual's privacy interest. Certainly with respect to the child support registry information, there's a lot of personally identifiable information in there that is not available to the public, nor should it be made available to the public simply because it's placed in the hands of another state agency. And so we've met that. And then whether the proposed exception is as narrowly tailored as, I'm sorry, also with respect to public safety, if we release the information regarding abnormal wagering activity as it's being investigated, that could jeopardize the public safety because it would not result in a complete investigation of that alleged abnormal activity. And whether the proposed exception is as narrowly tailored as possible. Again, all publicly available information remains public. All that this does is make confidential that information required to be confidential under federal law, or information that would have personally identifiable information of those on the child support registry. And lastly, it could compromise, it's tailored with respect to abnormal wagering activity to protect the investigative responsibilities of the gambling control unit. So for those reasons, I believe that LD 1352 and the exceptions contained therein to the Freedom of Access Act meet the matrix that we are to use when analyzing those exceptions. And with that, I would entertain a motion. And I see a hand up from Representative Evangelos. I don't know if that's to make a motion or with a question. Representative Evangelos.
My mic was off, sorry. That is in agreement with your report to make a motion to accept your report.
Thank you. We have a motion to accept the report from Representative Evangelos. Do I have a second? Seconded by Senator Carney. Is there any discussion? Seeing none, I would ask our committee clerk, Soupy, to please call the roll.
Thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kine. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Kime. Senator Kime is absent. Representative Cardone. Representative Cardone is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Mr. Chair, I have 9 members voting in the affirmative, 0 members voting in the negative, and 5 members are absent.
Thank you very much, Ms. Panett. And with that, I thank the committee for moving this forward and thank the representatives of BLA for bringing this to our attention. And we'll now turn it back to Senator Lucchini on LD 1363, an act to amend laws governing elections. Senator Lucchini.
Thank you, Mr. Chair. And I apologize in advance if I'm breaking up because my internet is apparently unstable at the moment. LD 1363 is a bill, department bill that was submitted by the Secretary of State. And it covers a broad range of election issues and kind of relevant to the discussion today. We create a statute by which a voter who casts an absentee ballot can cure a defect that's discovered by the clerks, municipal clerks on the return envelope. And the goal is to make sure that the absentee ballot is not rejected, but that the person's vote can count. So in this bill, the initial process that we create here is that when a voter requests an absentee, we ask them to provide a phone number and email address. And that is what we're looking to maintain confidentiality of. We certainly don't want voters to think that if they're giving their phone number or email that it's going to be widely available to people. So after a voter returns the absentee ballot, the municipal clerk must examine each ballot to look for one of several defects, which could be a discrepancy in signature of the voter. The return envelope could be missing a required signature, or the affidavit or witness certification on the return envelope isn't properly completed. So this bill requires that if the voter submits their email and phone number, that the clerk within a business day has to reach out to them to notify them so that they have the opportunity to cure the defect to ensure that their vote is counted. And that's the information that we're looking to keep confidential.
And thank you. And I think it's pretty clear, but just to confirm it, the only information that you are asking to not be subject to the Freedom of Access Act is the telephone number and the email address of the person requesting the absentee ballot. Correct?
Yes. Yep. Correct.
Are there questions from committee members for Senator Lucchini or the analyst, Ms. Stocco? And am I saying your name correctly, Ms. Stocco? Is it?
That's fine. It's Stocco, but I don't mind either way.
It's not fine to mispronounce, so it'll be Stocco from now on. Are there questions from committee members? Seeing none, I will proceed with our analysis. Again, beginning with, is there a need for the agency to collect this being the Secretary of State in this situation? And clearly it is the conclusion of the Committee of Jurisdiction that this information is necessary to, one, encourage people to participate in the election process, but also to maintain confidentiality of certain information that would otherwise not be available to the public. And it's also essential for the municipal clerks to perform their duties regarding the new process for curing any defects on an absentee ballot. There is no federal law that is implicated here. So we then turn to the exceptions that we need to find that the request for confidentiality meets. And I would focus on whether the proposed exception protects an individual's privacy interest, and if so, whether that interest substantially outweighs the public interest in disclosure. And again, here, the only thing that is being maintained as confidential is a telephone number, which might actually be available in a phone book or elsewhere, but we do not know that, particularly when it comes to cell phone numbers, and an email address. And the concern of the committee was that in the absence of this exception, a voter who does not wish to have that information provided might not participate as an absentee voter, and that might actually discourage voting. And there is no interference with the public's right, because as a general rule, the voter's absentee ballot application is a public record until the close on election day. All it does is delete that personally identifying information. Whether the public disclosure jeopardizes the safety of a member of the public really does not apply here. And so I would turn to whether the proposed exception is as narrowly tailored as possible. And again, as you have heard from Senator Lucchini and in my analysis, the only things being kept confidential are a phone number and an email address. So I would say that it is a very narrowly tailored exception. And unless there are questions from committee members, I would entertain a motion. Senator Carney.
So moved.
Thank you. Motion made by Senator Carney. Do I have a second? Seconded by Representative Babbage. Is there any discussion? Seeing none, I would ask Ms. Panett to please call the roll.
Thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Kime. Senator Kime is absent. Representative Cardone. Representative Cardone is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Mr. Chair, I have 9 members voting in the affirmative, 0 in the negative, and 5 members are absent.
Thank you very much, Supi, and thank you for committee members for moving this forward. And thank you to Senator Lucchini, Representative McCreight, and your capable analyst for presenting these bills to us today. Take care.
Thank you. Thanks.
And I see that Representative Berry has magically moved from the attendee room right to the middle of my screen. And we have 2 bills from EUT. We will begin with LD 1484, an act to enhance the Connect Maine Authority's capacity to provide world-class internet. What a wonderful bill title. Representative Berry, welcome to Judiciary. And if you could begin your analysis or presentation whenever you're comfortable.
Thank you very much, Representative Harnett, Senator Carney, members of the committee. It's great to be with you. My committee is meeting, so I apologize for jumping back and forth earlier. I appreciate your squeezing us in here. The Joint Standing Committee on Energy, Utilities, and Technology is requesting your review of a portion of the majority report on LD 1484. You've heard the title already. Senator Rick Bennett is the sponsor, and I'm very pleased to be here to speak to it as the lead co-sponsor of legislation. The original bill and a draft amendment has been provided to you, and I believe you have it in your possession at this time. We developed the bill in consultation with the Department of Economic and Community Development, as well as other representatives. The majority report sets forth connectivity goals and establishes the main connectivity authority, or MCA, to further those goals through the development and financing of connectivity projects and through other activities. And for the purposes of your review, the amendment would allow the main connectivity authority, the MCA, on its own or upon request to keep specific information about communication service providers and wireless providers that own or operate advanced communications technology infrastructure in the state confidential if making that information public would compromise the security of public utility systems to the detriment of the public interest, or if the information is of a competitive or proprietary nature. It only allows the MCA to designate this information as confidential to the minimum extent necessary to protect the public interest or the legitimate competitive or proprietary interest of the communication service provider or wireless provider. And it also requires the MCA to adopt rules regarding the designation of confidential information before actually designating any information as confidential. This is substantially similar, by the way, to language already applicable to the Connect Main Authority, which I'm sure you're all familiar with, and we did provide you that current law as well. Just briefly reviewing the statutory criteria that you all need to apply, we just want to comment that regarding the need to collect the information, it really is necessary to collect information for the MCA to collect information in order to evaluate current deployment of advanced communications technology infrastructure, revenues, costs, subscribership of such providers, because that is all implicated in their work regarding the availability and affordability of that technology. The collection and maintenance of the information also allows the MCA to determine its future actions regarding the deployment of funding in order to accomplish its mission, furthering the state connectivity goals, evaluating grant requests, and other project financing. Maintaining the information, Part B of your statute for today's purposes, is important because it allows the MCA to determine actions to be taken, including the deployment of funding, again, to further the state's connectivity goals. We're unaware of federal law that would require this information to be confidential. I'll skip down to E, which I think answers D. Public disclosure of the information may place the submitter at a competitive disadvantage and does not appear to serve a significant public interest. Regarding public negotiations, we are unaware of any connection. Regarding balancing the public interest and potential jeopardy to public safety, this is a real issue. Some of this information could be of a nature that, if disclosed, could compromise the security of public utility systems. So I can't emphasize that enough. For example, precise infrastructure location information, if public, could make the network susceptible to intentional illegal interference with a communication service, and even potentially affect critical emergency communication services such as 911. The exception, we believe, is sufficiently narrow. It only applies to certain information as outlined earlier, and only the information that we feel is necessary for that critical security and competitive or proprietary interest. Thank you for reviewing this exception, and I'm happy to answer any questions.
Thank you very much, Representative Berry, for that presentation, and I invite you to take my seat and do all of these analyses under the matrix. I'm not going to have a lot to add here, and I greatly appreciate that. Are there questions from committee members for Representative Berry? Seeing none, thank you for your presentation. And actually, in the interest of time, because Representative Berry ran through our matrix in its entirety, the only thing that I would like to add beyond my thanks for that presentation is that I would call the committee's attention to page 18 of your packet, which sets out the confidentiality being established here in great detail. And I was particularly pleased to see the requirement of rulemaking. So you can't act on this until you promulgate, till the agency promulgates rules as to what will be confidential and what will not be confidential. And I was also struck by, certainly you've met A and B, which is why we need this information. And I focused in terms of the exception on paragraph G, which is whether public disclosure jeopardizes the safety of a member of the public, and you mentioned location of utilities, possible interference with 911 performance. Obviously, those are public safety measures that we need to keep intact. So with that and without further discussion, I would ask, one, if there are any questions from committee members for Representative Berry, and seeing none, I would entertain a motion. Representative Evangelos, move to approve the review on LD 1484. And do I have a second? Representative Babbage. A motion by Representative Evangelos and a second by Representative Babbage. Is there any discussion on the motion? Seeing none, we will go to our next step. Ms. Burnett, if you could please call the roll.
I would be happy to, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I will recall the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Kime. Senator Kime is absent. Representative Cardone. Representative Cardone is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Representative Newell. Representative Newell is absent. Mr. Chair, I have 8 members voting in the affirmative, 0 in the negative, and 6 members are absent.
Thank you very much, Ms. Burnett, and thank you, committee members, for moving this forward. And thank you, Representative Berry. And we will turn again to Representative Berry to discuss LD 1708, an act to create the Pine Tree Power Company, a nonprofit utility to deliver lower rates, reliability, and local control for Maine energy independence, brought to us by the EUT committee. Welcome back, Representative Berry. And if you do as thorough a job on this one, you're going to put me out of a job, and that would be okay. But you may proceed when you're comfortable.
Thank you very much, Mr. Chair. And I think I'll just leave the matrix to you in the future, because the last thing I need is another chairmanship.
Okay.
And I think you do a much better job than I ever would. So LD 1708, an act to create the Pine Tree Power Company. I'll just read the short title. I think the sponsor, the amendment, committee amendment to 10-3 report was just provided to you perhaps this morning. At least I hope it was. But if you have an earlier draft, these relevant provisions are not changed from the original bill. So the original bill should do fine for this as well. The majority report would create the Pine Tree Power Company, which would be a privately operated, nonprofit, consumer-owned utility controlled by an elected board. The company's purposes are delineated. They are to provide for its customer owners in the state reliable, affordable electric transmission and distribution services, to help the state meet its climate, energy, and connectivity goals in the most rapid and affordable way possible. And the PUC, the Public Utilities Commission, is directed under the bill by January 1st, 2024, to find an existing transmission and distribution utility in the state unfit to serve and direct the sale of that utility if within the previous 5 years, the utility has been found to come in below certain standards. Currently, that fitness to serve test is not, it exists in law, but there's no specificity. So the specificity for the test is if it has been rated the lowest for customer satisfaction within the previous 5 years more than once, has reported reliability in the lowest decile of utilities of a similar size in the country more than once, or has charged its customers residential delivery rates in the highest decile among utilities of a similar size in the country more than once, and has to be 2 of those 3. Under the bill, the company would purchase the facilities of an investor-owned utility in the state, either of the 2 investor-owned utilities of the state, in sequence, financing the purchases through the issuance of debt against the company's future revenues. The board would contract with a non-governmental team, a private sector operations company, to operate the facilities acquired by purchase from the investor-owned utilities. And with that brief outline, I'll dive into the sort of more relevant provisions. The new section of law, Title 35A, Section 4008, on pages 9 and 10 of the bill, would designate as confidential certain records of the company. Firstly, a record obtained or developed by the company that a person, including the company to whom the record belongs or pertains, has requested be designated confidential, and that the company has determined contains information that gives the owner or user an opportunity to obtain a business or competitive advantage over another person who does not have access to the information except through the company's records, or access which by others would result in a business or competitive disadvantage, loss of business, or other significant detriment to any person to whom the record belongs or pertains. That's a bit long-winded, but I think it's important to really think that through. We're talking about millions of dollars changing hands through privately contracted, in many cases, multiple privately contracted businesses involved in the operations of this utility. And so competitive business and competitive advantage is a significant consideration. Similarly, exempted would be a record that contains usage or other non-public information regarding a customer of a utility. Additionally, the bill prohibits a board member, employee agent, other representative of the company from knowingly divulging or disclosing such record designated as confidential, except in a number of specific circumstances. And I'll leave you to read those for yourself. Again, this is pages 9 and 10 of the bill. Obviously, utility records are sensitive for much the same reason that was discussed in the previous bill, LD 1484, the security of our grid, the ability of our grid to protect sensitive customer information, the proprietary and confidential information of businesses contracting with the operations company. All of these are very important considerations. And so we hope that you will find it appropriate to enact these appropriately narrow, we think, exemptions. FOA. So with that, I'll save the matrix for the good chair, and I'm happy to answer any questions.
Thank you very much, Representative Berry. And for members of the committee, the confidentiality provisions outlined by Representative Berry are on page 27 and 28 of the packets that you all received. Are there questions from committee members? Representative Babbage. You're muted.
Sorry about that. Thank you very much, Mr.
Representative Babbage.
Rather than me look it up, Representative Berry, can you just help me with, this is no new barrier to records that are available now. Is that right? In other words, our collective usage data, is that available, or, you know, for public knowledge that could be used by state entities regarding our decision making in the future? I guess that's the end of my question. Thank you. I'm talking about collective data versus individual usage data. Yeah.
No, it is an excellent question, and one that could only come from a former member of my committee, as I know Representative Babbage is, and that is an issue. The importance of collective disaggregated data is hard to overstate. It's important for efficiency purposes. If you're trying to find more efficiencies in the grid, it's sometimes important, for example, for municipalities that are trying to find more opportunities to help businesses, commercial enterprises, nonprofits to find more efficiency, locate potential opportunities for that, as well as for the appropriate siting of generation close to load. So there are many, many reasons why disaggregated data is very, very important to the public interest. And generally speaking, that can be made available through the Public Utilities Commission. And they do have very broad discovery rights and abilities and responsibilities there. That would continue to exist. The PUC oversees both the new company and also the operations company, which contracts with it. So we would continue to essentially have the same degree of data availability that we have now. Frankly, for my own purposes, we need more data to become available. And I think our current utilities sometimes shield a little bit more, claiming it to be confidential than we would like. But you know, I would say that this certainly will not create less transparency than we have now. And if anything, by removing that profit motive of the owner of the grid, it should provide for greater aggregated data transparency than we have currently.
I appreciate that answer. Thank you. Thank you, Mr. Chair.
Thank you, Representative Babbage, and thank you for your response, Representative Berry. And I will quickly go through our matrix because, again, Representative Berry did a wonderful job. With respect to paragraphs A and B, whether the record protected needs to be collected and whether it has value to the agency, we always look to the conclusion of the Committee of Jurisdiction, and it's well stated in their written submission to us as well as in the oral presentation that we just heard. And I will then look to, does the proposed exception meet one or more of the following? And I'm going to add one that Representative Berry did not discuss, and that's paragraph D, which is whether the proposed exception protects an individual's privacy interest, and if so, whether that interest substantially outweighs the public interest. And I believe that's implicated here as well, because as Representative Berry said, this could affect information of consumers, both commercial and perhaps individual. And those are things that we have always protected from public disclosure. But the two main ones are paragraphs E and paragraph G. Paragraph E is whether or not public disclosure puts a business at a competitive disadvantage. And that's what this exception is designed to avoid. Any information that is deemed proprietary, which could substantially interfere with one's competition with others. And then G, which is whether public disclosure jeopardizes the safety of a member of the public or the public in general, and whether that safety interest substantially outweighs the public interest in disclosure. And with respect to sensitive information regarding locations, how grids work, where they might be vulnerable, clearly if that information were made public, it could jeopardize not just the provision of service, but the safety of members of the public that rely on that service. And I do believe that the exception is as narrowly tailored as possible because it is limited to those three areas: personal privacy, competitive disadvantage, and public safety. And for those reasons, and for all that was stated by Representative Berry, I would request a motion to approve the review of this exception. And I would turn to Representative Moriarty to make that motion. You're muted, Steve.
Yep, sorry. Thank you, Mr. Chair. I move that we approve the application for freedom of access review.
Thank you. I have a motion from Representative Moriarty. And is that a second, Representative Evangelos?
Yes, it is.
Thank you. We have a motion from Representative Moriarty, seconded by Representative Evangelos. Is there any discussion amongst committee members? Seeing none, I would Representative Berry.
Thank you very much, Mr. Chair. And just briefly, I'd love for the committee to be aware as well that there will be significantly more transparency going forward with respect to the management of this utility. Our current utility board meetings are not subject to freedom of access, and they're not open to the public. And at the board or management level, this will allow for that additional public access and transparency. So I probably should have mentioned that at the top. Just wanted to make sure you're aware. And thank you very much.
Thank you, Representative Berry. Is there any discussion from committee members? Seeing none, I would ask the committee clerk to please call the roll.
Thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I will recall the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Kime. Senator Kime is absent. Representative Cardone. Representative Cardone is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Representative Newell. Representative Newell is absent. Mr. Chair, I have 8 members voting in the affirmative, 0 in the negative, and 6 members are absent.
Thank you very much, Soupy. Thank you, committee members, for moving this forward, and thank you, Representative Berry, for your presentation on both of your bills today.
Thank you. Good to be with you.
Okay, we have 2 more to go. And unfortunately, unless Mr. Tartikoff is here to talk about one of them, I don't see anybody on the next 2. Mr. Tartikoff, are you here on behalf of someone on 1541 or 1467?
I believe ENR committee member Senator Carney will be representing the committee.
Oh, okay. I should have known that. The Senate lead, Representative Carney, we will turn to LD 1541, an act to support and improve municipal recycling programs and save taxpayer money. You guys have much better titles than we get here. But welcome, colleague and co-chair. Please begin your presentation when you're set.
Thank you very much. Actually, I would like to turn the presentation over to the OPLA analyst, Dan Tartikoff, to present. Is that fine with you, Dan?
Sure.
Thank
So we have come here before this session to discuss a similar confidentiality proposal as part of a drug take-back stewardship program. This is a different kind of stewardship program. LD 1541 establishes a stewardship program in the state for packaging material. Under the program, producers of products that are sold, offered for sale, or distributed in the state that are contained, protected, delivered, presented, or distributed in or using packaging material are required to annually report to a stewardship organization that's contracted by the Department of Environmental Protection to operate a packaging stewardship program in Maine. They're required to report regarding the total amount of each type of packaging material that they sold, offered for sale, or distributed in the state during the prior calendar year. And then based on methods that are going to be adopted by the department by rule, those producers would be required to annually pay to the stewardship organization a fee associated with the amount of packaging material that they sold or distributed in the state. And the payment would be differentiated based on a number of factors and adjustments, including whether the packaging material is considered readily recyclable in the state. The stewardship organization is then directed to use those producer payments to reimburse what are called participating municipalities for certain incurred municipal costs associated with the management of packaging material. As part of the stewardship program, certain producer information submitted must in turn be submitted to the department. The law requires, the law authorizes so-called alternative collection programs, which may be implemented by a producer or a group of producers to manage a certain type of packaging material, and that those programs may require submission of certain producer information to the department. So some of that information, whether submitted to the stewardship organization by a producer and then to the department, or to the department directly by the producers who have implemented an alternative collection program, may constitute proprietary information. Section 1 of the bill in new section 2146 subsection 15 provides that proprietary information submitted to the department that is identified by the submitter as proprietary information is confidential, must be handled by the department in the same manner as confidential information is handled under section 1310B of Title 38. And I believe we went over this when we went over LD 8, but 1310B in Title 38 is the general provision in Title 38 regarding how the Department of Environmental Protection is to handle confidential material that is submitted to it and maintained by the department. Generally speaking, the submitter of the material is required to designate information that they submit as confidential, and if it's so designated, it has to be segregated from other public records of the department. And the department doesn't really do anything but make a note of that. And then if an entity submits a public records request to the department for any information that has been designated as confidential, then the department notifies the submitter of that information, and the submitter has to demonstrate to the department's satisfaction that the information is proprietary and confidential and should not be disclosed. And then the department makes a determination about whether or not the information is in fact protected from disclosure. I've noted here, as I've noted before, that this same language and definition of proprietary information is extremely similar or identical to a myriad of other confidentiality provisions in Title 38, all of which refer back to that section 1310B process for handling of confidential records by the department. I'm happy to answer any questions you have, and like Representative Berry, I will not go through that matrix for you.
Darn. Thank you very much, Mr. Tartikoff. And I do have one question. It sounds, this is quite familiar since we did discuss this on another bill, but the confidentiality process here is really a two-step process. The submitter initially designates the information they believe to be proprietary and therefore confidential. But then when and if and when it is requested, they need to establish to the satisfaction of the department that it actually satisfies, that it meets the definition contained in the statute. Is that correct?
That is my understanding, and I know the DEP receives a large amount of information submitted to it under a variety of programs and for a variety of reasons. And so I think they have a fairly robust process for handling public records and public records requests. So I understand it's a little bit of a unique process compared to how public records and confidentiality are handled in other agencies or under other statutes, but that is the way it's been set out for a number of years. And I think it was a process that was ultimately developed with input from a predecessor to this committee. But that is largely how it will work. There is a two-step process.
Thank you very much, Mr. Tartikoff. Are there questions from committee members for Mr. Tartikoff or my co-chair, Senator Carney? Seeing none, I will quickly run through our matrix, beginning with, is there a need to collect the information and is there value in maintaining that information? As you've heard, this is a stewardship program that is designed to improve recycling, and without this information and cooperation of those producing this waste, the program is simply not going to work or be maintained, and that is the conclusion of the Committee of Jurisdiction. There are no federal laws implicated here, so I turn to, does the proposed exception meet one or more of the following? And I will focus on only one here, and that is paragraph E, which is whether public disclosure puts a business at a competitive disadvantage, and if so, whether that business's interest substantially outweighs the public interest in the disclosure of the records. And here, as Mr. Tartikoff explained, the only thing that is being protected here is proprietary information, the release of which could place one at a competitive disadvantage. So I believe that paragraph has been satisfied, and I would turn to whether the proposed exception is as narrowly tailored as possible, and it only relates to information that is not otherwise publicly available. And I believe that it is narrowly tailored as possible because of what I described as that two-step process. It is not simply the submitter of the information saying this is confidential and proprietary, that's the end of the story. That in fact, there's a second step. If there's a request for that information, the department then turns to the person or entity that submitted that information, and they need to establish that they meet the statutory criteria that allows the records to be maintained as confidential. So for those reasons, and based on the information provided by Mr. Tartikoff, I would be happy to answer any questions, or even happier to entertain a motion. Senator Carney. Senator Carney moves approval of the review of the.
Thank you. I was just unmuting. I move approval of the Freedom of Access review.
Thank you very much, Co-Chair Carney. Do I have a second? Seconded by Representative Sheehan. Thank you, Representative Sheehan. Are there any committee members who want to discuss the motion? Seeing none, I would again, well, you appeared just magically at the right time, Supi. If you could please call the roll on the FOAA review of LD 1541.
Thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Representative Cardone. Representative Cardone is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Representative Newell. Representative Newell is absent. Mr. Chair, I have 8 members voting in the affirmative, 0 in the negative, and 6 members are absent.
Thank you very much, Supi, and thank you to the committee members for moving this forward. And thank you, Mr. Tartikoff, but don't go too far because we're now up to our 8th and final FOA review of the day. And that is regarding LD 1467, an act to promote a circular economy through increased post-consumer recycled plastic content in plastic beverage containers. And I would call upon Senator Carney to say if she has comments to make, or do you want me to just turn it over to Mr. Tartikoff?
I just have one comment, which is I very much appreciate Mr. Tartikoff taking us through the analysis. Thank you very much, Dan.
He has been wonderful. Thank you and welcome back, Mr. Tartikoff. If you could educate us about LD 1467, that would be great.
Sure. I'm particularly excited to bring this one to you because in 8 sessions of staffing ENR, this is the first ENR bill I'm bringing that's not a product stewardship program, but sadly it's still proprietary information. So LD 1467, as amended, establishes a new post-consumer recycled plastic content requirement for plastic beverage containers sold, offered for sale, or distributed for sale in Maine. Under the proposal, the requirement must be met by an initiator of deposit under the state's container redemption law for plastic beverage containers that contain a beverage other than spirits, and by spirits manufacturers for any plastic beverage containers that contain spirit. Beginning January 1st, 2026, the initiator of deposit or spirits manufacturer may not sell plastic beverage containers in the state unless the total number of beverage containers that they sell contained on average and in the aggregate at least 25% post-consumer recycled plastic. Beginning January 1st, 2031, the requirement increases to at least 30% post-consumer recycled plastic. If you glance through the bill as amended, you would see that that's a pretty simple concept, but the application of it got very complex. So I'm only going to touch on one part of that, which is that if that initiator or spirits manufacturer is unable to meet the post-consumer recycled plastic content requirement, it must instead pay a fee based on the amount of virgin plastic used in its beverage containers that would have been required to be post-consumer recycled plastic in order to meet the requirement. Initiators and spirits manufacturers are required to annually report to the Department of Environmental Protection a variety of information regarding Maine-based sales data, market share data, plastic content of its beverage containers, and amounts and weight of both post-consumer and virgin plastic it's sold in. The department's authorized to conduct audits to verify that reported information, and every 5 years is required to facilitate a third-party verification of that reported information. The information that we're talking about that's used by the department to determine compliance with the post-consumer recycled plastic content requirements may contain certain proprietary information. The bill in section 1 in new 1612-4D describes the same confidentiality exception that I went over in the prior bill, using the same definition of proprietary information and to be handled in the same manner under that Title 38, Section 1310-B process. I'll leave it there, and if there's any questions specific to this bill, I'd be happy to answer them. But like I mentioned, the context is completely different, but the process is exactly the same, and we're talking about the exact same type of information or category of information.
It appears that Representative Harnett may be frozen out of his computer access. So let me just take us through the analysis. It'll just take me one moment, friends. Okay, so I'm toggling screens and having a hard time seeing people, but I'm just going to take us through the factors of the analysis. And we'll start with the first criteria, which is the need to collect the information. Under the proposal, an initiator of deposits or spirits manufacturers required to submit the information to the department. That could include proprietary information. The second factor is the value in maintaining the information and maintenance of the information received by the department from initiators of deposit or spirits is important in determining whether an initiator or spirits manufacturer meets or is operating in compliance with the content required by law. There is no federal information. Is Representative Harnett back yet? No. Okay. Don't want to steal his thunder here. There is no federal law that applies. The balancing of the effect of disclosure on business competition against public interest shows that public disclosure of this proprietary information may place the submitter in a competitive disadvantage that does not appear to serve a significant public interest. There is no connection between this information and negotiations involving a public body, so that factor is not relevant, nor is the factor related to balancing public interest and jeopardy of public safety. And then finally, the narrowness of the exception weighs in favor of approving this review because the exception only applies to certain information submitted by an initiator, which is designated as confidential and is not otherwise publicly available. And the disclosure would impair the competitive position of the submitter. And so in light of those criteria, welcome back, Representative Harnett.
Thank you for stepping into the breach.
Would you like to take over or would you like me to finish up?
Oh, I can take it back. Thanks.
Okay.
You ran through the analysis and
Yes.
I appreciate that. With that, I would entertain unless there are questions from committee members, I would entertain a motion on LD 1467 and its exception to the Freedom of Access Act. Motion made by Representative Moriarty. Is that correct?
Yes, I move that we approve the application for freedom of access review.
Thank you very much, Representative, and seconded by Representative Evangelos. Is that correct, or is that a question, Jeff? That's correct. Thank you very much. We have a motion from Representative Moriarty, seconded by Representative Evangelos. I would ask our committee clerk to please call the roll.
Thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Representative Cardone. Representative Cardone is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Representative Newell. Representative Newell is absent. Mr. Chair, I have 8 members voting in the affirmative, 0 in the negative, and 6 members are absent.
Thank you very much, Supi. Appreciate that for us. And with that, thank you again to committee members, and thank you, Mr. Tartikoff, for your presentation on both bills. And I recognize Senator Carney.
I just wanted to say an extra special thanks to Mr. Tartikoff. Thank you.
Thank you, sir. And with that, I will turn the gavel back over to my co-chair, Senator Carney.
Thank you very much, Co-Chair Harnett, and thank you so much for your excellent work on the Freedom of Access reviews. At this point, we have a number of language reviews that we're going to take up, and I think we're going to take them out of order a little bit. Again, we're juggling a lot of different schedules, and Peggy, I hope that this order works for you. I'd like to start with 1416. And this is the qualified immunity, essentially study resolve. We've changed the bill into a study resolve.
And that's the one that Sam's been working on. So he'll work with you through that. And just a reminder, we put these study groups together as kind of a starting place for you, and then you can make whatever changes you need.
And Sam, would you like to screen share? I think that helps us work through pretty efficiently.
Okay. So I have this is majority draft amendment for 1416. So if you'll recall, this is the bill that the committee asked me to put together a draft study on. It is kind of the usual type of study structure you would typically see. So there's establishing the task force to study the use of qualified immunity by Maine law enforcement. That's just a working title, so that can be anything you want it to be. Membership. I did want to go through the membership because I use kind of my best judgment. I did just as a just to start off, I got some feedback from a couple different folks that there should be a member of municipal law enforcement or somebody representing municipal law enforcement officers included, which I neglected to include. So just wanted to state that at the outset. That wasn't intentional, just an oversight. So I did include 2 members of the Senate, 2 members of the House from both of the parties holding the largest number of seats. That's just standard language, but that could be different too if the committee desires that to be different. 2 members with lived experience with use of force by law enforcement officers, and this was an attempt to include people who had experienced use of force by law enforcement officers. I think lived experience is the term that is typically used for citizens. Member of an organization advocating for civil liberties. A member of an organization representing the interests of state troopers. A representative of an organization representing the interests of sheriffs. That should be representative of an organization representing prosecutors, and a representative of an organization representing criminal defense attorneys. And then if the committee likes, they could add a representative of an organization representing municipal police officers as that. The chair would be the Senate member, appointed by the President of the Senate. The typical appointment language and convening language, that's kind of the usual boilerplate language. So duties, I have here the duties that the task force shall study the use of qualified immunity as a defense by law enforcement officers to civil rights claims, study the use of absolute immunity as a defense to claims asserted under the Tort Claims Act, examine how the application of immunity defenses impacts the lives of individuals in Maine, including individuals asserting claims against law enforcement officers and law enforcement officers themselves, and review reforms to qualified immunity initiated in other jurisdictions. And again, that was just kind of my best shot, so that could certainly be changed. The usual staff assistance language and report out language with the usual date of December 1st, 2021, with authorization to report out legislation related to the report in the second session. Should I leave this up, or would you like me to take it down for discussion purposes?
Sam, if you could leave up the membership, I think that
Sure.
would be really helpful.
Yeah.
And I see several hands up. I just wanted to jump in and just reflect that I do think it's really important to include a representative of a municipal police department. But I also think it's really important to include maybe not so much a prosecutor, but an attorney who represents plaintiffs in excessive force cases. That's the context in which the qualified immunity defense would be raised. And then an additional question I had, Sam, is there anything magical about the number 11, or could we increase the composition beyond 11?
The magic number is 13, but you can have more. It's just non-conforming, which is fine. You just add non-conforming language if you have more members. So you can really have as many as you want. We just add the non-conforming clause.
Because I would like to add an additional member of the House of Representatives.
So then that would be somebody who's not necessarily a member of the two largest parties, correct?
Right. It could be any member of the House.
Okay.
One of the two largest parties or not. It doesn't that issue would be irrelevant.
Okay.
So those would be my initial feedback. And then in the duties, where it talks about absolute immunity under the Maine Tort Claims Act, I would maybe strike the word absolute and just say study the use of immunity as a defense to claims. Thank you. And now I'll just call on people. I have no idea what order the hands went up. So Representative Reckitt, I'll start with you. And
thank you. I'm wondering whether it would be appropriate to have the Attorney General be a member of this panel, since his office is the one that investigates excessive force. I think Representative Evangelos could tell me whether I'm right or wrong about that, I'm sure. But I think in any case, I think I would, to tell you the truth, I would rather not have the person who handles those things. I'd rather have the Attorney General himself. Just because I think if we have the person who handles those claims in his office, I think there's a risk that they have a preconceived notion about what should happen. So anyway, that's my 2 cents.
thank you so much, Representative Reckitt, for those thoughtful contributions. Representative Evangelos, go ahead.
Thank you, Madam Chair. Is my mic on? Yeah.
Yep, we can hear you loud and clear.
So you, Madam Chair, have answered 2 of my several concerns. The main trial lawyers obviously should have I guess you can't name them by organization, but I think that's where you're heading. They testified on the bill. So that was going to be one of my requests. And then obviously, since I was the one that, several years ago to bring the deadly force issue to the Judiciary Committee, I was hoping we'd add a 3rd member to the, I hope it's me, but I'll let them take it up. One of the concerns I had was that the Section 2, number 3, 2 members with lived experiences, I would like that to be appointed by the Speaker of the House, because these families are calling me because of my activities around these areas, and I know who they are, and I have a good working relationship with Speaker Fecto, so I would ask that piece be changed. You're right, Lois. It is the Attorney General's office, and obviously we can't have the Chief of Investigations, so I'm not opposed to having the Attorney General sitting in on this. I'm multi-screening here, so excuse me. See if I had anything else. I think we're going to add the trial lawyers, municipal police. Give me a second. I'm reading what's on the screen, but I'm reading it on my computer because I took notes. An extra legislator, law enforcement there. So if I think that's good. And then I'm just going to quickly read the Section 7. So I noticed in both of the bills under language review, the report resolved used the word may. And the Joint Standing Committee on the Judiciary may report out legislation, but I'm not sure what the motion was on this one. I'm positive what it was on the parole bill, but is may strong enough a word?
Yeah.
I mean,
I personally think it is, Representative. I see where you're going, but I think that you can't, if the committee couldn't come to an agreement on the legislation to report out, it wouldn't seem appropriate to use the word shall to force the committee to do something that it wasn't inclined to do. So I think may is appropriate in that it's grants permission.
okay, but given the fact that I'm highly skeptical whether this commission or committee with law enforcement on it is going to come to an accommodation. If they're deadlocked, does the Judiciary Committee still have the jurisdiction and right to report out a bill on its own?
Yeah, they're reporting to us, and our decision-making process about legislation can take into account the report, but is not it's not dependent on a recommendation in the report.
So it's not binding.
Correct.
So if they come forward and say they're deadlocked, then we can take it up on our own and see what direction we want to go in.
Well, I don't think they would come to us saying that they were deadlocked. I think in that if they couldn't agree, the report would reflect multiple perspectives.
Okay. And then we pick it up from there.
Yeah.
Okay. So yeah, I just, so I think we've hit all the points then. Trial lawyers, because they're the ones who are going to be handling these liability claims. But I think it's also important to have the criminal defense side on there, because as we witnessed in Minneapolis and other areas of the country, they are bringing criminal charges now against these police. So I would like both of those involved. It's okay to add a municipal police representative. Fair and balanced, but not Fox News. And I think we've hit all the spots. All I want is that the Speaker of the House to appoint the peoples whose lives have been affected by the use of deadly force, and then I can give them the names of the families who would best be represented in that.
Representative Evangelos, I'm just going to raise a point to consider on that, which is that we have this great advantage of having the Speaker of the House be from the very southern part of the state and the President of the Senate be from the very northern part of the state. And I think it would make sense actually to have each of them appoint one of those members, because the issues may be different from region to region.
Yeah, unfortunately, these cases run from Kittery to Fort Fairfield, but I have no objection to having one of each. I can talk to each of them. Several of the families have testified in the past, and I know Representative Harnett and some of the other members will remember the Jackson family testifying in the 129th. So I'll work with both of them. Thank you.
Thank you.
I'm good on the rest of this.
Representative McCreight, I think you were next.
Thank you. A very small point compared to everything else that's been brought up, but as you're adding members, it's generally thought to be a good idea to make sure it's an odd number on the committee when it comes to voting. So I just wanted to put that out there. And I was trying to find it. In VLA, we just had a bill to about a task force around the cannabis industry, and the amendment doesn't show up yet, but I notice here, can you scroll to membership, Sam? Thank you. Again, you can't have everybody in the world on the committee, but on that committee, we have civil liberties, an organization advocating for civil liberties. And in addition, I can't think of the wording, but it's basically saying NAACP to be a member of the committee. So I just wanted to suggest those two things for consideration.
I can ask the analysts for VLA and see what language they use to for an organization like the NAACP.
Yeah, it was Rachel Talbot Ross's bill, and it just added some members to the advisory council for the marijuana, or OMP. Thank you.
Madam Chair, may I respond briefly?
Yes.
I do remember now that Attorney General Fry had mentioned on the deadly force review panel that he wanted to expand a member exactly under the criteria that Representative McCrate just mentioned. That I should have, as my omission, there should be, in addition to an organization like the ACLU, there should be an organization representing racial diversity in the state. And when it comes to those kind of appointments, does that still lay with the Speaker of the House or the President of the Senate? Is that how that works?
Yes.
Okay. Alrighty. So yes, good point, Jay. Thank you.
Yeah, excellent point. Representative Moriarty, you're next.
Thank you, Madam Chair. I left our meeting this morning for a few moments to take a call from my police chief, who circulated to me a message he had received from other chiefs and so forth about the lack of representation from municipal law enforcement. So I sent an email to Peggy and sort of started that ball rolling and take some responsibility for it. I agree that they ought to be there. There is certainly more municipal officers than there are state troopers or sheriffs or deputies. And that's where most people's contact, with the largest number of direct contact is with municipal officers as opposed to the two other organizations. Agree with the other comments previously made. I do question whether the Attorney General personally needs to be a member. With all due respect, and I mean that sincerely, he will likely be a conduit from the committee to the criminal division. He's got a lot on his plate, a lot of hats to wear, and naturally he will consult, I would assume, with folks within his office. And I think even without the AG, we've got a pretty good balance of the primary groups most impacted. So also I'm concerned it's getting a little large. I tried to keep a running tally here and then lost it. So it gets a little bit unwieldy after a while when you add too many people. Thank you.
Thank you very much, Representative Moriarty. I did just want to observe that I think we should ask the Attorney General. I think that he's been really engaged in these kind of issues, and he may actually really welcome the opportunity.
That's fine.
Yep. We can follow up with him.
Sure.
Yeah. Thank you. Representative Babich, go ahead.
Thank you, Madam Chair. I agree with the comments that have been made, and I appreciate Senator Carney's getting rid of the word absolute, and the House members and the diversity that's been included. I think this is all very good. Regarding the Attorney General, he's a constitutional officer, and I understand the advantage of having him there. But if there was some concern about having the prosecutorial division or personally represented, normally would have the AG or his or her designee, and that does not satisfy the original recommendation of having the Attorney General themselves. So I imagine that they will be represented one way or another, either as a consultant. The decision we have to make is, do we want him to be a voting member? Regarding the number of people in the committee, I mean, it's always nice to have an odd number so that there is a clear majority or minority report. But there's no problem with having an even number of people on a committee, because it still takes a majority to have a majority report, and if in the same as in our own committee, if we ever do end up with a tie, then we have report A and report B, and it's more or less the the substance of their reports that we'll be using anyway. So that's just my comments. Thanks so much.
Thank you, Representative Babbage. And Representative Evangelos, I know you have your hand up. I just want to turn briefly to Sam to ask if he has enough information about the committee's thoughts to draft, do another draft of this and circulate it by email, and then we can approve the amendment when we gather for our final committee meeting. Sam, do you have enough information from us?
Is it okay if I just run through the changes to make? I just want to make sure I did not miss anything and I captured them all accurately.
Yes, go ahead.
So the first one is a representative of municipal law enforcement. Replace the prosecutor with a plaintiff's attorney, representative of an organization representing plaintiff's attorneys or something like that. Another member of the House not tied to any party. Remove the qualifier of absolute in the tort claims immunity. The AG, and I'm still not sure if I should put the AG or the AG's representative yet, but just hold that one for a second. The lived experience appointed, one appointed by the Speaker of the House, one appointed by the President of the Senate. Try to keep an odd number. I haven't counted them out yet, but hopefully we can keep them to odd numbers. And then an organization representing racial minorities.
That, I think you've captured it, and will Representative Evangelos, you can have the last word on this.
Thank you, Madam Chair. Yes, he's got it right. I want to go back to something Lois said, Representative Galkay-Reckert. I'm fine with Aaron Fry joining us in some capacity, but it's not necessarily the criminal division, it's the investigative division that handles these use of deadly forces. And, you know, they've got 170-0 record, and Lois is right. She made the point that that is not an appropriate appointment to have that particular individual or people from that department on there, because their findings have been compromised, and one of them is still under challenge, and we're waiting on the AG to make a decision on that. So I just don't want this commission devolving into a conflict over these findings. So I want to be careful on that piece of it. Attorney General Fry has been engaging the legislature and individual legislators on trying to institute some reforms, including the one that Representative Talbot Ross brought forth this year. So I'm comfortable with the AG, but I'm not comfortable with the designee if they're involved in this past decision-making process. That's all. Thanks.
Thank you. Yeah, and that's something that we're just going to have to look into and include updated language after we check in with the Attorney General. So, all right, I think that we have addressed all of the issues. Sam, thank you very much for your work on that. And then, so I think we're done with our work on 1416 for today, and we'll have a final review of that. And now I want to turn, I know we're jumping all over the place a little bit. Representative Evangelos, can you remind me of the next one that we were planning to take up? I thought, yeah.
It's LD 842. It's the parole bill.
842. Okay, I'm not seeing that in our list of language reviews.
Peggy sent it out.
Okay, I've just missed it. But Peggy, thank you.
Sure, no problem. And I'm happy to share this. So I actually had been working on two different study groups. One is the parole group that I know that Representative Evangelos and I have had a couple of conversations, but I didn't make any changes yet. So I'll be happy to share the screen. So this is LD 842, and I believe this is a majority report to create a study commission. So this is an act to create a commission to examine the reinstatement of parole. And so the membership that I'm starting with is, I start small, so you can add 9 members, 2 from the Senate, 3 from the House. The Commissioner of Corrections, the Attorney General or designee, the Attorney General or Attorney General's designee, a representative of an organization advocating for the interests of people who are incarcerated, appointed by the President, and a member with experience in mental health and corrections appointed by the Speaker of the House of Representatives. And then Representative Evangelos and I were talking about either switching somebody or adding somebody who is an expert in the field of criminal sentencing or criminology. One of the resources in the state that Representative Evangelos has identified is Dr. Arthur Jones, who I believe ran the parole system in a couple of states, or at least worked with the parole system in a couple of states. So I don't know if that is somebody you would add and or replace 6, or, you know, start all over, however you want to handle it. And so that's a member. Do you want to work on membership, and then we can look at duties?
Yeah, that's actually, will you preview the duties? Because that will influence the membership.
So I also put in language about the commission requesting individuals with specific expertise to serve as consultants to the commission, not necessarily get paid, but serve as consultants. I mean, I know that CLAC, the Criminal Law Advisory Commission, has people that serve as consultants. So, and then the duties were very, very basic, that the commission shall examine parole as it currently operates in this state and in other states, the benefits and drawbacks of parole, the different models of parole, the effect on parolees, the costs and savings of instituting parole, and the elements of a plan to implement parole. I think that the last piece was one thing that you had talked about, was not only looking at it, but trying to come up with a plan to implement the return of parole.
Thank you. Representative Reckitt, your hand was up first.
Yeah, I just have a question, and it's probably to Representative Evangelos, because his memory of this topic is sharper than mine. The man he mentioned, Mr. Jones, was he the person who testified at the hearing?
Yes, he's and I was going to suggest Peggy had some draft language. He's a criminologist and a parole board expert, and he
was the guy that testified.
He ran Rhode Island and worked in New Jersey, 28 years experience. So I want to capture that job description.
And is he a resident in Maine now or not?
He's in Belfast, yes.
Yeah.
And he also, I mean, we're not supposed to talk specifics, I was told, but I think it's important that he represents racial diversity as well and sees things from a broad perspective. I mean, the fact is 1.5% of our people are African American, and 10 to 12% of our incarcerated are in the Maine State Prison are Black. So I think it's extremely important. So Peggy did draft an expert in the field of criminology, criminal sentencing, or criminology. I would just add to that, Peggy, possibly, or an expert on parole, and then that can be a member.
Thank you, Representative Evangelos and Representative Reckitt. Did you have anything to that you wanted to add in addition, Representative Reckitt? No, you're all set. Okay, Representative Moriarty.
Thank you, Madam Chair. I don't want to sort of break this down into too many subparts, but I was thinking there might be a specialist in criminal law and or procedure. We've used or heard from various faculty members at Maine Law in the probate area and so forth this session, and I think there's a distinction between criminology and criminal procedure that might be useful. The other thing, I have a question for Peggy. As you know, we spoke a couple of weeks ago, and I raised an issue or a point as to who composed the original committee that came up with the Maine Criminal Code in the mid-70s. And from what backgrounds were they chosen from? Did you ever get any information on that?
I did, and I'm trying to think exactly where I have that. But I do have the actual legislation that created that commission, and it was a very high level commission that worked for quite a while.
Yes, did.
Right, and had like a what do you call it? Like a reporter, a person who was, not only was there the commission, but there was somebody who compiled their work. Yeah. I believe. Yeah, and I can pull that up and talk about that if you want.
The task of this committee is much smaller.
Right.
Than that of the mid-70s, so we don't need anything of that sort of size and complexity. But I just thought it might be a model for the makeup, which could be of some value to us.
It included, if I remember correctly, judges as well as law school folks, and not sure who else.
Okay, and I think judges are at least worthy of consideration for this current committee as well, or a judge.
Or maybe current or former.
Yeah,
Yes.
that's a good idea. Current
Yes.
or former.
Yep. That's all I have.
Thank you. Representative Evangelos, go ahead.
Thank you, Madam Chair. We've covered most of it, and the way this has been drafted included a third member of the House of Representatives, so I won't belabor that one. I appeared before CLAC for 2 hours to present this bill to them and to defend it. And there were a couple of district attorneys present who were highly in favor of parole, and they spoke to it with CLAC and with me. I mean, I'll tell you who one of them was Andrew Robinson. He from Androscoggin County. He was very much so in support of this. I don't know if you want to consider a district attorney or not. I do want to make one point on the Attorney General, the Attorney General's designee, and I'm not going to cross any lines and mention any names, but the Attorney General's representative on CLAC was violently opposed to parole. And I mean violently opposed. And so I don't mind someone coming in from the AG's office, but they have to have an open mind. This person doesn't, and I'll discuss it with the chairs, certainly not in this forum. But I know that we're going to have people from all different perspectives. All I ask from everybody is they have an open mind. It's important to allow the commission or the committee to deliberate without running into obstruction right from the beginning. So I was very impressed with CLAC's attitude towards this. And you may remember John Pelletier said that CLAC had made a shift in its opinion on this issue, and that more members now were leaning in this direction than weren't. There were 2 specific members that were against it, dead set against it. And again, I'm not going to do names, but we had a very, very good discussion. And I will tell you that a former Assistant Attorney General and a very fine person who happens to be the chair of the Executive Clemency Board spoke positively within the CLAC meeting I had about this idea. And I thought that was a very important, because he questioned me at length about executive clemency and why it wasn't working. And that was one of the reasons why I brought the parole bill forward in the first place, is that since 1976, when we abolished parole, no one has qualified for executive
Representative, I just wanted to, I'm so sorry to interrupt, but we've dozens of language.
No, I'm wrapping it up, but I'm just telling you that it lends credence to the kind of people we could have on here, but not somebody that's already closed their mind. And we can talk about the rest of it later. But so I'm pretty good. The only question I had was, we don't seem to be saying who's going to be appointing these people like we did in the other bill. We've got 2 members from the Senate, from the President, 3 members from the House, from the Speaker, the Corrections Commissioner, the AG or the designee, and then a representative organization advocating for the incarcerated. So who's going to be selecting these people is my question.
So as drafted, I have the president and the Senate appointing a representative, an organization advocating for interests of people who are incarcerated, and the Speaker of the House appointing that other member. And I don't know if that's, if you want to change that to criminal sentencing, criminology, expert in parole, criminal
So we're
procedure.
gonna, right, so we're gonna do are we doing it one additional member then the criminologist, parole
Yeah.
expert?
However you want to handle it.
Yeah, if you could, if the committee doesn't mind, if we could make one extra member for that sort of person and let the Speaker of the House have that jurisdiction, because, you know, I'm in contact with them a lot more.
And Representative, did you also want to add a county DA or designee?
Yes, wouldn't be a bad idea. And also, I'm not allowed to say who, but Mr. Robinson wasn't fair. And I think we need to be sensitive to the race issue again.
Okay.
Same thing we did with the other bill. Let's put a component in there to make sure we're sensitive to that, given that our jails and prisons are full of people from.
Yep, understood. Peggy,
Thanks.
do you need any additional information from us at this point?
So just the diversity question, do you mean for members on this commission that they need to reflect diversity? We have some language that we were using last year.
The language we used with Sam a few minutes ago to make sure that there's a member of the commission that represents, a group that represents racial diversity and the interests of racial issues in our state. So, you know, like.
So are you talking about 3 additional people then?
I guess we are if we're going to do a DA.
Yeah, that's what it sounds like to me as well, Peggy.
And we're going to, Senator Carney, we're going to look this over one more time, right?
We are.
All right, that's all I got then. Thanks.
All right. Anything else, committee members, on this one?
Are the duties good enough? Actually, I don't like that. Are the duties specific for what you want to accomplish? Okay.
I think we're good.
I might add a little bit of language about how parole fits in with the kind of the overall framework of Maine's criminal code, because I think that's an important piece of the implementation puzzle.
One other quick thing, if we're going to be talking about money, I want to include the fact that, first of all, somebody under that gets parole is still under the supervision of the Department of Corrections. But yes, it's going to cost money to set this up, but every time somebody gets parole, it's $50,000 less. Well, it's $55,000 according to the recent study. $55,000 less per resident of a prison who is released and now is employed gainfully and becoming a productive member of society. So the money part's a two-edged sword. I want to make sure we consider both sides of that.
Yeah, I think that's in there because it speaks to both the costs and the savings. So I think that's already been addressed.
All good.
Arnett? Nope, we're not able to hear you, Representative. Oh. Tom, why don't you turn off your video so because I think we'll hear you better. Tom, we are not able to hear you. I think if you can maybe try logging back in, that would help. So let's do this while Representative Harnett is reconnecting with us. I think what we'll do is ask if there's any other comments on this, or we can just kind of put this on hold and Oh, okay, Tom, Representative Harnett is rejoining momentarily, so let's just take a minute. Representative Evangelist, did you have anything else you wanted to add before we wrap up on this?
All good, and we'll read it again, but all good.
Great. And does anybody else have anything they want to add while Representative Harnett is rejoining us? I'm not seeing any hands up. Okay. And just so that I know that we've had Kathleen Ayers and Leo Delicato waiting ever so patiently in the attendee part of the meeting. So I'm just going to bring them onto the panel because we'll start on, I think they're here for 480. Is that right, Peggy?
Yes.
Okay, I'm going to bring them on so that we're ready to dive into 480 as soon as possible. Welcome back, Representative Harnett. Go ahead.
I actually, all I was saying is you made the point I was going to raise about that savings were discussed. So sorry for that. Hopefully I'll be here for a while.
Okay, we hope so too. Okay, so I think we're done with our work session on 842. Thank you everyone for your excellent contributions. And we'll open the work session on 480. Representative Evangelist, did you wish to be heard on?
I just wanted to thank you for moving it up on the schedule. I had a long day.
Yeah, no, that's fine. We're working hard to accommodate everybody. Thanks for your contributions on those two. Okay, apologies. This is a crazy time of year, and you both have been extraordinarily patient. We really appreciate your hanging in there with us, and we would. So Peggy, do you want to give us a little synopsis of where we are on 480, and then that'll orient us?
Right, and I don't know if you need me to share. So this bill addresses the appointment of attorneys in probate court when there is a guardianship, conservatorship, or other protective arrangement proceeding pending. And right now, the probate court judges appoint somebody. The statute says they must appoint somebody if the person wants to challenge, if they have a question, if they want to limit the guardian's powers. I'm sorry, I don't remember all the details of that says the court must appoint, but in those circumstances. But the court's not required to make sure that the person is represented. This bill starts with the default that the court will appoint somebody who's not already represented by an attorney, will appoint an attorney for somebody who is has one of these, is the subject of one of these proceedings, unless, and the amendment changes it to the judge finds by a preponderance of the evidence that the adult has knowingly waived the need to have an attorney. So the question has been really raised. The Department of Health and Human Services said, because they handle all the public guardianship and public conservatorships, they think that there would be additional legal costs because attorneys aren't always appointed. They don't feel attorneys are always appointed in those cases. And so this would increase legal costs for the Department of Health and Human Services. But what that doesn't address is the costs to the counties, because when a probate judge appoints counsel for somebody in the probate court, that's a cost that the counties pay. And so the fiscal note shows that the state has costs, but it also identifies this, I think incorrectly, as a municipal mandate. It's really a county mandate because it requires the probate court to appoint attorneys. And however it's been assessed, that would mean the appointment of more attorneys than are currently being appointed. So when you have a state mandate, you have some options about how you go forward with that. Last year, I believe the bill did not indicate costs on the county because I think the assumption was that attorneys were being appointed in all the cases that were necessary. And this year we have a different conclusion by the Office of Fiscal and Program Review. So you have a couple of very good resources that have joined you. Kathy Ayers is the probate register here in Kennebec County, and she's also the president of the Registers Association. So when an attorney is being appointed by the probate court, they're going to look to the register to do that, to find the attorney. I think in almost all the cases, I doubt it's really the judge reaching out. So, so you agreed to wait and try to figure out what these costs might be to the county. Ms. Ayers had given us some information from 2018 that about all the caseloads, in fact, the whole probate court caseload, because we were working on some other issues. And I did share that with you, and I can find that and pull that up as well too, if that would be helpful to you. But that's where we really are, is what's the burden of this bill on the probate court, and especially the counties with regard to costs.
Thank you. And so if you could, Peggy, because I think what the numbers say will help inform our decision.
Sorry, I thought it, yeah.
No, I think you probably did give it to us.
Do you want the case?
The case count, yeah. I'm kind of
yeah, let me
having
find
a
that.
hard time triaging my way through all of the information.
Right. Okay, I will find those. And I don't know if there's somebody else you want to talk to while I'm digging those out.
Actually, I would like if Kathleen Ayers, if you could give us kind of your impression of what the extra cost would be on the county based on your familiarity with these issues.
Sure. Let me start with the 2020 numbers. The statewide, there were budgeted $272,000 for attorneys, and 211,000 was spent. So it wasn't completely all spent. And let me say that by changing this bill to the preponderance of evidence, I think it is a lesser amount than if it had stayed the clear and convincing. And the procedure would be somewhat less on another layer of procedure with the preponderance of evidence piece. So, I mean, it would be a guesstimate for me, but some of these obviously are not being appointed at a rate like we do in Kennebec, because, you know, and I want to just read it, why we get an attorney. If it's requested by the respondent, if the visitor who goes out and serves the respondent, if we determine, the court determines it's needed, or if it comes to the attention that the respondent wishes to contest any aspect of the proceeding or seek any limitation on the proceeding with guardianship powers. So I can't give you a number of how much this will change. I think it will force these counties that are doing, not appointing them at a rate that is really like we are, you know, it will force them to do that. So I do think that one bad case can be up to $30,000 or $40,000, depending on how bad it is and how many times it gets appealed, and whether the person has, you know, funds or not. A bad case can wipe out your budget. And some of these counties have apparently not had a bad case like that, but it can happen. So I think a 10% increase, I projected that the 272, a 10% increase is a guesstimate of that, what would happen because of the change from clear and convincing to preponderance. I think it's going to be allow us to those people that really, really do not need an attorney in the situation will not be forced to if we keep that preponderance of evidence piece. And I think it won't be as cumbersome on the probate courts as I originally testified against with the clear and convincing evidence piece. So.
Thank you very much, Ms. Ayers. And I just wanted to welcome Representative Cardone back to the committee. And we started a little bit before your arrival.
That's okay. I thought this AFA committee would be finished by 2:30 and they're still going. So I'm glad you started. And I see you've got the stakeholders on. I just wanted to make sure they had the opportunity to speak to you on this bill. So everything's fine.
Okay. So then I'm going to turn to Leo Delicata and ask him to provide us with his perspective on what the costs on the county probate courts would be.
Thank you very much for allowing me to join you and to have a conversation. From the very beginning, I was really surprised by the change in the fiscal note because LD 531, which was exactly the same bill in the 129th, except that it had a higher standard of proof, actually had a fiscal note that said no fiscal impact. I mean, it said no fiscal impact. So when I saw the fiscal note on this bill, which not only had now a fiscal note for the Department of Health and Human Services, but a fairly substantial recitation about whether this could be a mandate, I was really surprised. I mean, if the office charged with the responsibility of determining what the fiscal note should be can't decide whether in fact a mandate is involved, I don't know how you could decide. It makes no sense to me. And as far as the amount is concerned, which would, if the amount was more than, de minimis, it would be a mandate. I've maintained from the very beginning that the standards that we have in the law now, 503, which were just Kathy Ayers just recited beautifully, catch almost all of the cases in which people ought to have an attorney. The cases that we're concerned about are the cases where there's a really strong sense that there might be exploitation. And guess what? The visitors are not picking it up. And they're not picking it up because, we don't have any kind of visitor training that is uniform throughout the 16 different probate courts. Now, Miss Ayers' court is a wonderful court. They do a tremendous job and they make absolutely certain to leave no stone unturned. That is not clearly the same in all the other 15 courts. So, I get very concerned because you have these people that are compromised in health, compromised cognitively, who may have only one person in the world, may or may not be a family member, who is trying to take care of them. And you wonder, even if they know something is going on, whether they would say something for fear of losing the one person in the world who visits them and buys them groceries or takes care of them in any way. And so those are the kinds of things that somebody would have a difficult time saying, I want a lawyer, because for most people in that generation that I'm talking about, you only get a lawyer if you're in trouble. You only get a lawyer if you've done something bad. And so they're not, and so if you've already got that sense in your head, and the only person who is seemingly caring about you is the person you really ought to be worried about, you're not going to get an attorney. And so I don't think we're talking about a tremendous number of cases here. You know, the whole number of, it was interesting because the 2018 figures that Kathy provided, and I haven't seen the 2020 figures, when you break down the actual number of guardianship and conservatorship cases that you would have the opportunity, or at least you'd have the event in the court of deciding whether somebody should get an attorney, is 1,400 cases. Actually, it's less than that, because if you take out the number of cases where you're terminating guardianship and conservatorships, which in every single one of those cases, even under the current law, you should have an attorney because they're contesting the authority of the guardian or the conservator. So if they're contesting the guardian or conservator's authority and you're trying to terminate the guardianship, they ought to have an attorney, unless they already have one, or unless there's absolutely no question about whether it ought to be terminated. So those numbers to me are a little squishy, but the bottom line is that you're not talking about thousands and thousands of situations. You're talking about a relatively split into 16 different courts. So you're not talking about a tremendous number of events.
Yeah, and I think I'm sorry to interrupt you, but I just want to really kind of hone in on, like, how do we identify what that number is?
And that's really the problem. I mean, we can all get down to a point where we can decide, or you can decide how many case experiences we're talking about, but we don't know how many attorneys are actually being appointed, and as it compares to the number of cases that we have. And we certainly don't have any way of determining whether, in fact, the discussions or the ability of the visitors to actually elicit a really accurate opinion from the individual about whether they want an attorney. And so we may have a lot of situations where attorneys aren't being appointed. We may have a lot of situations where attorneys are being appointed, but we don't know how much more it's going to cost people or the counties until we get better at measuring things. And maybe Kathy's right.
Yeah, let me just turn to the bill sponsor and just see if she has any ideas, because I think what you're articulating now is what we're really all struggling with. And how do we get beyond that hurdle?
Mr. Delicata has articulated my concerns, or our concerns, or what he and I have been struggling with on this bill. The only thing I want to add is that, as Mr. Delicata said, LD, was it 530, Leo?
31. 531.
531.
531.
In the last legislature, when we brought this bill, we had some sense, and I don't remember whether it was as a result of 531 or whether it was as a result of the other information that we were collecting about probate courts, because we were doing the probate court subcommittee at that point. But we had some information to indicate that in general, the 16 probate courts were not reaching the limit. They weren't going over the limit that they budgeted. for attorney fees. And our sense about 531 was that it was not going to add so much of a burden that it would cause those counties to go over their budget or have to re-up their budget significantly. Now, as Mr. Delicott has made clear, those were all estimates and best guesses based on what we had, because what we're talking about here is a small subset of cases where attorneys would not be, where it is seemingly uncontested, because if it's contested, an attorney would already be appointed. It's seemingly uncontested, but the court sees some reason that it's not going to pass that preponderance of the evidence test. So if in those subsets of cases, you take one of those cases, it gets to the point where a court says, by preponderance of the evidence, I'm not sure you get this. I'm going to appoint an attorney. And there's going, in many of those cases, we think an attorney's going to take a look at it. An attorney is going to maybe meet with the client once or twice or do a little bit of work and say, okay, there isn't, I'm not concerned about exploitation here. I'm not concerned about, that there's something nefarious going on. And that's not going to be a big attorney bill. In the rarer case where the attorney takes a look at it and finds that this client really doesn't want a guardian, or doesn't that there's something else going on here, that this guardianship should be fought, I hope it's going to be a relatively rare case, but it's going to be a case where you're going to say, oh my God, I'm glad we had an attorney there. That attorney was needed. So I think that on balance, if we're wrong about this and the cost overruns are significant, are high, if we're wrong about those estimates, then boy, were we right that we needed to have this law. And then we may have to go back and look at adjusting the costs. We're not trying to stick the counties with a bill by any means. But that's kind of how I'm feeling about going forward with this.
Can I ask you, because I know that one of the options is to, it's the third option, and I'm not going to remember all of the exact language, but I mean, one of the options would be to, acknowledge that there might be some cost but not fund it in any way. And then if a county didn't have the resources to bear the costs, then they just wouldn't comply with the law. But if there was a way for us to require the probate courts to record each of those instances where they would have appointed an attorney, but for having the resources, that would maybe help us track the number that we can't reach. Does that seem like a possible way forward?
It does to me in terms of having the information. I would defer to Ms. Ayers as to how much of a burden that would be, or how helpful that would be to the probate courts themselves. I think that would be helpful.
I'm not sure what you're asking us to do. I mean, I report on every case, whether there is an attorney or whether we spent the whole amount.
Well, as I understand it, and Peggy, I'm probably saying this wrong, but one of the options, the third option, is to basically pass the law without any provision for the counties to any appropriation that would fund the work on the part of the counties. But and that the counties have the option, if they don't have the resources, to just not comply with the law. But could we require them to report each instance in which, had the funding been available, this new statutory standard would be implicated, and they would have had the funding been available, they would have appointed attorney as a way of figuring out how many people are not getting served who need to be served in this situation.
Yeah, I think that would work. I really do, because I really think that it's not as big a number of an increase with the preponderance of evidence as the budgetary office thought. And if there are counties that, I want to give you an example. Penobscot County went 31,000 over already in 2020. Cumberland County was 50,000 less that they had not spent. So I would hope that a county that spent over $30,000 asked for an increase this year. And it's always been and I've preached this for a long time to the registrars, that we need to increase it on a regular basis. So if there are counties that are, it would be on them to do that. I just don't want to put too much on the registrars themselves, because with the new guardianship law, where every single thing is a hearing, we are jammed up. That's just, everything in the guardianship area now requires a hearing. And so as long as we don't have to, as long as it's just keeping track of the money. But I do know that former judges that I had and the judge that I have now, even if we ran out of money, would still be appointing an attorney. So, but they could definitely let you know about the overage,
Mm-hmm. What do you think, Leo Delicata?
Well, I think that they could certainly tell you how much more money they spent. But honestly, I can't imagine somebody telling you we didn't appoint an attorney because we didn't have the money, even though we should have.
Mm-hmm.
I mean, I'm sorry, but that's a little hard for me to believe.
Yeah.
I think this is very difficult, and it's very difficult because we don't have any really concrete information. And if you just let it go the way, so that they can ignore appointing attorneys when money is tight because it's a mandate and you haven't funded it. I think there are some counties where that's going to happen.
Mm-hmm.
And I'm not sure that there's a good, I don't think that there's anything you can really do to encourage people to appoint attorneys. I think if you knew in how many cases attorneys were actually appointed, that would be interesting and probably probative. If in Ms. Ayer's court, you get a 90% appointment or a 95% appointment, and some other court, you get a 10% appointment. And that because they report that. It would give me some pause. But I mean, again, I think I agree that we're talking about a small number of cases. I wish that the fiscal note hadn't been written the way it was written. I don't know why it was written the way it was written. Same people involved, same language, except the language that you have in your amendment is less of a burden than the language that they had last year. And yet we get this completely different fiscal note, which puts you in a difficult spot. And I really don't know. I don't have a good suggestion as to what to do. I suppose that there is another way to deal with this, and I hesitate to suggest it. But you have another bill that establishes a commission to make a plan for the transition of the probate court into the state system, which we all know will take a long time to do. You could carry this bill over, because if in fact, I hope that commission gets funded, that is one of the issues that they ought to take up. And, you know, and maybe a different source for actually paying for attorneys.
Okay,
But,
I just want to turn to the bill sponsor and get her thoughts on whether we do a carryover or whether we, or how you'd like to proceed, Representative Cardone. We're not able to hear you, Representative. Thanks.
Sorry. As long as you don't vote it ought not to pass, I don't really care. I mean, it's not, in the world of fiscal notes, it's not a huge one. And we have a lot more money on the table this year than we're going to have, or that we have had in past years. But I can't ensure that it's going to get funded. Who wrote the fiscal note? Do we know? Was it Lauren?
I don't know.
Okay. One possibility is if you carry it over, I can talk to whoever wrote the fiscal note and find out a little bit more about how and why, and how that compares to what was it, 351, 531?
531.
In the last legislature. I may be able to get more information on this to reconcile, to try to reconcile this. And I don't mind doing that. I'm sorry, I've just been too swamped up to this point to be able to do that work. But that's certainly something that I can do and I can bring back. I don't know if it's going to be helpful. I don't know if it's going to change anything. I know I had a good working conversation with Luke Lazur and the stakeholders on the other bill that I brought, the main care lien, on what to do about a fiscal note. And we did collaborate, we did work on that note. So it may be the note will be changed, but there are limited parameters on how this can be, how that note can be addressed. But I would be happy to do that if everybody would be comfortable with a carryover.
Yeah, let's hear from Co-Chair Harnett, but I think that maybe makes a bit of sense. Go ahead, Tom.
Thank you, Senator Carney. And this, if this was covered, I apologize. It might have been mentioned by Mr. Delicato or Representative Cardone, but 531, am I correct? That required the appointment of an attorney in every single case, right?
The committee amendment did not. The committee amendment was exactly like the one that you had before you in Senator Cardone's bill, except for Representative Moriarty's amendment, changing the clear and convincing to a more likely than not, the preponderance.
Okay, so when it was clear and convincing, it generated no fiscal note.
Zero.
And we're lowering the possibility of court appointment, and we have a fiscal note and a mandate.
And a mandate, and that's what's just totally baffling.
Thanks.
So, committee members, there is, in the next little bit that we have to work on this bill, it does not seem like there's a clear path forward. Do our committee members comfortable? And it is a really important issue. In the cases where it will make a difference, it will make a huge difference. Do we feel comfortable tabling this and carrying it over? How are people feeling about that? Representative Sheehan, go ahead.
I was just going to say, I think this bill is super important and I would support carrying it over.
Thank you. Representative Moriarty?
Madam Chair, we have already voted to pass this bill with the substitution of the preponderance standard. My question is, what's going to happen in the interim if we carry it over, other than wrestling about the fiscal note? Is there anything more that we need to learn or do, or?
No, it would just be addressing the fiscal note to see if there was a way to reduce it and to deal with the mandate, because there's both the DHHS costs, I believe, and then also the county costs that we need to try to identify and deal with.
So your feeling is that in the interim, when things are not as busy and things are not running as hot and heavy, we'll have a better chance of success.
Yeah, and Representative Cardone, the bill sponsor, indicated that she would appreciate that time between sessions to follow up with the OFPR. Is that right,
Well,
Representative Cardone?
Yeah, I will work on the fiscal note. My concern is that if you pass it, I think I'm right about this, but Peggy, if you know I'm wrong, correct me. If we pass it out with this fiscal note and it gets voted on and it goes to the table, it's going to have this fiscal note attached. And if it doesn't get funded in this session, I think it gets carried over to the next session, but it gets carried over with the fiscal note on it. I don't think there's any chance for me to go and try to negotiate that fiscal note and see what, see whether it's being appropriately addressed. I think you got to keep it in committee in order for me to be able to do that and be able to have it changed.
That's it.
I wouldn't be able to, if it gets carried over on the appropriations table, then it is, to change it, it would have to come off the table and remove the committee amendment.
And go back to committee. It would be a lot more difficult, having already gone through the House and the Senate, presumably, and gotten on the table. It would be a lot more difficult to change it, I think.
It seems that way, and it also, the bigger the fiscal note, the more lumps and bumps it might have in the House and Senate as well. So I would love to hear just briefly from both Kathleen Ayers and Leo Delicata. We are all, I think, are recognizing the urgency of this, but do we feel like it's appropriate to give it another year to work on the fiscal note before the committee passes it out of the committee and onto the House and Senate?
I would certainly be in favor of that. I think that this fiscal note, just on principle, needs to be solidly addressed with the people who wrote it, because there's a reason why it's so different, and it would be important to learn why, I think.
Mm-hmm.
And I absolutely agree that, getting it carried over from the table is, you've lost complete control over it at that point. Once it gets to the table, you've lost control of it. And, if the committee really wants to have this passed, then leave the tender mercies of being carried over on the table is probably not the best strategy, as far as I can tell. Giving Representative Cardone a chance to speak with OFPR and to speak with DHHS to find out how they came up with their fiscal notes, I think is a wise thing to do. You lose nothing by it.
Yep.
And you keep the bill in committee. You have control over it.
Thank you. And Kathleen Ayers, do you think that that's a wise move as well?
Yeah, I do. And I think it would perhaps give me an opportunity to find out the breakdown from as many counties as I can, and give you a breakdown of how many are being appointed and in what cases. that can be done. It's just like I said, there's so many registrars that are just overwhelmed with
Mhm.
going on right now. That, and the other thing is, it's really not a shock to me because county government is getting allowed, because of the jail situation, has insisted on these mandate watch, So this is really not a surprise to me, and it's because of other areas in county government where we have continually struggled. So
Thank you for adding that. That helps us understand a little bit more what's happening.
And excuse me, I'm getting ready for my golf game.
Oh, that's all right. I think we're moving toward a vote. Let's see if we can get a motion to table. And looks like Representative Sheehan has moved to table. And is that a second, Representative Harnett? Okay, and so let's do, Soupy, go ahead.
Yeah, just to let you know, if you're tabling it and then plan to carry it over, you do have you have a motion basically where you can't have two reports. So I think, do you have to reconsider, Peggy?
Yes.
Thank you.
Okay, so we would have a motion to reconsider, and then can we do the motion to table and carry over in one fell swoop, or do we have to do those separately?
I don't know that you have to table to carry something over.
Right. I think you can.
If you're not going to vote today to carry it over, then you're going to want to table it. But if you're going to vote today, then you don't need to table it.
Okay,
That's
so
just,
we'll vote to carry it over. So, but we need to reconsider.
yes.
Okay. All right. So Representative Sheehan, or is that your motion to reconsider?
Yes, Madam Chair, I move we reconsider LD 480.
Thank you. And Representative Harnett, is that your second?
Yes, it is.
Great. Okay, so we'll just do the reconsideration with a show of actual physical hands, committee members.
1, 2, 3, 4, 5, 6, 7, 8.
8.
I've got 8.
I have 8.
Me too.
Great. And we're going to move our guests back to the attendee space and onto the golf course or wherever they're going. Thank you.
Bye, thanks.
Thank you. Thank you.
Okay, so we've got to reconsider, and Representative Sheehan, go ahead with your motion to carry over.
Thank you. I move we carry over LD 480.
Second.
And seconded by Representative Harnett. And let's do this one with a roll call.
Ready to go?
Yes.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone.
Yes, sorry.
Thank you. Representative Cardone votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier. Representative Evangelos. Representative Newell. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Representative Evangelos. Representative Evangelos is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 8 members voting in the affirmative, 0 members voting in the negative, and 6 members are absent. Thank you.
Thank you very much. So the motion to carry over passes 8-0 with 6 absences. We'll close the work session on LD 480. And committee members, what I would like to do now, I know it's very late, but we need to get information about carryovers reported out to the presiding officers. And I'm wondering, I would like Peggy, I'd like some feedback from you on this as well as Soupy. I feel like it would make sense for us to vote the carryovers this afternoon so that I know that we're a week late. I'm reporting them to the presiding officers. And so does everybody have time to do that this afternoon before we adjourn? And is there any reason to be concerned about go ahead, Representative Moriarty.
And is that a bill by bill proceeding, or can we take them all in one motion?
Well, that's an interesting question. Peggy, do you know whether it's appropriate to do it that way?
I don't know that it would be a problem if you're all on the same page. I think Soupy will end up writing a separate voting sheet for each one. But if you're very clear about what you're voting on, I don't think that's a problem. Soupy's the official vote taker counter. So if I don't see any problem with it under the rules or anything, because you are taking a vote on each bill.
Soupy, do you have any concerns about us doing it that way from your perspective?
I do not. I just want to make sure I get all the numbers correct. But I have no problem with one but I will, Peggy is absolutely right. I will have to do a separate sheet for all of them. But if everybody understands that and knows that from the beginning, that shouldn't be a problem. So the person making the motion will, for all of and the second, for all of the sheets will be the same.
Okay. Representative Harnett?
Thank you, Madam Chair. Are we working off the list that you sent at 2:13 this afternoon?
Well, what I propose, this is how I would propose to handle it. What I would like to do is I would like to go through and recite the bills that I think are important for us to carry over and why. And then my recommendation would be that somebody move the list of bills that I've recommended. After I recite them, I will check to see if there is any disagreement among committee members, that something should be taken off the list. And then we'll vote on the list, and then we can vote on any that people don't feel comfortable voting as a package.
So we would be voting on the list that you circulated earlier today, plus adding 480.
Exactly.
Okay.
Yeah.
Thank you. Just trying to keep my head straight.
Yep. So let me go through my suggestions, and give me just a moment, everyone, please. Okay, so I'm going to go through the bills, and I apologize, they're not in numeric order. So the first one is LD 233, which relates to electronic juror information. And we are waiting for rulemaking to happen, which hasn't happened, and that's why we want to carry that one over. The next one would be LD 1310. That's a criminal records concept draft. And we have a criminal records review committee being set up. And what we would do is we would vote ought not to pass all of the other criminal records bills, let the review committee bill and then go through, and then retain the concept draft for the second session. So that's 1310. The next one is I've got to put my glasses on here, 1696, which is recodifying the Protection from Abuse Act. And that is just a complex bill that we didn't have time to thoroughly review this session. The next one is 903. That's the uniform money judgments, which we would consolidate with 902, which we've already voted ought not to pass on. The next one is 598, and that's an amendment to the Human Rights Act pertaining to hair texture. And that is awaiting rulemaking, and so it doesn't make sense to move the legislation forward at this time. The next one is the Equal Rights Amendment, and that we've been requested by our colleague, Representative Reckitt, to carry over. The next one, 811, is a concept draft related to reproductive rights that we also are may need to move forward during the second session. And then there are a number of bills related to tribal sovereignty and other issues that we've promised stakeholders and sponsors that we would carry over. And those are 906, 1218, 1626, 585. And that's that grouping.
I don't think it's 585. That was the LR number. That is 1568.
Oh, thank you. You are absolutely right. I'm just gonna, it takes a village to, to get through all of this, all of these numbers and all of this great work. Thanks, Peggy. The next one is 1529, and that's the constitutional amendment related to privacy. The next, and that one was requested by the sponsor last week. And I believe that the committee, I don't think I was there, but I think the committee agreed to that. The next one is 982, and that's an issue related to how to define, to create definitional language in the Maine Human Rights Act to extend protections to people who are in corrections entities. And then we have 1581, which is a re-referral from the Energy, Utility, and Technology Committee, for which we were given an extra carryover. And then we have a bill that was just referred to us, which is LD 1728, which we simply don't have time to address this session. And then and then we have the 861, the yellow flag bill that we discussed earlier today. And then there are two on this list that I haven't mentioned that and then 480, which we were just discussing. And then there are two others on the list, which I haven't mentioned, but I think are both important for us to consider. One is Representative Babbage's land claims bill, which is 1665. And then the other is a bill that the committee has voted on but hasn't been reported out, and that's 1068. And that is a bill that I sponsored related to protection from harassment orders. And there's work that will be done over the summer on 1728, which is Senator Timberlake's bill, and also on 861 that may relate to 1068. And so I would like it if we could carry over all three of those. So 1068 is a latecomer to the list, and I would just ask that we include that as well. I think that takes us over our limit by one or two bills, and I'm happy to advocate that we be allowed to take those one or two extra bills to carry over in excess of our allotment. So with that, I don't know that if I've missed anything and somebody was paying close attention, I'd be happy to hear any amendments to that. Go ahead, Supi.
Yes, thank you. I have a couple of questions. I did not get the number after 598. I think you mentioned that was lowest representative records.
344.
It's 344. And then it was 811 after that, correct?
Exactly.
Okay, thank you. So I only missed one. And 1068, I don't have my file here, so I don't know. You said we voted on it. Is that one that we have to reconsider as well?
Yes.
In order to carry it over? Okay.
Oh, yes, we would have to do that as well. Thank you. Yeah, we voted on it, but it has not been reported out.
Right, and they're actually working on trying to compile fiscal information for that as well.
Okay.
So, I mean, it's still in processing, and one of the questions is how to identify those costs. I think I'm correct.
Okay.
That's a total of 19.
All right. And we were allotted 17. We got one bonus, so we only have to beg for one more. Is there any other that we have to reconsider? I don't think there is.
Oh, God.
Okay. So,
Could I ask a question?
yes, go ahead, Representative Reckitt.
I'm just wondering whether there's any two of these bills that are enough similar that they could be carried over as a piece. You know, I don't know whether, I don't know the details of Senator Timberlake's bill or the harassment bills. I mean, I don't know what-
I think, Representative Reckitt, I think it's just going to be easier to ask permission for one more. I don't anticipate that it will be a problem, and if it is, we can do a workaround.
Okay.
Thank you for brainstorming about that.
All right, thank you.
Okay. And then Representative Harnett, your hand is up. Did you? I wonder if he got frozen out again. Okay, that's what happened. Thank you.
Frozen.
Okay, so let's start with the beginning, which would be to reconsider 1068. Is that acceptable to everyone? Representative Sheehan, do you have a motion?
Yes, Madam Chair. I move that we reconsider LD 1068.
And is there a second?
Second.
Seconded by Representative Cardone. And all those, wait, go ahead. Are you ready, Soupy, for the vote on the reconsideration?
Yes.
Thank you so much. So all those in favor of reconsidering, please raise your physical hand and hold it up until Soupy's had a chance to count the votes.
I get 7.
Get 7.
Yeah, great, thank you. So the motion to reconsider passes, and then on the reconsideration, Representative Sheehan, do you have a motion to carry over?
Sure do. I move that we carry over LD 1068.
Thank you very much. And seconded by, I'm sorry, who seconded? I missed that.
I think I did, Madam Chair.
Seconded by Representative Moriarty. And so we'll do this one in a roll call vote. All those in favor of carrying over 1068. Oh, this is the motion to carry over 1068. Thank you.
Are you going to do one motion and carry both once?
Yeah, I was on.
You don't need to. You can keep going like this if you want.
No, I think we'll do them all together.
Okay, so this is a carryover motion for the 19 bills you've identified.
Yes, exactly.
So I will withdraw my motion to carry over LD 1068, and I will instead move to carry over the aforementioned 19 bills.
Thank you, Representative Sheehan. And is there a second on that motion?
Second.
Seconded by Representative Moriarty.
I'm okay if you want to call the roll.
Yes, are you all straight with what the list, Soupy?
My henpecking is there, but I can read it. And Peggy and I will get together and make sure it's correct. But yes,
Right, and we'll be sending a memo to the presiding officers with all them actually listed.
Wonderful. Thank you very much.
And I will call the roll.
Yes, please.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone.
Yes.
Representative Cardone votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier. Representative Evangelos. Representative Newell. I will recall the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Representative Evangelos. Representative Evangelos is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 8 members voting in the affirmative, 0 in the negative, and 6 members are absent.
You're muted, Ann.
I know. Thank you. Thank you very much, Ms. Panett. So the carryover motion on the 19 bills passes 8-0 with 6 absences. Our colleagues will have an opportunity to vote by noon on Monday. And I want to just express incredible gratitude to everyone for working so hard today, especially Peggy and Soupy and Sam for sticking with us. We waded through a lot of complicated stuff and jumped all around our agenda. And thank you, committee members, for hanging in there until nearly 5 o'clock on Friday. Peggy and Soupy and Sam, do you have any last words of wisdom or information for us?
I was just wondering about sorry to slow you down, the criminal records bills.
Oh, thank you.
Are you going to save those, or? Okay.
I think we should address those right now as well.
Okay.
And so committee members, this is related to the carryover on 1310. We have a number of criminal records bills that will be kind of swept up in the study, the review committee, which is LD 563. And so to consolidate and be efficient, we are planning to vote ought not to pass on the records bills that will be subsumed within the study committee. And we will also send copies of those bills to that committee for consideration in their work with a letter. And so with that, I would entertain an ought not to pass motion on the following bills. Representative Harnett?
I was just jumping the gun. I'll wait till you list them and make the motion.
Okay. On 216, 1055, 1210, 1459, 1465, and 1602. And Soupy, let me know if you want me to reread those.
I have 6. I'm not, you did it as a group for the carryovers. Peggy may know better. What do you think? Separate?
I don't know that it matters. If you had the same person doing the ought not to pass motion, the same person seconding, however you want to handle it. I mean, I know it means a separate sheet for you, but.
No, obviously I'll have to do a separate sheet, but I don't want to delay the committee any longer, but okay.
Soupy, I will just say, if you're more comfortable doing them separately, it's only 6, we can do them quickly.
No, it's fine. You know, it's funny. People think in the 32 years you've been here that there isn't something new that will come up, but this is actually the first time that this has ever come up. So we can set some precedent.
Let me just check in with Representative Harnett. Co-chair, do you feel that it would be advisable to do them separately?
I think if I'll list the LD numbers in the motion, so it's quite clear what the motion is rather than the aforementioned. So okay. I think I'm prepared to move forward.
Go ahead, co-chair.
Thank you. I move ought not to pass on the following bills: LD 216, LD 1055, LD 1210, LD 1459, LD 1465, and LD 1602. And I further move that we will inform the committee looking into criminal records review under LD 1310 to consider these bills in their deliberations.
Thank you, co-chair. And I would just mention that the bill that creates the review committee is actually 563.
Oh, I'm sorry, I had a different number here. That's okay.
Right, and we're carrying over 1310 in case we need a vehicle for it next year.
Exactly, yeah.
So you're right about that.
Thank you.
Is there a second? Seconded by Representative McCreight. And I think we are ready for the vote.
Thank you very much, Madam Chair. Senator Carney.
Before we go,
Whoop, sorry.
thank you. It's been up a little bit, but I just want to clarify, what was 563, Senator?
So yes, thank you for the clarifying question. So 563 is the bill that creates the Criminal Records Review Committee. And then the bill that we just voted to carry over, LD 1310, is a concept draft, a criminal records concept draft that we could use as a vehicle in the second session, which is why we carried it over. But these bills that we're voting ought not to pass on are subsumed within the Criminal Records Review Committee, which is
Thank you. I appreciate that, Cliff. Thank you very much.
Yeah, okay. Everybody all set? I think we are.
Very much. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCreight.
Yes.
Representative McCreight votes yes. Representative Cardone.
Yes.
Representative Cardone votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier. Representative Evangelos. Representative Newell. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Representative Evangelos. Representative Evangelos is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 8 members voting in the affirmative, 0 in the negative, and 6 members are absent.
Thank you very much. And so the ought not to pass motion on LDs 216, LD 1055, LD 1210, LD 1459, LD 1465, and LD 1602 passes 8-0 with 6 absences. So we will close our work session on those bills. And I'm sure there are other things that we need to take care of. And Soupy and Peggy and Sam, what are we missing here?
Well, I just want to say, I think you voted on every single bill except the errors bill. So congratulations. That is quite a feat.
Whew. Yay. Let's give ourselves a pat on the back.
Yeah.
Including Sam, Soupy, and Peggy.
Thank
Will
you.
there be an opportunity another day next week to go through these amendments? Okay.
Yes.
So,
absolutely.
right, that's what we need to do is we need to have language review. And Sam and I were just trying to figure this out, and that maybe the best way to do this is to keep sending them to you and then ask permission to meet on Tuesday. I think the Utilities Committee, Energy Committee is meeting on Monday. So if we ask to meet on Tuesday, that'll give you places to spread out and meet remotely if you have any breaks. And we can take up any questions you have with language review and go through the errors bill and vote on that. And Sam, I just drove Sam away. So if you have, does that work? Can we do language review, send it out by email, and then bring it up when we're together? Is that, if you have questions?
I think that's a great process that we would look at it and then just try to hone in on any issues ahead of time.
May I ask, time of
Just a
day on
moment,
Tuesday? Oh, I'm sorry.
Just a moment. I wanted to call on Co-Chair Harnett. Go ahead.
Thank you, Madam Chair. Again, I think Peggy might have answered my questions. I understood some committees were doing language review fully by email. This is a little different than that, correct? We will eventually, we'll get them by email, or we have them by email. And then we will physically get together or virtually get together at some point.
Virtually, I think all committee meetings are still virtual. And so we would have a remote meeting, which is why I'm trying to identify a different day than what the Energy Committee is meeting, because if they're meeting, they're going to need whatever space there is to spread out and be remote. And we also don't have permission yet to do that, but you do have to vote on the errors bill. So you do have to do that. And, you know, we have to spend some time going over it, even if it's clean. So I would like to think that we'll send them all out by email, and we will only need to talk about the ones you have questions about. Sam and I are, of course, happy to answer any questions. But as a group, you shouldn't have a discussion by email.
Right.
Because
Okay.
that's not open to the public.
Do we have them all now, or are you going to?
You
put
do
them
not. You do not.
Okay.
I am sorry.
Oh, no, that's fine. I'm just looking at a stack of minority reports and okay.
We finally drove Peggy from the scene.
You have at least 2 piles of this.
Okay. So does Tuesday give you enough time, Peggy?
May I ask a question about that?
Go ahead.
I was just wondering about time of day, and our numbers seem to be dwindling here. And I neglected to absentee vote, and I need to leave at 6 o'clock on Tuesday in order to vote in my hometown. So I don't know what that does to schedule here. I mean, only if you. I'm just trying to contribute.
Right. I haven't sent the memo to the I mean, your chairs haven't sent the memo yet to the presiding officer. So if you want to select a different day, I mean, maybe Wednesday or Thursday is even better. They are not setting aside time for committees to meet. They are not expecting committees to have anything left to do. So this will be catch as catch can, really.
I
There
just want
is a
to call on
day.
I want to call on Representative McCreight for a second. Go ahead, Representative.
I just wanted to point out that Friday, and I don't know if that's too late, we're not scheduled to have session in the afternoon because some committees have confirmation hearings, such as VLA on the Friday. So that, I just suggest that as an option if people would prefer.
How does that sit with everybody? Go ahead. Thank you, Representative McCreight. Go ahead, Representative Moriarty.
Apart from Friday afternoon, are we considering a committee meeting at the same time session is taking place?
I think it would have to be quite early in the morning.
Or during breaks. There are some times when the House and the Senate, while you're waiting for papers.
Oh, yeah, but that's.
You wouldn't be able to plan it in advance.
And we are starting chairs and caucuses much earlier in the morning now. We're starting at like 8 o'clock.
Representative McCreight, what time are the confirmation hearings that other committees are doing?
VLA has some at 1 o'clock. So I assume 1 o'clock is the time that's been designated. And the speaker did mention this a while ago, that they would not schedule session on Friday. Obviously things can change, but VLA is definitely scheduled for 1 o'clock on the 11th.
Okay.
And they're not the only committee.
Peggy.
Not scheduled Friday afternoon.
I'm sorry, go ahead, Tom.
Not scheduled Friday afternoon, correct? I think we're still going to do a half-day Friday.
Half-day session.
Right. Okay, that's what I meant. Thank you.
So Peggy, Soupy, and Sam, does 1 o'clock on Friday work, or is that?
Well, that assumes that everything's all done, right? And you're not making any changes to anything.
Okay.
That's just a little worrisome.
Mhm. Okay.
It's just a matter of getting bills reported out in time to get them to the floor.
Right.
Especially divided reports.
Wait,
Can we do divided reports? Catch as catch can?
Well, I guess I'd like to have you vote on the errors bill before that. And any of the bills that, you know, there were some times when you voted and you said, oh, we'll finalize that in language review. And I think there are a few of those, not a whole lot, but I really would not want to be waiting till Friday to do that if at all possible. I'm sorry that we have pushed you to this limit.
No, it's not you, it's the volume of work. So I would like to suggest, committee members, that we try to meet at 8 o'clock on Wednesday morning. And Tom, I know that you may have a caucus, but I think that would everybody else be available at 8 o'clock on Wednesday? No, Jay wouldn't either.
And I believe the Democratic House caucus is beginning at 8:30 every day next week.
Okay.
And at this point, Ann, I guess I have no idea what the Republican caucus, House caucus is doing. You don't have any Republicans here.
Right. Okay, so I think what we're going to do is we need to, Tom and I need to talk to the Republican leads and get some times that might work and see what our comfort level is with hoping that the breaks that the House and Senate take synchronize as well.
Are you able to meet? I don't know if there are restraints on Soupy or on Peggy. Are we able to meet at like 6 or 7 p.m.?
I think you have met at 6 or 7 p.m. Yes, that's okay.
I mean, I would think that most of us, maybe not everyone, but most of us are gonna be there overnight if we're coming from any distance. And maybe an evening meeting can be scheduled easier than something in the morning or catch as catch can.
Okay, let me
Can I ask a
into
question?
this. Okay, go ahead, Steve.
Can we meet in the committee room? Otherwise, if we meet remotely, for those of us who are in session in the morning, we've got to drive home, consuming an hour or more, and then go through the Zoom thing.
No, I think we would just have our laptops or whatever we're using to connect with us and find a place where we could
sit down in the State House somewhere.
Yep.
Yeah.
I'm driving to Tom's house.
I mean, we could meet in the committee room if we all had headphones.
Well, I think there's a capacity limit. But
Oh, well, no, I don't think so, because we're sitting in the House chamber.
Oh.
Okay, well,
Yeah, I
I
mean-
don't think we're going to be able to resolve this now, except that
There's
we've got
one
all
other
the ideas on the
possibility.
table. Peggy, go ahead. You have the floor.
Oh, I was just going to say, if all the other committees are done, then you might have, and if committee clerks are done, you might have other committee rooms where you could be remote if you have your own devices with you.
I mean, up here on the 4th floor, you have the lounge. The chairs, you have your office. There's the legislative lounge. There's the one on the 3rd floor. You know, I'm not aware of, I mean, there was a limit to the committee room here. You're gonna have to give me a chance to clear off the table, but that's.
But the meetings are
throw things on
required.
the floor.
Right. I think the meetings are required to be remote. That's my understanding, is all meetings, committee meetings are remote for the rest of the session.
Right, but they don't say where people have to sit.
Right.
Right. No, the stumbling block, I think, is just a time when we can have House and Senate members available.
A 1 o'clock meeting would probably encompass a half an hour of lunch by the bodies. I'm not sure about that, but
Yeah, the Senate hasn't hasn't had that kind of midday break.
And
So
ours have
it's
moved
just-
around. They're not on a regular schedule at all. It's how the day goes.
All right, everybody, let Tom and I explore some options and talk to Senator Keim and Representative Hagan and try to hone in on a time that works. What I'm hearing from people is that early mornings are probably not recommended. A definite time is recommended, and that we could give some consideration to potentially an evening time. That
Yeah, I prefer Wednesday, but if you guys can work Tuesday and get it done earlier, that's, great.
And I will tell you that Monday night, the House Democrats are having an off-site caucus. So
Yeah.
Monday evening is not good.
okay. Thank you. Peggy?
Wednesday, I feel much better about Wednesday than I do about Friday,
Okay.
if you're thinking about timing. And the joint rules say you cannot take a vote after 10:30 p.m. unless authorized by the presiding officers. Just wanted you to know what the parameters are.
All right.
Yes.
All right. So Tom and I think we'll talk to our colleagues about after session on Wednesday and get back to everybody. All right. Thank you. Anything else?
Have a nice weekend.
Thank you
Thanks,
all.
everyone.
Thank
Right,
you,
thank
everyone.
you.
Great work
Hey.
today.
Thanks then. Well done.
Don't forget to come up and vote on or sign your jackets.
Good
Absolutely.
point.
You.